Good morning and welcome to LawNewz Network. I'm Aaron Hernandez and we're here today in the final end stage of the Aaron Hernandez trial. Yesterday, both sides rested their case. Today, we are to hear the beginning of closing arguments. It's an exciting day. I'm joined by criminal defense lawyer Caroline Polisi. Hi, Caroline.
Hi,
nice to see you. Yeah, thanks for
Thanks.
being here. So I'm going to get right into it. Let's just catch everybody up on what was happening yesterday. So yesterday we heard from a couple of defense witnesses. We heard from a digital analyst talking about cell phones and text messages. And we heard from Dr. Downs, who was the defense forensic pathologist expert. And he testified about a number of things, most importantly about how the victims may have been positioned.
Yeah.
And then we heard both sides rest. So I want to focus a little bit on Dr. Downs because we heard something through his testimony that was kind of a surprise, right?
Absolutely. Yes.
So we heard Dr. Downs all of a sudden, and when I say all of a sudden, I don't remember hearing much testimony about this throughout the course of this trial. We heard him talking about the position of one of the victims. And it sounded like, he was giving all of this testimony that was really headed toward the victim having had a gun pointed out of the car that was shot into.
Came out of nowhere.
Where did that come from?
Exactly. Now, we heard a little bit of an allusion to this in Baez's opening statement, but it was really unclear where they were going to go. And you also saw the defense team on cross of the prosecution's forensic pathologist, Dr. Linden, sort of go deeper into this idea of where the hand, the position of the body upon the gunshot entering the body. And we didn't really know where that was going or what was happening. Now, all of a sudden, we see, this is a real aha moment when the defense finally gets to put on their case. They put on their forensic pathologist, Dr. Downs, and he's going into great detail. He's making a case essentially for this sixth shot. You heard there was a lot of back and forth. I mean, it's kind of hard to pronounce the sixth shot, but everybody kept saying it back and forth, and the prosecution said, sir, how do you in fact know that this sixth shot happened? And Dr. Downs seemed pretty credible that, based off of the way the arm was, and there was a graze wound, that had to be essentially from a sixth shot.
Now, interesting to talk about the shots. Early on in our coverage of this trial, I spoke with a number of criminal defense lawyers. And in the early stages of the trial, we kind of agreed, like, who cares? 5 shots, 6 shots, does it really make a difference? I mean, is that really a point of, bolstering or destroying someone's credibility?
Right.
It's not like it was in a conversation, was it 1 shot or 6 shots?
Right.
5 shots or 6 shots at that time really didn't seem like that big of a deal. It almost seemed like a distinction without a difference.
Well, it is, right? Yeah.
But I think yesterday we really, started to see more like, oh, maybe it's a big deal that this 5 or 6 shot, because when you take it into context with the tattoo, with Dr. Downs' testimony, now 5 shots or 6 shots actually seems like it's a little bit meatier of a defense point.
Exactly, and the prosecution put this issue to the jury, really. They put this issue as a large issue in the case when it sought to introduce this evidence about the tattoo. Remember, there were 5 bullets on Aaron Hernandez's tattoo, and the defense vigorously sought to suppress that evidence because they said, it's irrelevant, it makes no difference. Now, when the prosecution said, no, we want to submit this evidence as evidence of guilt, that's when they put the issue of whether or not there were 5 or 6 into evidence, and it's a huge deal.
Now, so let me just ask you this, and then we'll watch a quick clip. It strikes me that yesterday, in particular, in this case, after a month of testimony, all of these many days and weeks at this trial, yesterday I really got the feeling that the defense was just coming up with things, maybe that they'd planned, but that new things, and that they really were kind of, calling audibles, right, like at the end of the trial. And if you put it in further context, not so much what the jury saw, but there was a motion early on for a serviceman to testify. He was subpoenaed, and he moved to quash the subpoena, and so his testimony was not compelled. Bill Belichick, who was widely anticipated to be a witness, he was on the witness list. He didn't testify either. So I wonder, is this whole new vein that things are going in, making a bigger deal out of the number of shots, talking about the potential that one of the victims may have had a gun, is this perhaps taken in total with changes in witnesses? Does that indicate that maybe, the defense is going off what their original plan had been?
No, I don't think so.
You think this was always their plan?
I think so. I mean, we discussed this a little bit earlier off camera. I think the prosecution really doesn't have a strong case here, and in fact, Baez could have simply rested when the prosecution rested. Of course, we know that the defense has no burden here. It's their choice whether or not to put on witnesses, and everybody, prior to the defense putting on their case was wondering who's going to be the witnesses, what are they going to do, because really, it's such a strong case. Baez really did a great job of drawing out that counter narrative on the crosses of the prosecution's witnesses. However, I do think he put on a good case here. I think that the witnesses added to his case. He had those, he did make a bold call there to do some character evidence, introduce some character evidence when he called, the manager of Tootsie's and said Aaron's a great guy and things like that. And we all thought maybe the prosecution is going to rebut at this point, but they didn't. They didn't. So I think he's in a good position. Baez obviously knows what he's doing. He's confident, right? He's a confident lawyer. He's a confident attorney. We see that in the courtroom, and this is another evidence of this confidence.
Sure.
He's throwing things out there left and right and seeing what's going to stick.
And I think, speaking of confidence, we're going to go now to a clip of Dr. Jamie Downs, and Jamie Downs. Also, I think he's a confident witness, which may be an interesting contrast to the prosecution's forensic pathologist, who maybe wasn't really as confident.
Yes.
Let's take a look. Let's watch this. This is the beginning of Jamie Downs' testimony, the forensic pathologist, where we're hearing really sort of for the first time, this whole business of one of the victims now potentially having a gun. This testimony was the result after there was significant debate in the courtroom outside the jury's presence as to whether or not the doctor could testify about some of this bodily movement of the victim. So let's take a look at this.
First of all, you mentioned in your report the term right brachium. What does the term brachium mean?
Again, as I mentioned earlier, brachium medically is the upper arm. What we would call the arm is the brachium and the forearm.
Well, the brachium is the arm from the shoulder to the elbow. Isn't that correct?
The upper arm, yes.
Okay. And then there's below the elbow, which for layman's purposes we'll call the forearm.
Yes, sir.
Now, you filed or you submitted a report of your conclusions, opinions, and observations in connection with this case on March 5th of this year, correct?
I believe so, yes, sir.
Okay. And in that report, which was roughly, 5 to 6 pages?
I couldn't tell you how long it was. That sounds about right.
Okay. Your opinion says nothing about the position of the forearm. That is the part of the arm below the elbow, correct?
I believe that's correct because,
right.
again, as I said earlier, I can't position the forearm.
Correct. And in fact, what you said was that the right brachium was raised to approximately shoulder level and extended outward. That was the conclusion that you drew in your first report there.
That's correct.
Okay. And may I have Mr. Favors, Your Honor, resume that position that he was in before with the demonstrative, as the demonstrative aid?
You may.
And, Your Honor, if I could have Dr. Downs come back down.
Doctor, if you would, please watch your step. And ask both to keep your voices raised, please, for our court report.
And if I could have Mr. Favors have a seat. Sure. And I'm asking you to do it because I don't want to get it wrong. Could you have Mr. Favors resume the position that is consistent with your opinion in this case?
Again, approximately hand open, and roughly something like that position. Leaning to his right. What I'm looking at is to this point. The rest of this is what we call anatomic position. That is, again, toes forward, palms forward.
And you can resume your seat. If you could just hold that position, that's your I noticed, Doctor, that when you put Mr. Favors in this position before lunch and today, you had his forearm extended.
Yes, sir. As I mentioned, anatomic position.
But you don't know what the forearm was doing.
No, sir. I think I made that clear several
Then
times.
why did you have it extended as a demonstrative aid to the jury when you had no idea what the forearm was doing on the early morning of July 16, 2012?
I think I've said it 3 or 4 times. It's anatomic position, sir.
Okay. And it's true, Doctor, that you, in every chart that you did for this case, even though you had no idea what the forearm was doing, you drew the passenger of the seat with the arm extended out the window. Isn't that correct?
Every time I followed anatomic position, yes, sir.
Okay.
Mr. Lee?
Oh, Mr. Favors.
Sir, we're going to mark you for identification. Thank you.
First of all, you mentioned in your report the term right brachium. What does the term brachium mean?
Again, as I mentioned earlier, brachium medically is the upper arm. What we would call the arm is the brachium and the forearm.
Well, the brachium is the arm from the shoulder to the elbow. Isn't that correct?
The upper arm, yes, sir.
Okay. And
So that was a little bit of the testimony of Dr. Downs, the defense forensic pathologist witness. That was yesterday, the last witness in the defense case in Aaron Hernandez. We are now waiting. The jury is coming into the courtroom. We are waiting for the beginning of closing arguments. I'm Allura Nanos, and I'm joined here at LawNewz Network by Caroline Polisi. Hi, Caroline.
Thanks for having me.
So we're waiting for the big moment. We're waiting for the closing arguments.
Exciting.
It
Yes.
is very exciting.
Yes.
This is like, what a finale.
It's finally
Yes.
happening. It's finally here. There's a lot of anticipation. You can only imagine the nerves in that courtroom today.
So now here's the thing, right? So you're a defense lawyer. And in this case, this is kind of a picnic for the defense lawyer in a way, right? Because there is just so much that the defense can pick from. We have, general kind of sloppiness with handling of evidence and crime scene investigation. We also have this defense witness, Dr. Downs, who testified fairly credibly about perhaps one of the victims having a gun. Then we have the star prosecution witness, Alexander Bradley, who clearly had all kinds of issues on the stand, and
That's putting it lightly. I
Yeah,
think.
there was a lot to deal with there. We also, we have the character in the street sweeper who he's a memorable witness, and he's like kind of the personification of the general sloppiness of the prosecution's case.
Absolutely. I love him, McMaster. He's the greatest.
And the thing
He
is,
was the best.
because he's a real person, it's like a way of really, like I said, personifying the idea that maybe the prosecution or the police work was not so hot.
Yeah, the prosecution really tried to rip apart his credibility, but I thought that, you could visibly see just how nervous he was, and I think it came off as very credible. He was clearly angered by the way the police had treated him, and he felt indignant towards that, and it came across as very credible. I think he was a defense witness.
I think that it depends a lot on what a juror brings into that courtroom.
Absolutely.
Because I remember the police officers who testified early on in the case, and they weren't perfect witnesses, but they were sort of your standard police witnesses. There was nothing really memorable really about any of their testimony, and I think if you're a juror and you come into that courtroom with a predisposition to trust police, you may very well trust them and not trust the street sweeper.
Absolutely. I mean, so much of this case is going to come down to that human element, the idea of, because again, we don't have any forensic evidence in this case. This is a circumstantial evidence case, and it comes down to what the jury chooses to believe, whether or not the witnesses they think are credible. So today, of all days, is a day in which you can argue the law until the cows come home, but this is really going to come down to an assessment by that jury, their cognitive biases, what they felt along this whole journey that they've taken so far, who they really feel an inclination towards was telling the truth and was lying.
I think that is absolutely true, and you're an experienced criminal defense lawyer. In this case, what would you do in your closing arguments? Would you really hammer one particular defense, train of logic, or would you kind of offer the smorgasbord and say, well, you have this and you have that and you have all these things to choose from? What would you do?
What I would do, and what I think Baez will do, is the smorgasbord tactic, which is, look, you only need one little bit of reasonable doubt. But here we have a lot of little bits of reasonable doubt. You can string them all together and say, look, you could make a determination of acquittal in this case simply based on one of these elements. So, for example, simply based on the fact that the police and detective work in this case was far from adequate. I think Baez did a masterful job of crossing Detective McIsaac here, saying that, where are those missing tapes from the Pure nightclub? Why didn't you log that evidence, and why didn't you maintain a chain of custody for that evidence? Isn't that the ordinary course of business when you conduct a murder case, when you're investigating a murder case? And, we saw McIsaac kind of just flippantly laugh it off, saying, no, we don't usually do it that way. That's just one example of the ways in which the case, the state has not prosecuted their case by the book.
I agree. I think that there really is something there, and I think yesterday, outside the presence of the jury, we saw some motion argument about the Bowden instruction, which is the Bowden instruction is a jury instruction that the defense argued for and won, that the judge will instruct the jury that if it finds that the investigation was faulty, that it may consider that faultiness as proof that the prosecution is unable to meet its burden.
This is huge.
I mean, here's the thing. Did they need the instruction? Not really, because, the jury could easily infer that anyway, but the fact that the instruction was given is a big deal.
100%. That's the heart of the matter right now. The having a judge deliver those words, just having the judge sit on the stand. Look, the jury looks to the judge as sort of the arbiter of everything in this case. So to have a judge sit on the stand and say, essentially acknowledge that there were faults in the state's in the state's presentation of the evidence here, that's huge.
Right.
It's
as if that prior to the instruction, the jury might be saying, oh, that sounds a little strange. I could see how that might be some sloppiness. Maybe that police officer didn't do such a good job. But when the judge comes in and says, if you find that the police work was lousy, you can infer that it might mean the prosecution is lousy. It's as if the judge has articulated what may be going on in the jury's head anyway.
Absolutely. It's a huge win for Baez. Huge win.
And if you put that together with the fact that the defense has McMasters as the personification of that, sloppy investigation and police work, that is a big deal. So I know that the jury is about the jury is coming back into the courtroom in Hernandez. They're not quite ready yet. So while we're waiting, I'm going to just play a quick clip of that street sweeper's testimony, just to remind everybody what it is that we're talking about. And during that time, if the closing arguments begin, we will come right back to that.
Thank you. Good morning, sir. Can you introduce yourself to the ladies and gentlemen of the jury?
Warren McMaster.
And can you spell your last name?
McMaster.
And on July 16, 2012, what were you employed as?
An operator for American Sweepman.
Okay. And did you operate a street sweeper?
Yes.
Okay. And, sir, can you tell us what you saw that evening as you drove through the area? Actually, if I can get the pointer.
Pointer?
Can you show the ladies and gentlemen of the jury, there's a stick there, where you traveled as you came up to the corner of Harold and Shannon that evening?
Came from the gutter side right here, across down to Charlotte. Right side gutter going.
I'm sorry, I didn't get the end of that.
The right, I went from marginal to Charlotte, right side gutter outbound. Sweden.
And did you drive by a BMW at that time?
Yes.
Okay, and what did you see as you were driving up to it?
It looked like a SUV and a BMW side by side. Yeah.
And what could you observe as it relates to any of the passengers in the SUV?
Looked like someone out of the sunroof with a device in the hand.
Okay. The person that was out of the sunroof, did it look like a man or a woman to you?
It looked like a female.
Okay, and what did you think they were doing?
It might have been calling for help or recording or whatever. It looked like they had something in the hand.
Okay. Was that, when you say, did it appear that they were videotaping it?
Possibly.
Okay, is that why you say a recording device?
It could have been a cell phone. They could have been calling for help.
Okay, but you didn't know exactly?
Yes.
Okay, and then what happened after that? Where did the SUV go?
We just went down towards Harold Street, took a left to Harold Street and just left.
Disappeared?
Yeah.
Okay, and then what did you do after that? Now, at some point, did the police ask you to come back?
My supervisor did.
Okay, and what did you do?
And he came back to Marginal and parked.
Okay. And when you came back to Marginal, what happened?
Greeted by a bunch of police officers and my supervisor and just a bunch of chaos.
Okay. When you arrived back on the scene, how did the police respond to you once you got there?
Kind of,
When you arrived back on the scene, how did the police respond to you once you got there?
kind of disrespectfully. And
Disrespectfully?
rude, yes.
Okay. And how did they behave towards you? What did they do and say?
They just told me to shut my mouth and remain quiet and I'd be under arrest if I said anything. And just pretty much sit there until further notice. And a bunch of them kept coming up and saying the same thing.
Okay. So, were the police happy to see you come back? Objection.
Sustained.
Did the police indicate in one way or another either their pleasure or displeasure of seeing you back at the scene that evening?
It didn't feel like it was a pleasurable thing. You know? It didn't feel like a good situation to be in.
Did they curse at you?
Yes.
Okay. And did they order you to either sit down or
They told me
out here?
yeah, they told me to sit down on the side of the road, remain quiet, shut my effing mouth, or be under arrest. Just pretty much told me to shut up. No, sir.
Okay. And after all of this occurred, did they ask you to empty anything out or your hopper or anything?
They told me to go to Marginal. I'd go to Frontage Road and empty my hopper out.
Okay. And explain to us how that works.
I transported my machine towards Frontage Road, pulled up. There was a couple officers there, one in unmarked uniform. I think there was three. And I just dumped my hopper out, which is like a disposal for the machine. And I dumped it out, spread it out a little bit evenly, and we raked it all out and searched through the. And I just dumped my hopper out, which is like a disposal for the machine. And I dumped it out, spread it out a little bit evenly, and we raked it all out and searched through the material, whatever was in there.
So they use rakes?
Yes.
Okay. Did you use anything, I guess, anything more than just a rake?
Shovels, there was a hose.
To uniformed officers, plainclothes, or both?
There was multiple. There was uniformed and ununiformed officers.
Did you to uniformed officers, plainclothes, or both?
There was multiple. There was uniformed and ununiformed officers.
Did you tell them what you saw about the woman in the sunroof?
Yes.
Okay. And did you tell them that you drove through the scene?
Yes. They're just being kind of like, you know, being rude to me, honestly. They're just being real rude to me and just telling me to shut my mouth and not to say nothing and just remain quiet and don't talk to no one. There was a news cruiser there. They were trying to like get questions out of me and said, shut me off your mouth or you'll be under arrest.
Did they tell you if you opened your mouth?
They're just being kind of like, you know, being rude to me, honestly. They're just being real rude to me and just telling me to shut my mouth and not to say 30 minutes, 40 minutes.
Okay. And then they asked, and that's when they asked you to empty out your hopper?
Yes.
Okay. And then after that, how long were you there with them?
About 20 minutes, 30 minutes.
And after that is when they let you go?
Yes.
Okay. Subsequent to that, how long before the police came to talk to you again?
Just recently, last month.
Okay, last month. And tell us about that experience.
Just they called me, they kept trying to get a hold of me. You know, didn't have like enough time to meet up with them, and then when I finally did.
That was the street sweeper in the Aaron Hernandez case, witness used by both the prosecution and defense. We are in our last minutes getting ready for the finale of this month-long case. We're about to go to the courtroom, and the attorneys have done their last few sidebars to get the last-minute details about jury instructions and closing arguments out of the way. We will now bring you to the courtroom where those closing arguments are about to begin.
Contact with the case outside of court. If you have, would you raise your hand? Seeing no hands raised, I find this jury remains indifferent. And that is the last time that I'm going to make that finding, because I expect today that we will hear the closing arguments of the attorneys. Then I will instruct you in the law. And then 12 of you will commence deliberations on the evidence in this case. At that point, you'll no longer be indifferent. By that I mean you'll begin to form judgments about what facts have been demonstrated by the evidence, and applying the law to those facts, determining through that process whether the Commonwealth has met its burden of proof as it relates to the various charges and the elements of each charge in this case. So understand, you will begin to form judgments as a group on the evidence today, and at that point you are not indifferent. You must remain indifferent, however, as to all extraneous matters, all outside information, because, as I will instruct you, and as I've told you before, you can decide this case only and solely based on the evidence you've heard in this courtroom during the course of this trial, and on the inferences that you draw from that evidence, but not referencing anything else, anything outside of the evidence. Now recall what I told you at the outset of this trial. It seems so long ago, but when we first assembled as a group here to commence the case, I instructed you on what constitutes evidence and what is not evidence. And in just a moment we turn to counsel for their closing arguments. A closing argument is the reverse side of the opening statements that you heard. Remember, I told you an opening statement was a preview of what the attorneys expected the evidence might show or might not show. A closing argument now is the attorney's opportunity to review the evidence with you and to argue to you, that is, attempt to persuade you as to what conclusions you should or should not draw from the evidence as you've heard it. In a closing argument, counsel may argue the evidence that has been presented. They may reference the evidence, that is, the testimony of the witnesses, any exhibits that you've seen, and suggest to you what that might show. To the extent any attorney in their closing argument states the evidence different from the way you recall it, understand your memory controls. That is, you determine what the evidence has been and what it shows, and no one else. And that applies to anything counsel may say about witnesses or testimony or exhibits, and indeed anything I may say, because you and you alone are the finders of fact. And counsel may argue inferences from the evidence, that is, conclusions that flow reasonably from the evidence as you've heard it. But counsel may not engage, nor may you in your deliberations engage in speculation or conjecture. Any inference must be based on the evidence as it's been presented and must be reasonable in the context of that evidence. And as well, attorneys are advocates, and attorneys are not permitted as advocates to express any personal opinion about the evidence in this case. Rather, they may state it, they may suggest why it may be believable or why it may be flawed, but they cannot express their own personal views nor argue anything that was not presented during this trial. The way I intend to proceed is as follows. In a criminal case, the first closing argument is given by the defense. And so in just a moment, we're going to turn to Mr. Baez for the closing argument on behalf of the defense. At the end of that, likely we'll take our morning recess and then hear a closing argument from, I think, Mr. Hagan on behalf of the Commonwealth. After those two closing arguments, likely we'll take our lunch recess, and then I will give you formal instructions of law after lunch, and then, time permitting, 12 of you will commence deliberations. So that's the sequence of events for today. And with all of that said by way of preamble, let us turn now to the defense for the closing argument on behalf of Mr. Hernandez. Mr. Baez. Yes, sir.
Good morning, ladies and gentlemen. Good morning. I have the unique honor of going first, but it's not by choice or a coin flip. The reason I'm going first is because the state is the party with the burden here. And you can recall we've discussed that ad nauseum, and I'm going to keep going at it and keep mentioning it because I think it bears and it's worth mentioning. But I promise to try my best to not be repetitive. The other task that I'm faced with, and that is to be able to cover what we've gone over the last several weeks, and to make sure I remember every single thing that relates to reasonable doubt. Now, what's important to note is while we try our best to be good lawyers, both sides, the case doesn't always come out exactly the way we anticipated it, because it's not a scripted event. But of course, before I begin, I want to say on behalf of both sides, we thank you for the attention that you've shown every witness in this case and the commitment you've made to justice. It's no small thing to leave your lives behind and to sit here in judgment of facts. And we all, both sides, I think, have discussed and commented how proud we are to be a part of this process. So having said that, I'd like to begin with what I told you at the very beginning of this case. And that is that there is absolutely no evidence that Aaron Hernandez committed this crime. What was scary, if you recall when I mentioned in the very beginning, how easy it appears to be able to be charged with such serious crimes. As Clerk Sheehan read the charges the first day during jury selection, and we sat there and you all sat there and heard these awesome charges. How it would actually unfold in the courtroom would be a completely different way, a completely different manner. I want to start and dive right into what the facts are, okay? And I begin with where it all began, at the Cure Lounge. You will recall specifically that the evidence showed, and before I go any further, I want to tell you, please rely on your own memories. I'm going to show you exhibits, show you different snippets of the evidence, and recall certain things. But all my demonstrative aids are just that. They're demonstrative aids. They're for you to rely on your memory, not on anything I say or anything that Mr. Hagan says. So please, I don't want you to get the impression that I'm saying this is exactly what happened. It is what we believe the roadmap that we've put together for you has compiled, okay? It all begins with the entry of Cure Lounge at 12:30 and 43 seconds. You may recall Aaron going down the stairs and coming up exactly 9 minutes later at 12:39:44. What transpired down in the Cure Lounge is the foundation of this case. It must be true. And you recall the whole issue of motive? You recall how it is not a required element of proof, but it is the foundation of a case. It is the why. Aristotle once said, everything that is done with an eye towards something else. Simply put, to understand the deed, look to the motive. Look to the why. And the why is really one of the most important things of this case. It's why we're all here. Why are we all here? Well, the Commonwealth of Massachusetts told you we're all here because of a spilled drink. And I think that there has been evidence after evidence after evidence submitted to you that shows you that that's not why we're all here. It shows you and proves to you that Alexander Bradley lied. He's many things, a perjurer and a liar. And I think that was proven here. Now you have to understand something. When it comes to cases and how they're laid out, we can only work with what we have. We can only work with what was done. And the fact that there are zero cameras, zero video of the actual inside of Cure nightclub should tell you something and should scream volumes at you. You recall Mr. Zaid Nabusi, and when he testified to certain things about having 16 cameras per DVR, but yet only 8 of them appeared. You may recall that the head of Cure Lounge is former Detective Miller Thomas, the president of the Boston Police Department's Detective Unit. They work hand in hand with the police, hand in hand. And if you recall one thing, every piece of evidence, every single piece of evidence confiscated in this case is done so in a selective way. There are procedures involved. All you have to do is look at the envelope, and every time an envelope was opened, it's signed, it's sealed with evidence tape, it's packaged, it's logged in. But yet all of these tapes are not logged in. There is zero chain of custody for the most critical and important piece of evidence in this case. You cannot let that lie. You cannot accept that. If this is the procedure, if this is the way it is done to preserve the integrity of the evidence, so when it comes to you, when it comes before you, you have to say to yourself, I will not accept that. And you should not accept that when there's something so mysteriously wrong here. Now, This case and the prosecution, the way it was presented to you, was really all about what they knew and didn't tell you. They knew about Jamie Furtado's photograph, but they didn't tell you about that. You will recall Antoine Salvador, the psychology doctoral student, who came before you. And here's the thing again. When this trial started, we hadn't found him. As you heard in the evidence, we found him in the middle of trial. The police had 5 years. 5 years to track this man down. And they came here and told you, after all this time, after all the investigation of flying all over the country to try and prosecute Aaron Hernandez, that they didn't speak to anyone who was in the club that night. Wouldn't you want to know what happened inside? What precipitated all of this? You start from point A to go to Z, and then therein you'll find the truth. Well, the truth was with this man, and he wasn't that hard to find. There was a photograph of him that they kept from you. They knew about this. Jamie Furtado, if you will recall, this man worked at Cure Lounge. He took that photo. He told the police about it. He took this photo. And they could care less about it. And you know why? Because it doesn't fit in with what Alexander Bradley says. Alexander Bradley was their three-legged pony, and they were going to ride him to the finish line. No matter what he said, no matter what lies he told, they were going to back him. And that's what unfolded every single day before you. The support, the rallying around Alexander Bradley and his lies. And it all began with point one. It all began here, downstairs in that basement, where this photo was taken, where this man told you, look, he was with me 5 to 6, 7 to 9 minutes, 7 to 10 minutes. He didn't have a dog in this fight. He's considered an independent witness. Mr. Bradley does have a dog in this fight. It's the deal of a lifetime. He's either there or sitting right there. And that's a big incentive. This man has no incentive to come to lie to you. And the Commonwealth is going to ask you, who are you going to believe? The drug dealer or the doctoral student? And that's what it boils down to. Ignore the obvious. Just believe our story. Just believe Alexander Bradley. And that you can't do. We're all sitting here, you've all come here to sit and objectively listen to the evidence. And there's been a lot of noise, we all know that. But this is actual evidence. This is proof to you from the very beginning, from the get-go, that he was lying. He said, Alexander Bradley said to you, well, first things first, we came in the bar, and Aaron went a few feet away from me. I could see him the entire time. He was close enough to where I could see him. And then his story just started falling apart from there. Paige Aiello, you remember her, the club goer, the frequent customer at Cure. She told you as soon as she got to the bar, which was right around 12:30, that Danny Abreu immediately came up to her. That's immediate. This is immediate. Antoine Salvador said he saw Aaron Hernandez walk down the stairs. And again, if you simply do the math, when we were haggling over all of this nonsense with the 9 minutes, in the 9 minutes, you got what, 30 seconds to go down the stairs. If I want to take Mr. Lee's stopwatch, I'll take those 30 seconds to go down the stairs. Another 30 to go to the bar. Wait there. You have then Anton Salvador come up to you and say, hey, you mind if I take a picture with you? And he politely declined. Not the angry, standoffish guy that Alexander Bradley told you about, that they tried to paint Aaron as. No, he was good with fans. And he said, no. And then he said, can you please, it's my birthday. Sure, no problem. Then they went to Jamie Furtado, and they asked him, and Anton asked him, can we go in the back room and take a picture? No, you can't come back here. That's a private, closed-off area. And then Aaron came forward and said, can you please, it's his birthday. And he said he didn't want to be recognized, so he said, I played college basketball. They go back there. Jamie takes the picture. They come back. Anton then joins his friends and is all excited about his new picture with Aaron Hernandez. Then he goes back to him and offers him a drink. All of this, 5 to 6, 7 minutes. Clearly nothing's happening. Paige Aiello has already met up with Danny De Abreu. She didn't see any bumping or any incident at all. She knows who Aaron Hernandez is. She clearly would have recognized him. And none of that happened. And then you get up here, exactly to where we're at, and you see Aaron walking out calmly, looking at his phone, by himself. Not as Alexander Bradley told you. Not when he told you, I had to grab him and take him out of the bar, because he was going to kill him. That's absurd. It flies in the face of reality. It's an absolute lie. And you have proof. You have absolute proof that Bradley's lying. This doesn't come around every day. It's not that easy to prove a negative. And that's why the burden is always with the state. It's always with them, because it's impossible to prove a negative. But every now and then, a little luck will fall on your lap. You might get lucky where the police didn't go looking. They didn't go looking for this picture because they knew that they didn't want to go looking. How upfront and honest is that with you? That's not the type of professional police work that we expect. Not anywhere. And they didn't go looking for behind doors that they didn't want to go looking for, because they knew of what they would find. This is why I submit to you that the police actually knew what was going on down there and what actually happened, and knows their famous saying, it's not the truth, but it's not a lie. The rallying around Alexander Bradley and his statements. You remember Detective McIsaac? It's not true, but it's not a lie. It's truthful, but inaccurate. What? How absurd. How stupid does he think we are? It's truthful, but inaccurate. That's what Alexander Bradley is. Truthful, but inaccurate. Because he's their pony. He's their case. He's everything and all they have, all they ever have, and all they ever will have. Because it's not true, but it's certainly not a lie. This is what they want you to believe. This is their case. This sums up the entire investigation as it relates to Alexander Bradley. And you see Aaron walking up by himself. You recall when we played the video, the first guy to walk behind Aaron is a completely different guy, because Bradley's downstairs doing his business. Now here's the thing. Clearly Aaron was out doing other things. Clearly you have evidence of that. While we have suspicions, and how we showed you how it appeared Danny De Abreu recognized Alexander Bradley, that's not our burden to prove. All we can do is point certain things out to you. We know this. We know that Alexander Bradley's a drug dealer. We know nobody crosses Sherrod. And we know what kind of weapons he carries. And we know what kind of life he lives. You live by the sword, you die by the sword. That's Alexander Bradley. What he's doing in that club, the things he's up to, what happens when he gets upset, that's Alexander Bradley. So when you have Aaron coming up, still with the 2 drinks in his hand, he didn't even have the time to finish his drinks. And remember Bradley said, well, they could have been 2 other drinks. Well, wait a minute. You testified to seeing him and him being close to you and going to the bar only once. You recall that he said he might have gotten 2 more drinks in addition to the 2 first drinks that he ordered. And he gives you this whole story about Aaron buying 2 drinks. No, that's Aaron's drink and Bradley's drink. That's that simple. And what happens when Aaron comes out of the club? There's no spilled drink on him. There's nothing, 0, to indicate that anything has been spilled on Aaron. The Commonwealth wants to say to you, who are you going to believe? Us or your lying eyes? There's absolutely no proof that anyone ever spilled a drink on Aaron. To the contrary, there's proof of other things happening downstairs. Other things that clearly explain and fall perfectly within the timeline. And then some. You go downstairs, walk all the way to the other end of the bar, come back, order 2 drinks, take a picture with a fan, come back, have more interaction with him. All of this makes perfect sense. It's reasonable. It's a reasonable doubt, ladies and gentlemen. From the very beginning of this case, from its inception, its actual core motive is all crowded with reasonable doubt. It's not sprinkled throughout this case. Reasonable doubt lives here. It lives here throughout this entire case, and it starts with the very beginning. Now, what happens after we go to, what does Bradley say happens after they leave the bar? Well, you saw the exchange, the video. You can speculate what they're saying. But one thing's clear. You see Aaron trying to cross the street and go to the other bar, and Bradley staying there. But I'm not going to even ask you to speculate on what was said or what wasn't there. They will, because that's the best they can do. They can't prove their case beyond and to the exclusion of every reasonable doubt. So they're going to ask you to look at that video and speculate as to what's being said. Who's the angry one here? They're going to ask you to look at things. Only the video that's convenient for them. Not the missing video. Only what's convenient for them. Look at this and speculate as best you can. That's what they're going to ask you to do. I only know this, and this is not speculation. And that is that they go across the street. And Bradley tells you that once they cross the street, that Danny De Abreu walks across the street and goes to the other bar, along with Rashidi Sanchez. Now here's what's interesting. The 2 descriptions that Alexander Bradley gives are of these 2 individuals. Okay? One, we see there's something going on when Bradley walks by initially outside of Cure. And the other one runs from the scene and destroys his clothes, destroys evidence. These 2 individuals are who Bradley swears and tells you, tells the police that they went across to the other bar, and this enraged Aaron. This enraged him to the point where he had his angry face, his angry, I want to kill you look. You remember we went over this? After the fist pump, we went over this with Bradley, that this is Aaron's angry face, and Bradley's like, yeah, he was mad. But you see Aaron laughing and carrying on. They're having a good time. He's trying to go on. And this is a lie. But for the Commonwealth, it's truthful but inaccurate. It's not true, but it's not a lie. This is what the lead detective is telling him. That the second Bradley told him that these two individuals went across the street to the other bar, that he knew it was a lie. They didn't press him on it. They didn't say to him, wait a minute. Under this agreement that you signed, you were to give complete and accurate information, not truthful but inaccurate information. Not true, but not a lie information. You're supposed to give complete and accurate information for you to get this deal. And you remember, we went through this whole agreement with the state throughout the cross-examination and throughout this case. But one thing came out for certain: they're gonna ride him all the way home. They don't care. They don't care that he comes here and lies. They don't care that he's lying to the police. They don't care from the very first step of the evening, that's a lie. The second step of the evening, that's a lie. They don't care. And that's outrageous. That's unacceptable. Any citizen accused in this country deserves better than that. That's not what we will stand for. That's not what you should stand for. Accepting lies. This tells you, he's not going to come up here. As great a lawyer, all the training I try to get in the world, as best as I could go at him, he's not going to come up here and say, "You got me. I shot him. I'm the one that shot two people." He's not going to do it. Even if I threatened him with violence, the only language he knows, he's not going to confess. There's not going to be a Perry Mason moment, as much as I want to. So you have to look within some of his statements, and then you have to know it's unacceptable for you to lie even once. It's unacceptable. It's like you go to a restaurant and you order a wonderful meal. If you find a bug in that meal, you're not going to take the bug out and eat the rest of the meal. You're going to send it back. And Judge Locke is going to tell you, when evaluating Mr. Bradley's testimony, you were to listen with caution and great care. Caution and great care. That's basically someone telling you, before you hear word one, stop and listen with great care and caution. This is unacceptable. This is reasonable doubt, because anything coming out of this man's mouth must be listened to with caution and great care. And it can't be not true, but not a lie, or any of this nonsense. This says it all. These first two steps say it all. And that's why you can't believe this. That's why this case has no foundation. It's like a house of cards where the slightest breeze will come by and knock it down. Those are the lies of Alexander Bradley. You recall, as it relates to Bradley, there are other things that cause doubt here. And it's funny when we listen to law enforcement's attitude. You may recall how in the beginning of the trial we had the police telling you certain things at the crime scene. And something important happened with one of the police officers that I wanted to point out to you. And that is, you may recall there was a police officer, Sergeant McCarthy, who testified about some photos that he never saw. He said, under cross-examination, "No, I didn't see any blood over there. I didn't go over there." And then when the Commonwealth got up there and started asking him about these photos, they asked him, "Is it a fair and accurate representation of the blood that was there that night?" He hadn't seen it. but he told you all, yes, it's a fair and accurate representation. Now I want to show you a small clip of his testimony. And remember, to rely on your own memory, this is not an official transcript, but let's play that for a moment here if we can. You just told the ladies and gentlemen of the jury that those photographs were a fair and accurate representation of what they depict.
They were.
Okay? But yet, you didn't know that they even existed.
I knew there was blood droplets. I don't know the exact direction of the blood droplets.
Do you recall testifying on the first cross-examination that you were unaware as to whether a trail of blood was around the corner?
Yes.
Okay. And you just testified before the ladies and gentlemen of the jury, telling them that those photographs of the blood around the corner were a fair and accurate representation of what they depict.
They are.
Okay. But yet you did not see it.
Correct.
I have no further questions. That's absurd. That's a police officer telling you, believe me blindly, I didn't see these photographs. I didn't see this blood, but it's fair and accurate representation of what was there that night. That's admitting evidence falsely. There is a culture within this police department that's saying it's okay to come here, to get on this stand, to swear to tell the truth, and lie. And it passes all the way down to this man. If a sergeant in charge of the crime scene is willing to come here and admit evidence to you that he has absolutely no knowledge about and lie to you like that, everybody's falling in ranks. And you can't accept that. That's not professional police work. That's unacceptable to any citizen accused, whether you're a football player, you work in a grocery store, or you're a banker or anything like that. It doesn't matter. That's unacceptable. And that's the culture throughout this case. That's the culture of deception that came before you throughout this entire case. And it's something that you don't know it until you actually see it. It's kind of like making sausage in our criminal justice system. Now you've had the opportunity to sit through a 6-week trial and sit there and say, you know, well, now that I've seen it made, I'm not so sure I want to eat it. That's exactly how our system is unfolding and how this case unfolded before your eyes. It's not with every case. Every case is different. But in this case, what you all saw was lies and a culture of deception, beginning from the scene that night, carrying throughout the deal with the devil. And that's unacceptable. Now let me take you to what happened next, according to Alexander Bradley and what happened that evening. You'll recall that 3 witnesses, we saw the fuzzy figures that went in the garage there at the Tufts garage. And you'll see it again, I have no doubt, during Mr. Hagan's closing argument. It appears the 2 figures go in the garage. But there's no video of what happened inside the garage. Why? Mr. Hagan will give you an excuse and say, well, they didn't go into camera range. But there's no video of that. That's the lack of evidence to support, again, what Mr. Bradley says. But you did have testimony by other individuals. You'll recall Andrew Wallace testifying that he saw Aaron over by the W. Mr. Scan and Baseliner himself, Ugo told you, and in fact, we have him at video crossing the street at 2:28 p.m. Exhibit 180 that you'll have access to when you go back, where he wrote AH on the screen and said to you, after this time, when I crossed the street at 2:28 a.m., I later on saw Aaron Hernandez. Even if you deduct the 3 minutes that the state says is the difference between the cameras, that's still a different time than when the 2 individuals are already in the Tufts garage. That's reasonable doubt, ladies and gentlemen. That's significant doubt when you throw Anton Salvador's testimony as well, who also saw him over there after the let out. You saw one let out through Cure, where all the patrons will come out and they start intermingling. They basically take the club outside and they try and see who's intoxicated and who wants to go home with one another. Well, across the street at the W, there's another club. Further on down the road, there's 2 more clubs. And that's what people are doing at that time. They're going through this area. And you remember Sean McCann, one of the very first witnesses who called 911. Do we have his photo? He testified to seeing Aaron right at the top. He testified to seeing Aaron speaking with 2 individuals later on that night. 2. That he was with 2 guys. He couldn't describe whether the person had cornrows or not, but he said something specific. And he said, yeah, I saw him with 2 people. There's a lot that you don't know because the state didn't go digging for it. We can only do so much coming into the case much later. The state had this case from its inception. They investigated a certain way, and they were not going anywhere that Bradley wasn't taking them. And that's a fact. These 3 witnesses all saw him over by the W right around that time that the missing video won't show you who actually went in that garage. Shadowy figures, looks like what they're wearing, maybe. They want you to squint like you're looking at a toast with Elvis on it. You know, don't believe the facts, the hard evidence facts. Squint a little, stretch, speculate, and then you'll see our case coming together. That's the Commonwealth's case in this case. That's what they presented to you. Instead of actual evidence, actual witnesses who were there, who have no dog in this fight. You know, you could argue maybe Hugo does have a dog in this fight. He works for Cure Lounge, who's run by the detectives. Now we get to the actual shooting and what people actually saw that night. I will tell you, one of the other interesting things that happened during this case is things developed as we were sitting in trial. While you were listening to some of this evidence of what doesn't tie Aaron to this case, you remember we went through a whole 2-3 weeks where there wasn't a single thing that related to Aaron Hernandez. While that was going on, we were uncovering and finding police officers. This man was the 2nd police officer on the scene, but they never called him to testify. Why? You heard so much testimony from irrelevant officers. People who didn't have anything to say. I didn't see the sheets. I didn't see who placed the sheets. I don't know who did this. I don't know who did that. But the one guy who saw something, saw a critical witness, Mr. McMaster, drive up on the scene first, before the police ever got there. That's a bombshell. And they hid him from you. They didn't want you to evaluate this evidence. It's not for your ears. You don't have any business knowing about what Mr. McMaster has to say. Why? Because he sees someone who looks like a female. We don't know whether it was a male or a female. None of the evidence came in. But we know it's somebody who either with cornrows, long hair, who looks like a female. Stand up. That's not this guy. That's not Aaron Hernandez. He doesn't have long cornrows. He doesn't look like a female in any stretch of the imagination. Even if you squint as hard as they want you to, you're not going to get cornrows from him. Brian Kwan took the stand. Now this is wrong, ladies and gentlemen. They called him to the stand. They got what they wanted. He described Alexander Bradley as the driver. A black male, light-skinned, or dark-skinned Hispanic, or a light-skinned black male. That's this guy. But they didn't ask him about the passenger. Why? Why is this information being withheld from you? Is that an honest and forthright prosecution? Is that the evidence that you came here, you left your lives for, to listen to? Half the story? That's absurd. And that's nothing you should stand for. When this man knows, this man was the closest to what happened, and he tells you, long, shoulder-length cornrow hair. You know what they want to do? Mr. Hagen's going to come up here and say to you that these beads are cornrows. I guarantee you that's what he's going to do. He's going to come up here and say they mistook these beads for cornrows, long shoulder cornrow, long shoulder length cornrows. Squint hard enough. Speculate as much as you can, please. And that's what you'll find. You heard, there were little parts. When I was listening to the evidence, there were insinuations, and I'll bet you he's going to come up here and say that to you, that those beads are cornrows. That's what they want to pull. That's what they want to say, despite knowing this man, what they knew and didn't tell you. They knew what he saw, but they didn't want you to know it. They didn't want you to tell it. They didn't want to tell you. Same thing with Mr. McMaster. Same thing with Officer O'Donnell. This police officer saw a street sweeper. And we got so many up here. I didn't see a street sweeper. I didn't see a street sweeper. How many cops came up here and told you? I didn't see a street sweeper. I heard there was a street sweeper. There's a rumor. But I didn't see a street sweeper. What did they think? We weren't going to pull them out? How absurd and outrageous is this prosecution? How unfair. This is not justice, ladies and gentlemen. This isn't justice. Not the justice that you will dispense. Mr. Aquilino Freire saw the same female. What's the one thing that these three people have in common? They all saw a female-looking passenger with cornrows. They have nothing in common. They come from different walks of life. They don't know each other. They've never been in the only time they've been in the same room at one point in time, but never together. You recall I asked him, have you ever seen this guy? No, never. You ever seen this guy? Never. Did you concoct a story with these two individuals? Eyewitness testimony is not the most reliable, that's for sure. But when you see independent people who don't have a dog in this fight telling you the same exact thing, you have to draw some conclusions. And the conclusion is, ladies and gentlemen, that Aaron Hernandez was not in that car during the shooting. He wasn't there. And it's not our job to tell you exactly where he was or to prove to you where he was. That's this man's job. And he failed miserably. Miserably. This is as conclusive as you can get, with three completely different independent witnesses telling you the same exact thing. And this man telling you he's the driver. All of this doesn't lie. And here's the thing. We get from step 1, step 2, step 3, step 4, step 5. All of them are lies. All of them are lies. From the man who's not going to break down and tell you, yeah, I'm lying. Now, we get to the actual shooter. And you heard some significant evidence, specifically from Dr. Downs yesterday. Dr. Downs told you the angle of the shots from the passenger side is completely impossible based on the way Alexander Bradley told you. We did a forensic reconstruction of the scene from the injuries and worked their way out. He showed you the actual injuries and where they came from and the angulation and all of the different things that forensic scientists use to be able to uncover what actually happened, to tell us the truth. Because the science doesn't lie. The science is the only thing that doesn't have to take the witness stand and choose a side. The science is the truth. And scientifically, based on the way Alexander Bradley said this occurred, is impossible. Remember the whole angulation of the shot coming upward, which is much easier to do from the driver's side. Now, there was an issue of the BMW. And you may recall that Dr. Mustafi testified about some medical records where Aquilino Freire specifically said that both of his friends were killed in a gunfight. Do we have a gun that was in the BMW? No. But again, that's not our job to prove. But there is specific doubt as to whether this actually occurred. Based on the actual injury of the wounds. Remember my Abercrombie Finch model over here, and how he put on this shirt and basically explained to you guys that Mr. Furtado's arm was placed in a certain direction. All this man would testify to is what the science is, nothing more. If he was a hired gun, he would have said, yes, his arm was pointed in this direction. I can say with a reasonable degree of medical certainty. But one thing he said it was consistent with being able, and the shirt matches up to the bullet holes. The science doesn't lie. What's beyond that, we don't know. And that's not what we try to do. We just try, it's our job to show you the entire picture. And we would be not doing our job if we didn't show you that this was a possible event. When someone's saying they're in a gunfight, someone in the BMW is saying that they were in a gunfight, Mr. Hagen's going to say, oh, his English wasn't that good. He testified the entire time before the grand jury without the use of an interpreter. He came up here and spoke English very well. And true, English is not his first language. But you also have this man leaving the scene, telling you he stood there at the crime scene and 2 police officers took his name. No, none that were called here to testify before you. But he's covered in blood. 2 police officers take his ID and his name. This man leaves too, Gerson Lopez. He flees as well. Both of these guys run. What did they take with them? Where did they go? Why are they destroying evidence? These are questions we have to ask. These are questions we must ask. And this is not a far-fetched conclusion. It's a possibility. It is doubt. And this is why we had to bring this evidence before you. Because they certainly weren't going to do it. They would never do such a thing. Why aren't they getting these individuals' phones? Mr. Sanchez told you he had 2 phones, but he just used them for selfies and whatever. But he didn't have a phone. That doesn't pass muster. That flies in the face of reality. It's not true. Then we get to the forensics. And I want to show you something that you probably don't remember we're going to have a hard time remembering. And that's, yeah, go ahead, so, I don't know. What many of these individuals testified to. But this was the state's forensic case and their forensic witnesses. Everyone here came and told you that there was nothing, zero, by way of forensic science that connects Aaron Hernandez to this crime. You recall, we sat through 2 weeks of witness after witness saying there's no direct link, there's no link, there's no fingerprints on this gun to Aaron Hernandez. There's no DNA. There's no DNA to Aaron Hernandez. I can't tie this gun to Aaron Hernandez. None of the print that I got off the SUV was not Aaron Hernandez. I couldn't match it to Aaron Hernandez. There's no GSR that we can link back to Aaron Hernandez. There's no trace evidence or CSI evidence that goes back to Aaron Hernandez. But you know what? You know what's funny about this? Well, it's not funny. You know what's strange about this? Is that the way the state tried their case was all on emotion. They're heavy on emotion and low on evidence. That's why the very beginning of this case was showing you gory pictures of the crime scene to get you riled up. And then in the middle of the case, you remember they paraded these shirts filled with blood to remind you and to get you riled up again, to play on your emotions when the judge specifically will tell you you are to be dispassionate. You're not to base your decision on emotion. You're to base it on the facts, on the evidence. But that's not the game they're playing. No. That's not the case they're trying. You'll remember this witness, Amy Reynolds, told you these shirts, those shirts have no probative value to this case. But they mounted them up for you. And they showed them for you. They put them in plastic bags and put them on boards and everything and brought them before you just to show them to you. Not because they mean anything, not because it contributes anything, not because it's going to help you evaluate and do your job as jurors, but only for the one reason, to get you riled up, to get you to hate him, to get you to squint hard enough so you can see cornrows instead of beads. And what did they end their case with? Dr. Lindstrom, the autopsy. Beginning, middle, end. That's the strategy. Let's get them riled up. Let's tell them a story. And let's let them buy into it. We don't need evidence. All digital forensics, nothing tying to him. Fingerprints, the state fingerprint expert, nothing, no fingerprints on the gun. More computer experts, nothing. Crime scene supervisors, nothing linking at the scene, Aaron Hernandez. All of these. Ballistics. More CSI. Test fire to the gun that doesn't link back to Aaron Hernandez. On and on and on. And when you get done with it, the one guy who was in charge of the entire FBI video unit, who told you we could have recovered that Cure video. Remember that? All they had to do, he was already working on the case, to say, hey, go look at this hard drive and recover this video for us, please. They never asked him to do such a thing. Why? Can you trust them? Should you trust them? Should any citizen accused have to face this kind of justice? When they won't even send what the resources they have to find the truth for you, they end up with nothing. This is why you were told, can you convict if there's no forensic evidence? Can you? Would you please? That takes us to West Palm Beach. Now, I submit to you, ladies and gentlemen, there's a whole lot in Florida that you don't know about. And I think, based on the way this case was presented, they tried their best to throw more. The whole strategy is, let's throw everything against the wall and see what sticks. What do they get you? What do they bring you first? They bring you a druggie. Someone who admittedly tells you, I was completely partying that entire week, and those days were mushed together. He didn't want to come forward. There's a lot going on in Florida, ladies and gentlemen, where Alexander Bradley specifically told you that he can't recall 2 of the 5 days he was down there. He can't account for it. What does that mean? I can't account for 2 of the 5 days I was down there? He's doing what he does. This individual, I really don't know what he contributed. He had an interesting fashion. Drives a Jaguar, doesn't have a job. I think these 2 birds of a feather. And then he's shot a month later. He's shot a month later. And you'll recall, these guys, they're Deontay Thompson's friends. Sometimes people rise above and become successful. They don't forget where they came from. Many times, when you're successful, you realize and you recognize that your past struggles and where you come from define who you are and are really the core reason why you're so successful. We take adversity and turn it into sometimes something positive. But we don't forget where we came from. And we don't forget people where we came from. And Mr. Thompson is just one of those individuals, just like that. There were 15, 20 guys at night, each of the nights at Tootsie's Lounge. Contrary to what Mr. Bradley told you. Mr. Gargars, the VIP guy, knows who Aaron is and remembered pretty vividly of both nights that they were there. Mr. Hagan tried to trip him up. Was it a Monday, Tuesday morning, Thursday? No, he remembered each night and remembered that Aaron doesn't have, VIPs and celebrities, they don't have to pay to go up in the next level. And you saw that in Cure. That's because these bars, these clubs, they want celebrities in their bars because it's advertising. It's a celebrity endorsement of their product. And they want them there. And these 5 guys, not 4, for which Bradley testified to, you know, at what point, when the facts start contradicting Mr. Bradley, at what point do you send that meal back? How many cockroaches do you need in your food before you send it all back? I submit to you, all you need is 1. All you need is 1 reasonable doubt. Especially when Judge Locke is telling you, listen with caution and great care. This guy has an incentive. And all of this is lies. He's lying to you about how many guys are there, who's there. Deontay told you they had like 4 or 5 guys, 4 or 5 cars going there. You have no idea how long Bradley was at Tootsie's. You know his phone was returned, despite the fact that he lied about that. And there are phone records of him calling. There are phone records. Now you're right, you can't place, I take that back. You can't place a person behind a phone. But his excuses to you is, I didn't have my 2 phones. But there are phone calls. And one person is telling you, one person without a dog in this fight, who hasn't seen Aaron Hernandez in 3-4 years, had limited interaction with him, is telling you, we gave that phone back. But this man is telling you otherwise. Who are you going to believe? The drug dealer or the manager at Tootsie's? This is another person coming forward and giving you a conflict in the evidence, a conflict in what Mr. Bradley is telling you. Lies from beginning to end, ladies and gentlemen. Lies from Boston to Florida. But they're going to ride him. They're going to ride him all the way home. Come on, Rocky. He can't even give you his nickname right. This guy's calling him Rock, but oh, he's Rocky. Little Rocky. He just can't tell you the truth because he's a parasite. He's here, he's got an incentive, and he's lying all over the place. They can dress him up, put his $500 designer shirt on that he didn't work for. We all have to get up sometimes and go to work. People have to get up and go to work even when they don't want to, even when they're not feeling good, even when they just don't feel like it. But this man can prance around with designer shirts and not earn a penny. He's a career criminal. The last 14 years, but now he's got a legitimate trucking business that he's running from jail. We've cleaned him up. He's got a nice Burberry shirt on. The glasses are a really nice touch. Really nice touch. And then this guy testified about a gun that he loaned to Deontay, but took it back before the shooting ever happened. They flew this guy from Florida to come here and tell you that. And they're giving all of them immunity. They're handing out immunity in this case like it's candy on Halloween. Mr. Hagan's the next Oprah Winfrey. You've got immunity. You've got immunity. We all got immunity. Everybody's got immunity. That's not how you build a case. That's not how you present a case. You're not the Oprah Winfrey of immunity. It's absurd. It flies in the face of reality. It doesn't even pass the laugh test. But they will come here and put a man's life in the balance because he's an NFL football player. That's a nice conviction. That's a nice thing to have. Facts be damned. Facts be damned. Let's look at what the other independent witnesses told you about what happened in Florida. You recall the two gentlemen that worked outside the warehouse area? The warehouse area. It's an industrial warehouse park where this all happened. That's where drug deals happen in Florida. Where they bring in cars where you can't see them, things are going on down in warehouses. No people are walking by, especially at that time of night. It's Candyland for drug dealers. South Florida. And these guys tell you they hear one shot. It's loud. It's not muffled inside a car. They can hear it from inside the building. And all of the evidence found at the scene tells you otherwise. There's a shell casing, ladies and gentlemen. It's an automatic, a semi-automatic weapon. He didn't get shot inside of a car. Ignore the obvious and just believe his story. This three-legged pony is telling you he was shot inside of a car, but yet the physical evidence tells you otherwise. The blood doesn't lie. Look at this blood spatter. Shot up to the other side of the PVC pipes. His hat that he says he was wearing. The shell casing all outside near this area. And what's unique at where this area is. This is right here, where a car cannot even pull up because of the cement blocks. And he was he walked down this alley. He was missing for 5 minutes. Remember, that's what Kevin Riddle told you. And so did Mingle Blake. Mr. Mingle Blake, hardworking man, not like this man, is at work at 5, 6 o'clock in the morning, getting ready to deliver, to drive his truck. And this man is out doing his thing. He hears the shot, walks by this alleyway and doesn't see him. They looked all over the place for him for about 5 minutes. What's he doing? Is he hiding his phone so the police can't see who he was doing his drug deals with? Does he hide a gun? Does he hide his money? His drugs? What? What's he doing for 5 minutes? And every EMT person told you he was surprisingly alert. But he wants to tell you he's not a snitch. What's he doing right here? He's not a snitch. No, he is livid with Aaron for introducing them to these Florida guys. He almost got killed because of these Florida guys. You don't mess around with these Florida boys at all. Or you get shot, you get killed. That's what this man does. He lives by the sword. And he wants you to ignore the evidence. Ignore this. Ignore this. Ignore this. Ignore all of this. And believe me, I was shot inside a car. Every piece of evidence just lies to you. All of the actual evidence, the crime scene photos, it clearly shows him walking around. He's lying to you. He's not shot inside of the car. He's shot right there near the fence. The lies carry you all the way to Florida. And what's interesting is his first words to the police. A couple black guys shot me, and some Hispanics. He knows. He knows he can't rat anybody out. He knows they'll come and kill him. And now he wants you to think doing a civil suit is not snitching, and that and basically his method of justice is he's going to kill Aaron. Well, yeah, he's pissed at Aaron for almost getting him killed. Literally he could have gotten killed. Yeah, but he's smart. He's smart. He's going to get money from Aaron first. Why kill him? Let me get money from him. Let me extort him for money. And then I'll kill him. You can conclude, ladies and gentlemen, that that was his plan all along. Based on his testimony and those text messages, all of those self-serving text messages where he's clearly trying to get money. A dead Aaron Hernandez doesn't bring a payday. But if I get my money first, then I'll kill him with my Mac 11 and my chopper. And my bulletproof vest. What does he need a bulletproof vest for? What does he need these weapons for? And they don't even go and get it. They're making a deal with Alexander Bradley, a known drug dealer, a convicted drug dealer. They know what kinds of weapons he runs with. And they leave this on the streets with this man. Why? Because Rocky's going to rat him home. Let's go, Rocky. Rocky's going to get them an NFL baller. This is unacceptable. And then what does he do after cutting his deal? He still picks up with more gun charges. Doesn't matter. It does not matter. It does not matter that you're a violent drug dealer. We're going to ride you home because you're going to get us an NFL football player. Who has motive here? You'll recall the detective. They did zero in terms of investigating this case, but yet they're bringing it up in a Boston courtroom. They didn't even go search. They went milling about. Remember that? A milling about search. Right down the alleyway. There's no crime scene tape there. Doing nothing. This man does the right thing. He gets his tape recorder and records Mr. Bradley right away, unlike the detectives here in Boston. But they don't do anything. But they still want to prosecute that case here. They want to pick it up and bring it here. Something that happens in Florida that doesn't get investigated, they bring it here. It's outrageous. It's piling it on. It's throwing it all against the wall to see what sticks. If you hate Aaron, if you see, oh, look at this. Look at the people he hangs out with. Look at this. But they're not even his friends. They're Deontay Thompson's friends. Look at all of this. Look at how he's a bad guy. Look at his tattoos. That's absurd. They don't want you to base your decision on evidence. They want you to base it on prejudice. They want to say to you, he's got tattoos. He's different than us. He's a celebrity. He's a baller. He's different than us. Remember Mr. Hagan's opening statement about the two worlds? And how he's so lucky and because he's a celebrity and he's got all of these things, but we don't. That's what they're basing their case on. That's how it's all packaged up for you. That's how it's presented to you. Not with evidence. To the contrary, ignore the evidence. Ignore that all of the evidence in West Palm Beach shows the shooting occurred by the fence. Believe Bradley. It happened in the car. Really. Now, ladies and gentlemen, it comes at this point. It comes to this point where there's no excuse. There is absolutely no excuse. And this is the time you jump off the Bradley bandwagon. If there ever was a time, this is the time you go. The excuse that you're given after he says to his lawyer, his private confidential conversation with his lawyer that no one, that man must take with him to the grave, is, now you sure once I withdraw this lawsuit, that won't be held on perjury after I tell the court the truth about me not really recalling, about me not recalling anything about who shot me. He deleted this message. This was never to see the light of day. You were never going to see this. They certainly weren't going to tell you about it. They weren't going to put this on the stand and be upfront with you and tell you. He told his lawyer in a private conversation. That's protected. That lawyer takes an oath. The attorney-client privilege is one of the most sacred things in law because it allows you to maneuver your client through the system in the just way. The lawyer then is entrusted as an officer of the court to be able to maneuver you and not put you on the stand to commit perjured testimony. That is his obligation. That is the oath that they take. And it is an important right for you to have. but it's waivable. And when he signed that waiver to get that deal of a lifetime, he thought he deleted this message. He thought it would never come up. He thought this message would never see the light of day. He is a perjurer. And you need not any more information than that alone. That is your reasonable doubt for the entire case. He swore, even if you want to even stretch your imagination and believe he's talking about the civil suit. No, he's talking about telling the court the truth about not recalling anything about who shot him. He's telling his lawyer it's the truth. He's not lying about something in the 3rd grade. He's not lying about something that happened with Johnny at the bowling alley. He's lying about this case, this shooting. And he's telling his lawyer what the truth is. How can you accept that? How can this ever see the light of day in a courtroom? How can this man ever take the stand in a courtroom when another person's life hangs in the balance? That's outrageous. It's unconscionable, and it's something you should never accept. I tell you, this case is riddled with reasonable doubt all over the place. But this stands on top as the cherry on the cake. This stands atop and stands alone. There's not much for you to deliberate about. There really isn't. The judge will tell you when it comes to witnesses that are immune. That where a witness testifies under a grant of immunity, you should examine the witness's testimony with great care and caution. I've told you about that. A defendant cannot be convicted based solely on the testimony of an immunized witness. That's all there is here, is this man's testimony. And you can't base your conviction. The law is even protecting this from ever happening. The law would never anticipate something like this. But before you even from the get-go, the law is telling you, you can't base your conviction on this. There must be something to corroborate it. But there isn't. The bullet casing's outside. 3 witnesses are telling you he's at the W. 3 other witnesses are telling you it looks like a woman or someone with cornrows.
Mr. Baez, I'm going to ask the screen be blanked.
All of this is happening. All of this is happening before your eyes. But they want to bring this man. We put together a list of a little compilation of some of Mr. Bradley's testimony. And it's riddled with lies. Take a look at this again. Remember your own recollection of the evidence. But take a brief look at this for a moment. As we look at Rocky.
My memory?
So your memory gets better with time, right?
Oh, it does. Absolutely. I'm not sure.
Did you run searches that morning?
I don't recall running searches. I don't remember exactly.
Was it a year ago?
No, I don't believe it was a year ago. I don't remember. I don't recall if I was under oath at the time of the proffer.
Okay.
No, I don't recall that.
Okay.
No, I don't recall giving that answer.
Okay.
I don't recall deleting any messages.
Okay.
Specifically.
Now 726, 3749.
I'm not sure if that's my number. I don't recall arriving on the 8th. If in fact I was down there for 5 days, I can only account for 3. That would be correct. I don't recall, but if that's what it says, then that's accurate.
All right.
I don't remember if I had my hat on when I got shot. I don't know the exact reason that he shot me. No, I don't recall ever going back and forth and that. I don't recall. I mean, I may have. I don't recall exactly how long I set the car ride to. I don't recall any of the message I deleted. That's a long time ago.
Okay, well, you know about how long it was that you lost sight of it?
I can't exact it. No, not exactly.
The words that you just spoke moments ago to the jury are different than these words, right?
Correct. No, I don't recall, but if that's what it says, then that's what I said.
Okay. And this again is a situation where your memory does not get better with time, right?
Overruled. You may answer that.
I guess in this instance, that would be correct.
We know, because what you're trying to do is stay one step ahead of the law.
That's correct.
Those are Rocky's greatest hits. That's the center of their case, their chief witness, as they call it. That's the foundation of this prosecution. He perjures himself, tells lie after lie after lie, and admits evidence before you where it is clearly false and erroneous. I want to conclude, ladies and gentlemen, by telling you a little bit about reasonable doubt. And forgive me, I know from the day you met me, I've been talking to you about reasonable doubt and and what it entails. But one of the things that you must realize when it comes to reasonable doubt is that, as I've mentioned, it is the highest burden in American legal jurisprudence. And
Counsel, I'll instruct on reasonable.
yes, sir. Now, one of the things that the court will advise you on is that you have to have an abiding conviction of guilt.
Counsel, I will give the instruction.
Yes, Your Honor. As it relates to reasonable doubt, this case is entirely caught up with nothing but doubt. You don't even get to a strong probability of guilt, which is what what Judge Locke will instruct you on. He's going to tell you what reasonable doubt means. That you have to have the abiding conviction of guilt. That it's not even enough for them to show you a strong probability of guilt. And that's not what you saw in this case. There is no strong probability of guilt. They didn't even reach that. But clearly, ladies and gentlemen, when you get to someone who is clearly lying to you, time in and time out, again and again and again, and a prosecution that comes forward to you and gives you evidence, half the story, not telling you about Brian Kwan, not telling you about the street sweeper, not telling you about the 3 people who saw the woman or man with cornrows in the car, not telling you about the people who see Aaron Hernandez over at the W. All of these facts, they scream at you, and they're telling you, he's innocent. He didn't commit this crime. He is not guilty of what he is charged with. And they can pack on and pile on all of the charges that they want. But to bring forward a trial just to get an NFL football player is disgraceful. It's a disgrace to the cause of justice. And we're going to ask all of you, both individually and collectively, to return a verdict of not guilty. There is not much to debate when you're basing everything on this man's word. There is not anything that's going to tell you that you can trust this man. A moral certainty is the level that you must base your decision on when it comes to reasonable doubt. Some of the most important decisions. This is one of the most important decisions you will make in your life because you have another life that hangs in the balance. And the burden is so high for that one reason. The law is your guide. The law will tell you where to go with this. And that you must base it all on important matters. Because why? It's irrevocable. Once you make this decision, you can't take it back. You can't say tomorrow morning when you wake up, you know what? I changed my mind. I don't think so. You can't do that. It's a decision that you will make that is irrevocable. And for that reason, the standard is so high. For that reason, you have to have that abiding conviction of guilt. That the charge is true. And in a case such as this, blocking out all the noise, or it doesn't matter. What matters is your opinions. You're the finders of fact. What was true to you? What does the citizen accused deserve? True evidence. You can't trust this man. You can't ride him home. That's not justice. Again, I thank you all for your attention. And I thank you for your service on behalf of both sides. Thank you.
Ladies and gentlemen, as soon as you...
Welcome back. I'm a LawNewz Network. You just saw the defense closing arguments in the Aaron Hernandez case. After a month of testimony, we are at the end, and this is the final round between the prosecution and defense. We just saw almost 2 hours of Jose Baez, the primary defense lawyer, giving his closing statements in the case, and I think I can say, wow, it was an incredible job. I am joined here today by Caroline Polisi, a criminal defense lawyer in New York. Caroline, what did you think?
Wow, I was blown away. I mean, talk about laying into the prosecution's case in Baez's closing statement. I mean, he just went after each and every element of the crime in the prosecution's case, calling Alexander Bradley a parasite, a career criminal, a drug dealer, a liar. He lives and dies by the sword. It was riveting, and it was incredibly effective. You know, throughout the trial, sometimes you don't necessarily know where a defense attorney is going in terms of the questions that he asks on cross and the counter narrative he's trying to bring out. But here's where Baez is really stringing everything together, saying this is a hole in the case, this is a hole in the case, and this is a hole in the case, and putting it all together. We saw that sort of barometer of reasonable doubt at the end, and boy, I got to tell you, I do not see a conviction in this case.
Well, we'll have to see. I mean, one of the things that struck me is that, you know, the heart of the defense case here really is Bradley's a liar, and the prosecution is messy, or the police work was messy, right? And poking all these holes. But I think that one of the dangers in any case like that is always that it's tough to tie that together as a narrative when the crux of your argument is this is a mess and there's reasonable doubt, because that's like so amorphous, you know? But I felt like what Baez did here was really brilliant. He gave a reason for the prosecution to want to prosecute Aaron Hernandez.
Absolutely, mainly saying that this would be a big fish for him. You know, Aaron Hernandez is a star football player, and this could be a sort of a feather in the cap of the prosecution if they could get this big
And
fish.
that's huge, because now, as a juror, because you go into it and say, well, why would the prosecution want to why would they care about prosecuting this guy?
Right.
You know, you'd sort of have to believe that the police and the prosecutors and all these people have some kind of conspiracy to do something.
Right.
And often that logic really doesn't float. Like, it just doesn't go well.
It worked here.
It
really
did.
worked
When
here.
you say, you know, that the reason why the prosecution is being overly aggressive and making things up is because they have a particular motivation
Right.
to convict this particular defendant because of something unique to this defendant.
Right.
That's big.
And you saw Baez really go beyond the point. I mean, all throughout the case, he's been making hints, dropping hints here and there, saying, you know, mysteriously that this
that he
footage
owns
at the
Beyonce,
Florida nightclub was missing. But
took it
here
back
in his
before
defense,
the
he really
shooting
took
ever
that
happened.
extra step to say, look, you know, there is collusion here on the part of the prosecution and the police team, which is Bowdoin instruction. Can you know, I mean, you can say that.
Right,
that
absolutely.
It's screaming Bowdoin instruction here. There are holes in the way that the police went about investigating this crime, and he really used that example of the mysteriously missing videotapes at Cure that night.
Right, he said the videotapes were mysteriously missing. He also had this, what I thought was a fantastic, dramatic moment of holding up this sign that says, "It's not true, but it's not a lie."
I loved it. The sign part was amazing.
I mean, what could be better, right?
You don't get any more direct or in your face than holding a sign.
And
to
the
the
thing
jury.
is, you know, defense lawyers sometimes use these techniques, right, where they're trying to dramatize a certain part. But in this case, I mean, it is like the opposite of a sleazy defense lawyer kind of move.
Right.
That kind of classic move that the juror might, you know, say, "Oh, that's pushing it a little."
Right.
This isn't pushing it at all.
Right.
This guy's holding up a thing that says, "It's not true, but it's not a lie." Everybody in the courtroom goes,
Amazing.
"Of course, that's ridiculous."
Amazing.
And he goes there and he says, "This is absurd," which of course is what everyone's thinking.
Right. Well, Bias has come a long way since the Casey Anthony trial. We saw him sort of come out of complete obscurity in that case in 2011, and now he has a real chance, a platform to really prove his merit here. And if he gets an acquittal in this case, he's going to be known as one of the preeminent defense attorneys in the country.
Yeah, and he
he's
knows
doing it.
he knows this is his stage.
Exactly.
He knows this is the time. He knows. I mean, he has done, in my opinion, a really great job of bonding with the jury, particularly during this closing argument. I mean,
Absolutely.
he was very likable. He was very believable, understandable, and logical. And he started out by saying, you know, the prosecution doesn't have to prove a motive for the crime, but if you don't have a motive, then that's a problem because it doesn't make any logical sense. And then he actually flips this whole thing. So the prosecution's motive here that has always been advanced is, look at Aaron Hernandez, who is sort of this lunatic that flew off the handle after a drink was spilled on him and committed murder in result, and look at and doesn't that make him such a terrible guy?
Right.
Baez in the closing arguments flip that completely and says the prosecution wants you to believe that this is over a spilled drink. It's their fault. That's such a stupid motivation, and it doesn't make Aaron Hernandez worse. It makes the prosecution worse for suggesting such a stupid argument.
Absolutely. It is a stupid argument when you think about it. And the prosecution really, look, we've said this from the beginning, right? The prosecution, it's not an element of the offense to prove a motive. But the prosecution stated in opening statements that this was going to be over a spilled drink. So you have to believe that Aaron Hernandez got so enraged over a spilled drink, which, by the way, Baez proved likely didn't even happen, right? We have no
We don't even know if the spilled drink even happened.
Exactly. Right. He said, you know, there are these tropes that defense attorneys kind of harp back on it, and you want the jury to remember the things that he said. So he kind of said, who are you going to believe in this case? Are you going to believe Alexander Bradley, the convicted felon, or are you going to believe the doctoral student who took a picture with Aaron Hernandez?
He said the drug dealer or the doctoral student, which is like one of those great sound bites. The drug dealer or the doctoral student.
Amazing. And who are you going to believe? And obviously the jury's going to go with the doctoral student in this one, saying, look, he was in that club for 9 minutes. Okay, Aaron Hernandez had a very specific and circumscribed amount of time in order for this, you know, this whole episode of the drink spilling to happen. Actually, you know, we heard from this doctoral student that potentially 5 to 7 minutes of that was taken up during this.
And that's
me,
big,
will you take my
right?
picture?
Because as soon as you throw in the crime could not have happened in that time frame,
Exactly.
that's big because it's not. It wouldn't have, or he didn't have motivation, but it couldn't have happened is a big deal.
Right, and Baez is saying, you know, you can't prove a negative, right? But Baez is coming pretty darn close to it here. He's doing a great job.
I also thought that there was a really a great moment where he pointed to the witness chair and he pointed to the defendant's chair, and he was talking about Bradley, and he said, he has a dog in this fight. He's either the witness or he's the defendant.
Yep.
And I think that if I'm a juror, I'm going back to the jury room with that visual of, it's not so much that whether or not Bradley has told a lie. I mean, although we did get into that as well. But the reality of, look, this guy's either the witness or he's the defendant.
Yep.
That's something that's a lot less subjective because it's true.
Yes, and
right?
this is another trope that Baez comes back to again and again about the dog in the fight, meaning what are people's motivations here to get up on the stand? And he did it again when he spoke about the manager at Tootsie's, about his testimony versus Alexander Bradley's testimony. And this has to do with the witness intimidation charge, right? The shot in Florida. And he said, who are you going to believe about, whether or not Bradley really left his phone that night? Because, of course, that's the story Bradley is telling. Are you going to believe Bradley, who does have a dog in this fight, or this guy at Tootsie's, who I thought the manager seemed very credible, only met Hernandez a couple of times, no incentive to lie on the stand? Are you going to believe his testimony?
Right.
And Baez just drilled that over and over again.
He also brought up his own doctor, the forensic pathologist,
Yes.
Dr. Downs, and he said, our doctor is not a hired gun, which of course he actually is a hired gun, right? So that's sort of funny, right?
Well,
but I understand what his meant. I think his point was he's not the type of witness that will just say anything.
Right.
He's only going to say something scientific and help you understand the science.
Science doesn't lie, right? So that's one of the things, another thing that he kept saying over and over again. I can put as many witnesses up on the stand as I want, but the science can't get up on the stand, and the science isn't going to lie.
So I think that's brilliant, right? So of course the prosecution had their own forensic pathologist, the defense had their own forensic pathologist, and basically they're characterizing that the defense pathologist is the kind of the purveyor of science and reason,
right?
And the implication, of course, is that the prosecution's is not. Then when you put together the statement that came a little bit after that, where Baez said that the prosecution is like the Oprah Winfrey of immunity.
Oh, you get
this
immunity.
is like great.
You get immunity, like candy on Halloween.
But
giving out immunity. I love it.
It's so brilliant,
is.
to say to give the jurors these points in these really great sound bites to go back to the jury room and say, they kind of did. Characterizing the giving of immunity as if it's something so bizarre, which of course it is not.
Well, it's not bizarre, but look, they did give a lot of immunity here, and let's be clear, the jury is going to be instructed that they can't, in fact, base the entirety of their verdict on testimony solely from immunized witnesses.
Right.
And of course, Bradley is an immunized witness, and he doesn't have much corroboration to his testimony. So the only thing that the prosecution has here is the testimony of this immunized witness, which we know there's going to be instruction telling the jurors that they can't base their decision solely on that testimony. That is huge. That's going to be a huge deal.
There were just so many great moments, I think, in this closing. And I think that not only did you have some great moments, but you had a wonderful ability to weave these moments together to paint a picture of a motivated prosecution that purposely wanted to get this particular defendant for their own purposes, collusion between prosecutors and police, bad police work, bad prosecutorial work, too much immunity, and lying witnesses.
Yes.
And then on top of that, you have, it's almost like the idea of reasonable doubt came after all that,
right,
as just like a little added bonus.
Right.
Hey, by the way, and there's the street sweeper and all of this stuff, and there's not enough evidence, and anything could have happened. But there was so much even before they even got to that.
Right.
Like that really felt very meaty and really like a good narrative that the jury could hold on to.
Absolutely. And Baez, again, pounding home this idea that once the prosecution decided on its theory of this case, it put blinders on, right? It didn't want to know any evidence that could potentially fall outside of what their theory of the case was. So, they come up with witnesses inside Cure nightclub, or they hear about witnesses at the scene. They don't call those witnesses.
Right.
They don't interview them. Why? Because it has the potential to go against their narrative. And Baez did a great job of illuminating these things, saying, look, when this trial started, we didn't have the street sweeper, right? We didn't have some of these witnesses that say they saw a woman at the scene of this crime, potentially videotaping something. I mean, that is huge. The fact that the detectives and the police in this case did not go to great lengths to find those witnesses, to do the really hard, deeping investigatorial work, that is a big deal.
Yeah. So I want to take a look now. We're going to go to the first clip from today, just to look back at some of Jose Baez's better moments. We're on our morning recess right now from the Aaron Hernandez case. When we come back, we will be having the prosecution's closing arguments. But for now, let's just go back to look at some of Jose Baez's highlights of his really pretty masterful closing arguments. Here's one of my favorites.
You might get lucky where the police didn't go looking. They didn't go looking for this picture because they knew that they didn't want to go looking. How upfront and honest is that with you? That's not the type of professional police work that we expect. Not anywhere. and they didn't go looking for behind doors that they didn't want to go looking for, because they knew what they would find. This is why I submit to you that the police actually knew what was going on down there and what actually happened, and knows their famous saying, "It's not the truth, but it's not a lie." The rallying around Alexander Bradley and his statements. You remember Detective McIsaac? It's not true, but it's not a lie. It's truthful, but inaccurate. What? How absurd. How stupid does he think we are? It's truthful, but inaccurate. That's what Alexander Bradley is. Truthful, but inaccurate. Because he's their pony. He's their case. He's everything and all they have, all they ever have, and all they ever will have. Because it's not true, but it's certainly not a lie. This is what they want you to believe. This is their case. This sums up the entire investigation as it relates to Alexander Bradley. And you see Aaron walking up by himself. You recall when we played the video, the first guy to walk behind Aaron is a completely different guy, because Bradley's downstairs doing his business. Now here's the thing. Clearly Aaron was out doing other things. Clearly you have evidence of that. While we have suspicions, and how we showed you how it appeared Danny De Abreu recognized Alexander Bradley, that's not our burden to prove. All we can do is point certain things out to you. We know this. We know that Alexander Bradley's a drug dealer. We know nobody crosses Sherrod. And we know what kind of weapons he carries. And we know what kind of life he lives. You live by the sword, you die by the sword. That's Alexander Bradley. What he's doing in that club, the things he's up to, what happens when he gets upset, that's Alexander Bradley. So when you have Aaron coming up, still with the 2 drinks in his hand, he didn't even have the time to finish his drinks. And remember Bradley said, well, they could have been 2 other drinks. Well, wait a minute. You testified to seeing him and him being close to you and going to the bar only once. You recall that he said he might have gotten 2 more drinks in addition to the 2 first drinks that he ordered. And he gives you this whole story about Aaron buying 2 drinks. No, that's Aaron's drink and Bradley's drink. That's simple. And what happens when Aaron comes out of the club? There's no spilled drink on him. There's nothing, 0, to indicate that anything has been spilled on Aaron. The Commonwealth wants to say to you, who are you going to believe? Us or your lying eyes? There's absolutely no proof that anyone ever spilled a drink on Aaron. To the contrary, there's proof of other things happening downstairs. Other things that clearly explain and fall perfectly within the timeline. And then some. You go downstairs, walk all the way to the other end of the bar, come back, order 2 drinks, take a picture with a fan, come back, have more interaction with him. All of this makes perfect sense. It's reasonable. It's a reasonable doubt, ladies and gentlemen. From the very beginning of this case, from its inception, its actual core motive is all crowded with reasonable doubt. It's not sprinkled throughout this case. Reasonable doubt lives here. It lives here throughout this entire.
Welcome back. I'm Aaron Hernandez on the Law News Network, and you were just watching some of the clips from this morning's defense closing arguments done by Jose Baez in the Aaron Hernandez double murder trial. This has been a really, really interesting, exciting morning We saw all kinds of great stuff coming from Jose Baez that we were just talking here with Caroline Polisi about just what a good job this was, and and really where this is going for the defense.
Yeah.
We just heard. We saw some of the more sort of memorable moments. I think that sign was a really, really memorable moment.
The sign was amazing. We saw there Baez just drilling into Detective McIsaac's statement that, their star witness in this case, Alexander Bradley, well, he's not a liar, right? But but what comes out of his mouth may not be true, right?
Right.
Which is just completely, it just flies in the face of any type of logic. So I think it was brilliant that Baez came out with that sign, because that's the type of thing that's going to stick in a juror's head, right?
Absolutely. And what I really enjoyed is you have here an experienced criminal defense attorney, right? Who this is not even his first high profile case.
Right.
We saw him in Casey Anthony. That's really where he made his name for himself. And there is always the stereotype that follows all criminal defense lawyers. I'm sure you even know this, and I'm sure that it plays into kind of your courtroom strategy, that it is sometimes really important to not play the role of the sleazy criminal defense lawyer.
Yeah, I mean, we've seen a totally different Jose Baez here than we saw in the Casey Anthony trial. He is a seasoned attorney now, okay? Way back when, he was kind of the new guy on the block. People were saying, who is this guy? Where did he come from? He came out of nowhere. Now, all of a sudden, he's got a reputation to uphold, and we see a lot of confidence. He's got the puffed up chest. He's out there. He's carrying the sign, and he's really connecting with that jury.
I think he is. I think, though, in this case, unlike in the Casey Anthony case, in some ways, it's much easier for him to do this here and to play this role. And he is coming in and really setting himself up as if he is the guardian of justice.
Absolutely.
Because the prosecution is asking people to believe something that is absurd, and they're using their power of immunity willy-nilly. And
I love his righteous indignation.
Yes,
right?
he has.
He's just appalled that the prosecution could introduce such evidence, and that there could be such holes in a case that it shouldn't stand. He made a statement, you shouldn't allow this.
Yeah, he said it over and over again. You shouldn't stand for this. You shouldn't allow this.
If it's for the star football player, if it's for a grocery store owner or whatever, what have you, that as a citizen of the United States, you are entitled to have the prosecutors maintain some level of credibility.
And I thought that in today's world, that was really effective. To say to the jurors, I mean, and he didn't use the words, well, this could happen to you, you could find yourself in a defendant's chair. But I really think that the message and the inference was there to say, look, it's hard to prove a negative. That's why the state has to prove beyond a reasonable doubt that these things happened. Because if they accuse you falsely, it's really difficult to defend yourself, and you're not going to be able to necessarily prove that something did not happen. And he kind of said that as a very general statement.
Yeah.
So yes, it applies to his client, that Aaron Hernandez would have a hard time proving that he didn't do the shooting. But the inference is there. Anyone could wind up in a position where they'd be forced to prove a negative, and imagine how difficult that would be.
Absolutely. He also drilled into the prosecution's theory of this case. In their opening statements, the prosecution laid out these two separate worlds, right? We have the Aaron Hernandez world. He's a celebrity, he's rich, he's famous, he's wealthy. And then we have everybody else that goes about their job, the regular, ordinary people. Well, Baez flipped that on its head in his closing statement, saying that it was, in fact, Alexander Bradley, who is a freeloader. He's wearing, today he's wearing his
$500 shirt. Yeah.
But in fact, he's a drug dealer, right? And he gets money based off of committing crimes. So that was a brilliant move, taking what the prosecution laid out in the beginning and flipping it on its head.
And then also suggesting that it is this double world, which is the very reason why Aaron Hernandez is being prosecuted in the first place.
Right.
Because if he were just an average Joe, no one would care about the conviction, but because he's an NFL star, it makes him a much bigger win. But I have to ask you about that, though. During the trial, did you feel that the prosecution was really hammering home that the jury should mistrust him, Aaron Hernandez, because he was rich and famous? I didn't really get a lot of that during this trial.
No, if anything, what you saw was the defense, Baez, using that in the case of the Alexander Bradley witness intimidation charge. You saw the defense use the idea that, look, this guy is rich. He could potentially, there's some money there. And we saw him in the closing statement.
That it's a motivation for suing him
call
civilly.
Alexander Bradley an extortionist, right?
So I was sort of surprised when I heard Jose Baez talk about this double world thing, and don't apply a double standard, and don't let your prejudices influence you, because instead of convicting this guy because he's so different from you with his tattoos and his NFL and his money, treat him like you would treat everybody else. It was a great argument. It certainly, I think, hit home. I don't think it had anything to do with the trial, though. I never felt that this was a trial where the theory was, Aaron Hernandez is so different from you, that's why you should convict him.
Right. There's always a fine line when you start getting into the cognitive biases or potential cognitive biases of the jurors, and that's why we see this cottage industry popping up about jury selection, right?
Yeah.
Because you want to find jurors that are going to relate to you, and so as a defense attorney, you want to make your client as likable as you can to the jurors that are sitting in that box.
Right.
And that's one way he's trying to do it.
So, and it's, the implicit message is, if you vote to convict Aaron Hernandez, it's because you have a bias, your prejudice. And the only way you can prove that you don't have some kind of bias is if you vote for acquittal, which of course is not true.
No, but it's a great tactic.
But it's a great tactic.
Right.
I also really loved, we're going to play another clip now, it's that second clip. I loved this as a characterization of the prosecution's case. This, if I had been a juror, would have stuck with me. It stuck with me now watching. The characterization about squinting, about what the prosecution is asking the jurors to do, and how their case just doesn't make sense. Take a look at this clip. I thought this was a great characterization of the prosecution's case as a whole.
Through this area. And you remember Sean McCann, one of the very first witnesses who called 911. Do we have his photo? He testified to seeing Aaron right at the top. He testified to seeing Aaron speaking with two individuals later on that night. That he was with two guys. He couldn't describe whether the person had cornrows or not, but he said something specific. And he said, yeah, I saw him with two people. There's a lot that you don't know because the state didn't go digging for it. We can only do so much coming into the case much later. The state had this case from its inception. They investigated a certain way, and they were not going anywhere that Bradley wasn't taking them. And that's a fact. These three witnesses all saw him over by the W right around that time that the missing video won't show you who actually went in that garage. Shadowy figures, looks like what they're wearing, maybe. They want you to squint like you're looking at a toast with Elvis on it. Don't believe the facts, the hard evidence facts. Squint a little, stretch, speculate, and then you'll see our case coming together. That's the Commonwealth's case in this case. That's what they presented to you.
We're back. That was just a little replay of some of the finer moments of Jose Baez's defense closing arguments in the Aaron Hernandez case. That was great.
I know. You love that.
I do. I love it. And the reason I love it is because it does not smack of theatrics in the way that I think those type of things sometimes do.
Right. Well, you loved that one. My favorite was how many cockroaches do you need to find in your meal before you back, which was sort of the same idea.
Same idea.
These things can veer into the cheesy factor. Okay,
yes.
You can get, but they are effective in that they remain in the jury's mind, right?
Yeah.
Like the glove don't quit, you must acquit. I mean,
right.
That type of thing. These are things that.
But I think what I think though is that the reason I find that type of thing is so effective in this case is not just in its ability to stick in the juror's memory, but also in the ability to sort of give a name and a picture to something that the jurors may have already been feeling.
Yes.
So, the idea that, there are some holes in the evidence, that's like a very vague kind of thing.
Right.
But when you say to the jurors, the prosecution is asking you to believe something that's absurd.
Right.
They're asking you to make inferences that don't make sense.
Right.
And they're asking you to kind of squint and say that you see something but ignore the facts that you really do see.
Right.
It's almost like that is a way of describing really, in many ways, exactly what's been going on. And prior to this point, the jurors might have had a hard time articulating.
Right. The prosecution really dug its own grave in the opening statements that it made. Specifically, they said, this isn't going to make sense because murders don't make sense. That was a terrible thing to say.
Right.
Because
murders often make sense.
You need to have a coherent story. The prosecution, that's in fact exactly what the prosecution
But of course they
needs.
don't have
Correct.
a coherent story.
Baez did a great job on closing, tying in this squinting idea, saying, I guarantee you, this was a very effective tool he used. He said, I guarantee the prosecution's going to get up in summation and say about this mysterious woman with cornrows. If you squint hard enough, you can look at Aaron Hernandez and see the beads that he's wearing around his neck are actually cornrows. That was amazing.
It was great because, it really is, it's looking backward at what the prosecution has already done and said they're really asking you to look too hard at this. And then they're going forward at what the prosecution is going to say in its closing arguments, so that now if the prosecution says, oh, it could have been this, it could have been that, it could have been this, now they've already kind of set the stage for, look what they're doing. They're asking you to squint harder again.
Exactly. And remember, Baez doesn't get a chance to rebut the prosecution's closing.
Right. So he's sort of rebutting now in advance.
Exactly. He's laying the groundwork. He's saying, remember that I'm telling you that I predict that this will happen. We'll see if it's going to happen, and I'll be very interested.
I mean, I think that in trials, anytime someone credible predicts what the other lawyer is going to do, I think that can be a very dangerous moment, because when you predict and then the other person does exactly what you predicted, there's almost no coming back from it sometimes.
Well, the prosecution now is between a rock and a hard place, right? If they were planning on saying, on introducing some form of perhaps the beads could be construed as cornrows.
Right.
No,
they can't do it now.
They can't do it
now.
They can't do it now. But if they were going to rely on doing that, now they got to think pretty quickly. What are they going to say in rebuttal of that statement?
I wonder if this break, if the morning recess is helping them now that they're kind of redoing their closing argument.
They have the benefit, obviously, of going last. It's the last thing that the jurors are going to hear, because it is their case, right? They go last for a reason. This is the prosecution's case. It's the prosecution's burden. Therefore, the law dictates that they should have the last word.
Sure.
But I got to tell you, I think Baez is going to stay in their minds. I think he did an amazing job.
Early on in this case, when we were in the beginning of the prosecution's case in chief, one of the things that I know we talked about here and several of our commentators brought out was the idea that the prosecution was being very transparent in bringing in witnesses like the street sweeper, who didn't exactly bolster their case, but it was sort of like a laying out, look, this is what you're going to find. This is what evidence is going to come to light. So we're just going to be clear about it now to create credibility. And at that time, in the beginning of the case, I thought it was very effective, to establish that bond and that trust with the jury. But now what we're seeing is, even with that kind of show of transparency, it's not working. So I'm hearing that it looks like we're going to go back to the courtroom. Their morning recess is over. Are we ready to start? Okay, so we're back in the courtroom now. We're going to hear the prosecution's closing arguments.
Jerry, we're in a moment going to turn to the Commonwealth for its closing argument. And I do want to comment on one aspect of the defense closing argument. You may note that I interrupted Mr. Baez towards the end of his closing as he was discussing reasonable doubt. And that's only because, as I told you at the outset, one of my roles is to be the judge of the law. That is, judges are very protective of their responsibility to state the law, to instruct you on the law. And for purposes of a trial, the judge is the judge of the law. So I have to reserve to myself the responsibility to give you full instructions in this instance as to how to define reasonable doubt, what reasonable doubt means. It's not to suggest that Mr. Baez did anything wrong in his pointing out to you where, in the view of the defense, reasonable doubt may be found in this case. That is perfectly appropriate argument. One other aspect was a reference to the consequences of your verdict and your verdict being irrevocable. And I'd ask you to disregard any consideration of the consequences of your verdict. Your job is to determine whether, from the evidence presented and the inferences you draw from that evidence, whether the Commonwealth has proved the essential elements of each charged crime beyond a reasonable doubt. If it has, then you should return verdicts of guilty. If it has not met that burden of proof as to any essential element of any charged crime, then as to that offense, your verdict must be not guilty, without regard to the consequences of those verdicts. All right, we'll turn now to the Commonwealth. Mr. Hagan.
It is often said that a picture tells a story. And each and every one of you now know the terrible, the violent, and senseless story that these four pictures show. Two men's lifeless bodies covered in sheets. Daniel D'Abreu and Safiro Furtado. Two men who you know did nothing wrong that night. Two men who you know, despite baseless allegations from a defense attorney, were doing nothing wrong that night. They were doing nothing wrong when they were brutally murdered and killed. Two men who were not drug dealers, drug addicts, gun-toting gang members. You now know from the evidence that these were two men, hard-working immigrants to this country, who were out for a night with their friends to have a good time, who were set upon by a killer who was motivated by an illogical, senseless belief of being disrespected, being tried. A belief that will never, ever, no matter how long this trial were to go, no matter how many pieces of evidence we put before you, it would never make sense, because you cannot fully climb into the mind of a killer. Ladies and gentlemen, this car, these pictures of what was in that car, the carnage in that car, speaks volumes. It speaks a story. Their bodies pierced by 5 devastatingly accurate and deadly gunshots. But you now know from the evidence that not only 5 shots were intended to be fired by that killer. That killer took pleasure in what he did that night. That killer wanted his victims to see it coming. He called their names. And if there's one thing you can take from the know-it-all Dr. Downs, you can take the fact that we agree with his assessment that Safiro Furtado was looking at the shots as they were coming, looking down the barrel of a gun held by a murderer, because that killer wanted him to see it coming. These photographs, ladies and gentlemen, they speak to murder in the first degree and nothing less. 5 bullets shot into that car, killing those men, but more pulls of the trigger than 5. The killer wanted more carnage in that car. He continued to pull the trigger, but the gun was empty. Each pull of that trigger, ladies and gentlemen, think about it. To think, to pull the trigger, to hear the shot, to pull the trigger again, to hear the shot, to know, particularly when you were driving home, that you got one in the head and one in the chest. The killer knew that. Ladies and gentlemen, that screams intent to kill. That screams deliberate premeditation. That screams, these photos scream the crime here and nothing less, murder in the first degree. Zafiro Furtado, we don't dispute the fact that he was killed instantly. 2 kill shots fired by that man's gun right into his head killed him instantly. But that does not change the fact that he was killed with deliberate premeditation with an intent to kill. It's a different story with Daniel D'Abreu. You now know from the evidence how he died. And let's think about that for a moment, how Daniel D'Abreu died. 2 gunshots to his chest, gunshots ripped through his lungs, through his heart. His chest cavity began to fill up with blood. He breathed in blood. You heard that testimony from the medical examiner. And even though the celebrity know-it-all Dr. Downs says, oh no, he would be unconscious within seconds, Dr. Downs wasn't there. But Rashidi Sanchez was there. Donald Gobin was there. Brian Kwan was there. Rashidi Sanchez told you that he was not unconscious. Rashidi Sanchez told you what his last moments were like. He was trying to speak. He was conscious. He was laboring to breathe, and then he expired. Seconds, 10 seconds, or 60 seconds. Doesn't really matter when you think about the way that he died. 10 seconds. That was 10 seconds, ladies and gentlemen. So does it really matter whether it was 10 seconds that he lived or was conscious or 60? He was suffering when he died. And I don't tell you that to upset you. I don't tell you that to shock you. I don't tell you that, as Mr. Baez said, to make you angry. I tell you that because when you hear Judge Locke's instructions later on this afternoon, you will realize it's important. It's important to know how Daniel D'Abreu died. It's important to know whether or not he suffered. It's important to know whether or not the killer took pleasure in the deeds that he had done. Because, ladies and gentlemen, that will be the definition of extreme atrocity or cruelty. A murder committed with extreme atrocity or cruelty, which soon you will know from Justice Locke means murder in the first degree. That's perhaps the easiest part of your deliberations, what the crime is here. Murder in the first degree by deliberate premeditation of both victims, and murder in the first degree by deliberate premeditation and extreme atrocity or cruelty for Daniel D'Abreu. Ladies and gentlemen, about 7 weeks ago, each and every one of you were summoned to jury duty. It was the week of February 14th. There was a snowstorm on the 13th. Court was canceled. Each and every one of you came in and sat through a rather long selection process to become jurors. And at that time, you knew nothing about this case. About a week later, you were sworn in as jurors. You were chosen by the sides, by agreement, because each and every one of you could be fair, impartial, and objective. Each and every one of you would give this case the attention that it deserves. And you've held that bargain, or you've held that obligation amazingly so. No sick days for you. You were here on time every single day, and as Mr. Baez said, both parties appreciate that. When you came in and the evidence began, you were sworn as jurors. You still knew very little about the case. A few days later, you went on a view. You stood in the very spot where Daniel D'Abreu and Zafiro Furtado's life literally drained out of their bodies. Stuck in that car, trapped, nowhere to run from the killer's bullets. You stood in the spot where it all began. You stood in Club Cure. You walked around Club Cure. You walked to the parking garage. You went all around the area. You actually stood in a spot where the killer car saw the victims and set upon its prey. That was the view. You still knew very little then, ladies and gentlemen. Here we are, 5 weeks later, 70 witnesses later, almost 400 exhibits later. Now you know the truth. Not from anything I say or what Mr. Baez says. You know the truth from the evidence in this case, which speaks loudly and it speaks clearly. You now know the truth of who the killer was that night on July 16, 2012. You also know that that senseless violence did not end on July 16, 2012, but that violence continued 6 months later when the same perpetrator unleashed the same type of violence on the only man who could tell his vicious, awful secret, his former best friend, Alexander Bradley. And ladies and gentlemen, you now know from the evidence that the killer who I speak of sits right before you, Aaron Hernandez. Now, you just heard Mr. Baez's closing argument, much like his opening. Very well said. But think about what Mr. Baez said, and think about the evidence, and how much of what he said was actually supported by the evidence that you heard. And a lot of Mr. Baez's closing argument was about Alexander Bradley, and that's fine. I want to talk about Alexander Bradley with you. But before we do that, just bear with me. I want you to consider, ladies and gentlemen, as if you heard this case and did not hear one word of evidence or testimony from Alexander Bradley about the events of July 16, 2012. What if you only heard evidence from other sources? And what if the only thing you knew from Alexander Bradley came from his presumptive lawsuit he filed for being shot in the face? That's it. Bear with me. Let's go through that evidence if we can. The car. Is there really any doubt what the murder car was in this case? Did Mr. Baez even dispute that just now in his closing argument? Who had the best view of what the murder car was? Donald Gobin and Brian Kwan, right here on Marginal Street. You were there during the viewing. A block away, the silver SUV pulled up right next to them. Brian Kwan, Donald Gobin, they both got a great look at the car. Donald Gobin in particular knows cars. He actually said that night either a Toyota 4Runner or a Nissan Pathfinder, Rhode Island plates. That was said that night. Similar descriptions from Brian Kwan as well of the car. The survivors in the car, Mercedes Sanchez and Aquilino Ferrer, they both said silver SUV. You now know without any doubt that the car, the murder car, was a silver 4Runner with Rhode Island plates. You also know that the police and investigators scoured the video. The only car that fits this description coming out of that garage at any relevant time is this car right here. The silver 4Runner Toyota with Rhode Island plates. And there's a license plate. And you also know from the evidence that that's the murder car because you can see it pass by the victims twice that night, just prior to the killing. The first pass you see at 2:18 in the morning. The second pass you see at 2:20 in the morning. You can tell that's the exact same car. You don't need John Green's boards to do that. You've watched enough video during this trial. That is the murder car. You can watch that car pull up and park in the very spot where you stood during the view, the very spot where Mr. Bradley, we'll talk about in a moment, told you where it was parked. You can actually see the signal being put on. And this, again, ladies and gentlemen, is probably one of those blurry images that Mr. Baez refers to. But is this blurry at all? You can see the car park. You can now see the brake lights on. There's no doubt that that silver SUV with the Rhode Island plates parked there. And then later on, is there really any doubt? Here the victim's car is leaving the parking garage. You can see the two blurry figures, as Mr. Baez calls them, now walking back to that SUV. You see the victim's car pull out. And it's not coincidence, ladies and gentlemen. It's evidence what happens next. You will see that silver SUV pull out of that spot. You see the lights come on. Again, it's not blurry. You don't have to be a video expert to know what you see. You can see that car pull out and follow behind the victim car. And there it is. Right behind the car is Safiro Furtado, Daniel D'Abreu, and the other victims. The car is now in pursuit. And who is in that car? You know exactly who's in that car, ladies and gentlemen. Aaron Hernandez was driving at that point, at least initially, and Alexander Bradley's in the passenger seat. Again, we're considering the evidence as if you never heard a word from Alexander Bradley, so keep thinking about that as we go through this. Who's in that car? Aaron Hernandez, Alexander Bradley. No doubt. And then this is a video that Mr. Baez just mentioned in his closing. The video that maybe you were wondering during the trial, why did I keep showing it to you? Why did I keep using the magnifying feature on Windows Media to show you this video over and over again? Why does Mr. Baez not want to talk about this video? Why does Mr. Baez keep calling this a blurry video? Watch it, ladies and gentlemen. If there's one favor that Alexander Bradley did that night, it was the clothing that he chose that he was going to wear and Aaron Hernandez was going to wear. Remember, he let him borrow clothing? Is there any doubt from that video that I just played that you can see Alexander Bradley's yellow shirt? You can see Aaron Hernandez's gray shirt. You can even see the white insignia. It's not blurry. Look at the white. You can see the gray on white. Look at how tall he is. He's as tall as Bradley. Look at the white sneakers. Is this the mysterious woman, the 6-foot-tall woman with the braids that Mr. Bradley somehow picked up in the middle of the night and ditched Aaron Hernandez and went and did the murder? I mean, that's what Mr. Baez is asking you to believe. This is evidence that Aaron Hernandez and Alexander Bradley are in that car. And here's them leaving. Alexander Bradley's shirt, the gray shirt right in front of him, Aaron Hernandez. You're going to notice something very common in these videos I show you. There's always a certain person who's always leading the way. First person to walk in the club, first person to walk out of the club, first person to walk just about everywhere. And guess who that is? Aaron Hernandez. Because he makes the decisions. He was the leader that night. And he was the one who pulled that gun and killed those men. And as if you need to see it again, here's still photographs. Blurry? You can see the gray with the white. You can see Alexander Bradley's yellow shirt. Is there really any doubt? You can even see the baseball hat. Is there really any doubt that those two blurry, shadowy figures that Mr. Baez keeps referring to, is there any doubt that that's Aaron Hernandez and Alexander Bradley? And if you accept that that's Alexander Bradley and Aaron Hernandez, they get into that murder car right after the victims pull out, and then they follow behind. And you know what happens after that. And there's more. That car, who does that car come back to? The license plate, Fox Toyota. A car leased to Aaron Hernandez. Should that surprise you? And again, we're pretending we haven't heard a word from Alexander Bradley. Keep that in mind as we go through this. Where's that car found? Is that murder car found at Alexander Bradley's cousin's house? Is that car found, the murder car found, at the closest relative that Alexander Bradley has? Oh no, that murder car is found stuffed away in the garage of the house of a relative who he trusts more than anybody. You heard the evidence from various sources how much he loved Tanya Cummings Singleton, his aunt. I believe the sister said she was like a mother to him, a second mother. And where is that murder car found stuffed away? In that garage, you can't see through the windows, collecting cobwebs, stuck in that car. And that does not seem like a really wealthy family that lives at that house. You think that if they had cars, a nice 2007 or 2006 Toyota 4Runner, they wouldn't want to use it. But you know that car was never used again. Jennifer Mercado told you that was garaged about a year ago, July of 2012. No one's used it since. The battery's gone dead. It's collecting cobwebs. But guess what? The inside of that car is plenty clean because Aaron Hernandez made sure that his cousin cleaned it well. And you've heard evidence of that. Who lives at that address? Tanya Cummings Singleton, his closest relative. T.L. Singleton, the man who you know from the evidence, became close to Aaron as well. That's where he stuffed the murder car. What connection does Alexander Bradley have to that? You think Tanya Cummings Singleton and T.L. Singleton are going to hide a murder car for Alexander Bradley? Seriously? Again, we don't have to go over and over it again. That is the car used in the murder. There is no doubt about that. That car is tied to one man and one man only, Aaron Hernandez. But there's more. The very next day, July 17th, 2012, what does Aaron Hernandez do? He rents a car. Of course, Shayana Jenkins would lead you to believe, oh, it's no big deal. We just rent cars all the time. Just on a random Tuesday, we're going to rent a car. Despite the fact that you have the black Range Rover, you have the silver Toyota SUV, the 4Runner, that she said she drove too, suddenly it just disappears. But Shayana, remember, she doesn't ask any questions. She knows her role. The car just disappears, and he rents a car the next day. Guess what's that's called? Consciousness of guilt. That's evidence. And there's more. The murder weapon. Did you notice in Mr. Baez's entire 1 hour and 25-minute closing, he didn't mention one thing about the murder weapon? Not one thing. You know what the murder weapon is, and you know where it was found. There's the murder weapon. Think about this. Jaylene Diaz-Ramos. June 21st, 2013. Now, doesn't that date seem rather interesting and convenient? Just as the police were starting to converge at 114 Lake Avenue, you heard evidence from Trooper Donovan that a search warrant was executed on the 26th of June, 2013 at 114 Lake Avenue. So here we are, 5 days prior to that, and the murder weapon is on the move. Isn't that interesting? Isn't it interesting who is found with the murder weapon? Jaylene Diaz-Ramos, a young woman from guess where? Bristol, Connecticut. A young woman who you now know has ties to guess where? 114 Lake Avenue, where the murder car was held. 114 Lake Avenue, which is like a second home to Aaron Hernandez. Jaylene Diaz-Ramos' best friend in the world, the man she grew up with, John Alcorn, also known as Chicago. Who's his cousin? Close cousin, T.L. Singleton. Where did they grow up? The exact same house of their grandparents on 275 Sandstrom Road in Bristol, Connecticut. Who is T.L. Singleton married to? Tanya Singleton. Who's the closest relative to Tanya Singleton, the person who he trusts more than anybody and he's closest to? Tanya Singleton, Aaron Hernandez. Aaron Hernandez, John Alcorn had been to 114 Lake Avenue. You heard from Jennifer Mercado, he had been there. Obviously, T.L. Singleton lives at 114 Lake Avenue. Tanya Singleton lives at 114 Lake Avenue. And Aaron Hernandez spends an awful lot of time at 114 Lake Avenue. The murder weapon is linked to Aaron Hernandez. The murder car is linked to Aaron Hernandez. There is no link to any of these people to Alexander Bradley. So again, does the defense want you to believe that Alexander Bradley does the murder, but he convinces Aaron Hernandez to hide the murder weapon with his relatives, who would later give it to some woman who's trying to move it when she gets pulled over and she gets caught after a car accident?
Object, Judge, to
Good afternoon and welcome back to Law News. This is Stephanie Willis. I'm here with Charo Esdrin this afternoon, and we just see that we just went to sidebar because Jose Baez presented an objection during the prosecution's closing arguments. Has that ever happened to you before, Charo, during closing arguments?
It's a very rare occurrence that an objection would be called out during a closing argument. Why this was done at this point, it may be a red herring just because Baez didn't like what the prosecution was saying.
Right.
It could be for many, many reasons.
Right, and you know, that tends to happen sometimes. Sometimes we tend to use objections just to kind of, as you said, use a red herring or just to kind of throw opposing counsel off of their chart, so to say. So we had closing arguments this morning. We had them, Jose Baez actually started. And usually what we find is generally during the trial that the prosecution will start closing arguments first, and then we will switch to the defense, and then the prosecution will have their rebuttal. Excuse me. But that didn't happen in this case. Like, how do you think that favors for the prosecution?
I I don't believe so much that it'll favor the prosecution. Baez going first and the prosecution going second will undermine everything that Baez just said.
Okay.
And if we did it the other way around, then there would be no rebuttal. So we wouldn't. I believe it's going to hurt the prosecution at this point.
How so?
It'll hurt the prosecution to the point where they'll get their last word in now, and if they miss anything that Baez had to say, or there was something that was not in their final argument, they won't have that opportunity to go back and rethink what they wanted to say.
Exactly. So it doesn't present them with the opportunity to kind of just muddle down everything that was said, give them the opportunity to recoup a little bit, and then go back and have their rebuttal. I completely agree with you with that. So Jose Baez, during his closing arguments, the first thing that he came out with was reasonable doubt, and he said that he hammered on it a lot. He said, during the trial, I hammered on it a lot because, that's the burden that the prosecution has to prove in essence. And so how do you think that that the defense fared with the how do you think the prosecution fared with their burden of proof in this case?
On their first trial, it was all circumstantial evidence, but it was strong circumstantial evidence.
Right.
This time, it's all circumstantial evidence again. And in my opinion, it's not as strong as it was in the first case. They were not as meticulous with they lined it up meticulously, and they really made a case the first time around. This time, there is reasonable doubt.
I completely agree with you. And, that goes back to what Jose Baez was saying in regards to they didn't find any DNA evidence. Right. The gun is not really the same, because we heard from Alexander Bradley's testimony, who is their star witness, that he said that wasn't necessarily the gun that was used at the scene of the crime. So you have no DNA, you have no fingerprints, you have no CSI evidence, and the jurors this day and age, they love the CSI kind of evidence that they see on TV. So they really don't have much. So I do tend to agree with you. I think that they have a long way to go, I think. But I do think that Prosecutor Hagan is doing a good job. So far, I mean, he just started, and it's kind of hurts that he has to stop, because then he has to go back and look to his notes to see where he was cut off by Jose Baez. But hopefully, when he gets back on track, he'll be good to go when we get back from sidebar.
And remember, it's a show.
Right.
It's a show for those jurors. And if he's in the middle of making this grand presentation and all of a sudden he's cut off, it stops mid-show. Right. And all those feelings that the jurors may be having. I mean, listen, it's beyond a reasonable doubt, and we hope the jurors are impartial.
That's a good point that you made, that it's regarding the jurors' emotions. And that's something that Jose Baez actually said during his closing arguments. He stated that when the prosecution first started with their case in chief, that they showed a lot of gory pictures of the scene of the crime, just to pull at the emotions of the jurors. How do you think? Do you think that's true?
It is. Everything is about pulling at the emotions. Even though the jurors are given strict instructions that you need to be impartial, and they're vetted out, human nature takes over.
Well, we're going to see how it goes, because we're back in the courtroom.
Bradley, but there's more. Interactions with the victims. Well, this was another part of Mr. Baez's closing that, although he mentioned Mr. Ojimba, it's very interesting he didn't mention all of Mr. Ojimba's testimony. Well, first you have the victims and Aaron Hernandez walking to Club Cure together. And then here we are downstairs. Remember how many times you have to look at this photograph? Remember Ojimba's testimony. And Mr. Baez suggests he's biased for the Commonwealth because he works at Cure. Do you remember his testimony? He doesn't even work at Cure anymore. So Mr. Ojimba, Ugo Ojimba testifies. Remember what he testified to. And talk about a witness with no dog in the fight. A witness who just came in and told what he remembered, right? And he testified in the grand jury. Mr. Ojimba testified that he saw an interaction between the defendant and the victims, the two people who he later saw in the car, dead, riddled with bullets. He saw an interaction, and it wasn't just any interaction. Remember what he said? Something about it caught my attention. Now, granted, at the end, he concluded You'll remember that testimony, that there was nothing going on and there was not going to be any hostile interaction. But initially, it caught his attention. And also remember what Mr. Ojimba said about the makeup or where the positioning was. Aaron Hernandez was having a conversation or some type of encounter that caught his attention with, guess who? The man with the braids, the person we now know as Daniel D'Abreu. And where was the man with Aaron Hernandez? Over his left shoulder, not part of the conversation. And then Mr. D'Abreu had one of his friends nearby, and maybe a third, I think, was a testimony. Your memory obviously controls on that. But isn't that a compelling, important piece of evidence in this case? Doesn't that indicate that there was some encounter between the defendant and the victims in this case? Doesn't that almost knock out of the park all this nonsense about whether or not this could have happened in 9 minutes? And very quickly on that, Mr. Baez suggests to you that the Commonwealth and the police hid Jamie Furtado from you and hid the fact that there was a photograph taken with a fan? Seriously? Who put Jamie Furtado on as a witness? We did. Jamie Furtado even learned testified in the grand jury. Jamie Furtado testified on direct examination to taking a photograph with a fan. That was hidden from you? Because the police didn't figure out who the fan was and get the actual photograph from his phone? That really matters? That makes a difference? That makes the police investigation corrupt? That makes the prosecution corrupt? Seriously? So think about this, ladies and gentlemen. Mr. Ojimba, he has the interaction between the defendant and the victims. That's evidence, and that's important evidence. I have one moment now. And then what about this, ladies and gentlemen? Exhibit 275. Mr. Baez put something out similar to this. Aaron Hernandez leaves in 9 minutes. Nobody disputes that. But Mr. Baez acts like that's actually a good thing for the defense. So that's a thing that should cause some reasonable doubt. Jeff London's testimony, he said it was very unusual for Aaron Hernandez to go into a bar, the Club Cure, and leave in 9 minutes. There had to be a reason he left so quickly. And you know that reason because of the encounter he had with the victims. And Mr. Baez again makes it seem helpful that he's downing 2 drinks. Why is he downing 2 drinks as he's walking out of the door? Why not finish the 2 drinks downstairs? He didn't finish the drinks downstairs because something happened downstairs that caused him to leave. That is more evidence suggesting his guilt in this case. Ladies and gentlemen, what the additional evidence, the description of the shooter. Mercedes Sanchez.
The guys come, pull over, and said nigga or something like that.
Can you see in the car? Can you see into the car that pulls up next to you?
Yeah, it pulls up because I'm sitting in the back seat like on the right.
Okay, behind the passenger seat?
Behind the Safety.
Okay.
And then I see the car like the white guy with hat like.
What color hat?
You said the car?
No, his hat. What color is his hat?
There's a lot of color, like I think it's maybe white and something like the design is different, like.
Okay.
Mercedes Sanchez, arguably the best view of anybody in that car. Think about it. He's on the side closest to the shooter car. He's right there. He sees better than anybody. What description does he give to the police? You heard it. A man with a white hat. A white guy. A white guy. Aaron Hernandez, you heard, is half white. His mother's Italian. His father is Hispanic. Aaron Hernandez looks like a white male. Would anybody really, and Mr. Baez may have said that certain people when he was shot in the face thought he was light-skinned and white, but would you ever look at Alexander Bradley's facial features and think he's a white man? Really? White man was the shooter. And what about the hat description? White with color on it. Who does that look like?
You see any hair at all hanging out from under the hat? It's a white guy. No facial hair.
No what?
No facial hair. He doesn't have anything on his face.
No, nothing face.
Is his face? Is it fat? Is it round? Is it thick?
Skinny.
Skinny.
Yeah.
No facial hair. Look who has no facial hair. Aaron Hernandez. Look who does have facial hair. Alexander Bradley. Shooter's face. Skinny. Who has a skinny face? Who had back then a kind of round, almost fat face?
You see any hair at all?
Nary's close up again. Looks like a white male with a thin, skinny face. And yes, you can see the beads. Mr. Byers can mock that, but you know those are actually braided beads on his shirt, over his shirt. What is the evidence that there is of a female in the car? Really, let's talk about that real quickly. So the only evidence of a female in the car comes from Brian Kwan, but not his trial testimony. He told you he doesn't remember what the shooter looked like. It could have been a man, could have been a woman. And that makes sense because Brian Kwan didn't get a good look at the passenger. Brian Kwan's in the lower car. He's looking up at an SUV. He sees a figure there. And he said it could have been a man, could have been a woman. And Mr. Byers pointed out that back in 2012 he mentioned something about braids or something to that effect. But think about it. If Brian Kwan is looking up into that window and Aaron Hernandez is leaning over like this, trying to figure out if this is the car with the people he wants to shoot, you don't think that those beads braided like that could look like braids? And what's the only other evidence of women? Again, the defense theory that Alexander Bradley picks up some woman, dumps off Aaron Hernandez, and commits the murder? Seriously? The other evidence of a woman comes from Aquilino Freire, who didn't even see the shooter, didn't even see the gun. And he said, well, I may have seen a woman in the passenger seat, but again, that's not what he really testified to, was it? And then the only other evidence of a woman, this is the most absurd evidence of all the defense is asking you to find reasonable doubt in, from the street sweeper who comes after the fact. The shooting's already happened. Aquilino Freire has fallen out of the car. It's already happened, and he sees an SUV with a woman calling 911 or filming it. That's not somebody involved in the case. Even Mr. McMaster told you that. That's somebody who comes after the fact and is witnessing it. This whole woman thing, it's a red herring.
You see any?
There's more evidence, again, without Alexander Bradley. The cell tower records. Cell tower records put him in Boston right at the time the murder starts, 12:13. 1:13, right there on Stewart Street, right near Club Cure. $2:13. We're talking 20 minutes before the murder now. Right there, still, near Club Cure. And this one, probably the most important one of all. 2:37. Again, if there was any doubt whether or not Aaron Hernandez is in the murder car at the time of the murder, it's gone now, isn't it? 5 minutes after the murder happens. 2:32 is the time of the call. Here is his phone, Aaron Hernandez's. Guess who he's calling? Shayana Jenkins, his fiance. 17-second phone call. And the car, as you know, is on the move. The car is clearly, from the evidence, traveling down the Massachusetts Turnpike. There it is. Call starts here on this part of the pike. Westbound, there it is, the call ends. Again, Jenkins Hernandez, has no memory of that phone call. She also apparently doesn't have any memory of the phone call earlier in the night that you'll see on the tower records. That was for about 2 minutes and 37 seconds. But again, she's in Florida. She doesn't remember anything. We'll get into Jenkins Hernandez in a moment. Then, Newton. West Newton, still heading westbound. Then this point, clearly, they take a turn up north on 95, 128. Then they head back down. Is that indicative of getting lost? That's up to you to decide. And here we go. They're on the road to Connecticut. Manchester, Connecticut, 4:40 in the morning. And then finally, where do they end up, ladies and gentlemen? Again, this is Aaron Hernandez's phone, not Alexander Bradley's. Is there any question he's in that car? The defense would have you to believe he's still out up near Club Cure, hanging out, walking around with people in the W Hotel. Really? Is that what the evidence shows? No. He's at 47 Newberry Street, the address of Brooke Wilcox. And guess what happens then? You now know, and it will be a common pattern that you'll see in this case. Aaron Hernandez's phone goes dark. Off network. Consistent with being shut off or being out of battery, whatever it is, but the phone goes dark. And there's more evidence. Brooke Wilcox. You decide credibility. But wasn't Brooke Wilcox one of the most important witnesses in this case? Didn't you find Brooke Wilcox's testimony to make sense? Didn't Brooke Wilcox seem to come up with no axe to grind, with no dog in the fight? Yes, she knows Alexander Bradley. Yes, she has a child with Alexander Bradley. But did she seem like she was just going with what he said? Didn't she say things that were a little different than Alexander Bradley said? Brooke Wilcox. But think about what her testimony was. Again, pretending you never heard from Alexander Bradley. Brooke Wilcox, 5 o'clock in the morning, or thereabouts, suddenly Aaron Hernandez and Alexander Bradley show up at her house. Aaron Hernandez is pacing around. Alexander Bradley's acting nervous. Alexander Bradley says words to her to the effect of, that crazy MRFer just did some effed up shit. And then what happens? The internet search. Is Brooke Wilcox going to just make that up? Does Brooke Wilcox have any idea when she gives that statement that there can be a forensic download of the computer that can corroborate that? In fact, Brooke Wilcox thinks that the computer can never again have any data recovered because of the work she had done. But what does this show? This is corroboration. And guess what? It's a Chrome search. And I know this question was never allowed to be answered, but ladies and gentlemen, you're allowed to use your common sense, your life experience.
Overruled.
You're allowed to use your common sense, your life experience. You don't need to be a computer nerd to know this. Everybody uses the same browser. You get used to it. I'm a dinosaur. I've been using Internet Explorer for years. Everyone uses a certain browser, ladies and gentlemen. So doesn't it make sense that Brooke Wilcox said the same thing to you? I always use Internet Explorer. It was only after my computer was broken that I ended up using Chrome. Who's using Chrome at 7:15 in the morning? Aaron Hernandez, that's who. And that corroborates Brooke Wilcox's testimony. And what about what happens next? A familiar face, ladies and gentlemen, Tanya Cummings Singleton, the closest, most trusted relative of Aaron Hernandez. Suddenly, she shows up in her kitchen, whispering with Aaron Hernandez. And you have a phone call, 9 minutes long. Again, Aaron Hernandez is clever in this part, ladies and gentlemen. He actually uses Alexander Bradley's phone to make the call. 9 minutes to Tanya Cummings Singleton. You really think Alexander Bradley's going to be talking to Tanya Cummings Singleton?
Arguing facts, not in evidence.
And welcome back. We just had another objection in the middle of Mr. Hagan's not cross-examination, his closing arguments. Attorney Jose Baez presented an objection for arguing facts, not in evidence. And now this is something that you tend to see at times during closing arguments, as much as attorneys attempt not to make objections during closing arguments. There are times where you do have to make the objection of arguing facts, not in evidence. Now, Charo, you see that Mr. Baez made an objection for arguing facts, not in evidence. What does that say to you? What do you think is happening here?
I think what's happening is the prosecutor is putting on a great closing argument, and he's using words like, you know, jurors, you must use your life experience. You know, you have to take your own feelings and use your own common sense. Where Baez is saying, listen, objection. You know, this isn't, he's throwing, again, he used the word himself, a red herring. The prosecution said Baez is using a red herring, and what Baez is doing is throwing the red herring in here and saying, don't listen to what the prosecution's saying.
Right. And so essentially, but what happens though, when you have your closing arguments, that's exactly what they are. They're just arguments. So you can't really say whatever you want to say. Whatever what you're saying during your arguments has to have some, I guess, relevance to what's going on within the trial. But when you're arguing facts, not in evidence, that means that you're arguing something that was not presented or admitted during trial. And so we'll see what happens when the judge comes back as to whether or not he'll have to, I guess, strike what he was saying during his closing arguments. But we usually find that that doesn't happen much.
It's a very rare. It's a rare thing to happen during a closing argument for someone to be stricken.
Right.
However, if at this point he was bringing in the aunt and conversations that was happening, and if this wasn't brought in to the trial and started conversations of it, it can be stricken.
Right, right. I agree with you. Now, you have here that I'm going to refer to Prosecutor Hagan's closing arguments a little bit. So he started off by saying, well, in my opinion, we know that this is a circumstantial evidence case. So essentially what we have with circumstantial evidence is that there's not one thing that's particularly tying Aaron Hernandez to the murders, but we have little evidence that you take. And I remember something that Heather said to me previously when I was on. She said, you know, it's like a string pearl necklace, and you want to just put in your pearls, and then at the end of the day, you're going to have a nice necklace. And I think that's essentially what the prosecution is doing here. They're bringing in all the little bits of evidence that that were admitted during the trial, whether it was testimonial evidence or the gun and the bullets that were found at the scene of the crime, and they're talking about it, and they're bringing in little bits of circumstantial evidence to overcome their burden of reasonable doubt. So how do you think that they're doing?
First of all, that's a great analogy. The pearl necklace is a great analogy.
It is.
And they're doing a great job. I mean, from the beads in the hair to the phone going dark, you know, and going step and step and step.
Right.
The 9 minutes, and could he down 2 drinks during 9 minutes?
Exactly.
It's all circumstantial, but the prosecutor's doing a great job. He's forming a gorgeous pearl necklace. That's what he's doing.
And I think you're right, and we're going to hear some more because we're back in the courtroom.
Thank you.
Here was a very interesting part of Jack Fox's testimony, ladies and gentlemen. Remember, he told you about a conversation he had where he learned that the defendant, Aaron Hernandez, wanted to buy the car because, quote, he liked it so much. Jack Fox said he was there in August 4th. This is just a couple of weeks after the murder, and the Forerunner's not there. He wants to buy the car because he likes it so much. Really? It's in a garage collecting cobwebs, battery going dead. He likes it so much? No, that is a lie, ladies and gentlemen. That is a lie from the defendant to cover his tracks. And this isn't the biggest piece of evidence of all, again, without Alexander Bradley telling you anything about the murders on July 15, 2012. What happens in February of 2013? The most devastating evidence of all against the defendant, Aaron Hernandez, for the murders. Think about it. 6 months has gone by. The police aren't on to him. But you know from Jeff London, he's getting more and more paranoid, isn't he? He's calling him the feds, those types of things. He's paranoid. There's only one person who can unleash that secret and hold him accountable for what he did in July. That one person is Alexander Bradley. And you learned, and again, this is Alexander Bradley, what he would testify to in his Florida shooting, that the night before February 13th, 2013, the night before, that's that interaction. Do you remember that testimony? When Alexander Bradley tells you, Aaron Hernandez, those guys are looking at me, it's funny, they must be cops. Alexander Bradley turns to him, well, if they are cops, it's probably because of the effed up stuff he did up in Boston. And Aaron Hernandez gave him a look. And that, ladies and gentlemen, is exactly when Aaron Hernandez decided Alexander Bradley could no longer be trusted. And talk about evidence that he committed the murders. The one eyewitness basically tells you, hey, by the way, I still know that thing. And what happens 24 hours later? You know what happens 24 hours later. But before we even get to what happens 24 hours later, what happens at midnight the next day? You saw the cell phone records for Aaron Hernandez from down in Florida, the 203 number. His phone, once again, goes dark at midnight. Off network. Completely off network until about 7 in the morning. Isn't that interesting? Again, your common sense, your life experience. Who goes out to a club nowadays without your cell phone? How many times have each and every one of you life experiences when your cell phone's out of juice, you'll stop at a convenience store to get a car charger if you have to. You'll borrow someone's charger. Aaron Hernandez just goes without a phone the entire night that he goes out clubbing with his friends? Seriously? 24 hours after making that comment, Alexander Bradley ends up with a bullet in his head, right between his eyes. 24 hours after making the comment to him, a bullet in his head, right between his eyes. I know this picture is disturbing. I don't of Alexander Bradley in the face in Florida comes not only from Alexander Bradley, does it? Mr. Baez made fun of them, all the people from Belglade. Sometimes, ladies and gentlemen, witnesses are so bad, they're actually good. And that's what those Belglade witnesses were like, weren't they? Belglade, it's obviously known for producing professional football players. Probably something in the water as well that gives people convenient amnesia, doesn't it? Isn't it interesting, ladies and gentlemen? You heard evidence from all of the people who testified from Belglade. You learned that they all testified in the grand jury. Not one of them needed immunity in the grand jury. And the most important of those witnesses is Tyrone Crawford. Again, Mr. Baez makes him out to be, drugged out. He didn't say anything about being drugged out like that in the grand jury, did he? You heard his grand jury testimony read to him, or he read it to Mr. Lee back and forth. That comes in for all purposes. That is evidence. And what did he say back in 2014 in the grand jury? Didn't Tyrone Crawford completely corroborate everything Alexander Bradley told you about the night of the shooting? The only difference really is that he puts this mysterious fifth figure in the car, some guy named Soldier. That fifth figure may account for the fifth bill or the fifth entrance fee to get up to the next level. But whether or not that's true, that's up to you based on the evidence. But what did he tell you? He told you the second night, 2 nights at Tootsie's, the second night it's only the small group of them. And it's Aaron Hernandez, it's Jarrell Pierre, JPD, driving. He gives the exact seating position that Alexander Bradley gave you. What does that mean? And then again, he comes up here, the fake amnesia, doesn't remember anything, has to have it read to him. If anything, again, he was so bad, he was good. Wasn't it obvious he was just saying he didn't remember anything so he wouldn't be a snitch? Wasn't that obvious? Your common sense, your life experience. Oscar Hernandez, again, had to be immunized. Kind of just laid out the scene. He wasn't out with him that night, but wasn't it interesting that he didn't testify or remember anything about a gun? He had to be, again, impeached, or actually his grand jury testimony had to be read in, that he did in fact bring a gun to Deontay Thompson in the hotel. That corroborates Alexander Bradley. That puts at least one gun, a semi-automatic, in the mix. One of the guns that could have been used to shoot Alexander Bradley in the face. Deontay Thompson, again, he conveniently left out the gun, but other than that, just background. But then there's this JPD, Jarrell Pierre. Isn't it interesting how Mr. Baez turned that around in his closing? He makes it seem as if these are just random friends of Deontay Thompson, no connection to him, and they must be the ones who shot Alexander Bradley. Really? Alexander Bradley identifies Jarrell Pierre as the driver of the car. Alexander Bradley didn't even know his name. You heard him. He said JP, JD, something like that. Doesn't even know his name. And he identifies him as the driver of the car. And think about the corroboration of that. JPD, who again had very interesting amnesia, didn't he? He doesn't remember a thing. He doesn't even remember when he got shot. That's believable. JPD doesn't even remember what his phone number was back then. But we proved what his phone number was in this case, didn't we? That 404 number. And think about the cell records that you received for that 404 number. It completely tracks the night that Bradley was shot. It puts him at the hotel in West Palm Beach. It puts him at Tootsie's, leaving Tootsie's at 5, coming up the highway. And then the most interesting cell tower hit happens at about 6:45, I think, if my memory serves me correctly. And where does that tower hit? Right in between the scene where Alexander Bradley is shot and the West Palm Beach Hotel. And then another interesting piece of evidence from the cell towers. When finally the defendant, Aaron Hernandez's cell towers, pop back on, when he comes back online at about 7-something in the morning, guess who's at the same tower as him? Jarrell Pierre, JPD. And again, the defense would have you believe that JPD is just a friend of Deontay's. Really? Look at this. You have the phone records from Aaron Hernandez, his cell phone. Contact, JPD. They seem to be pretty friendly, don't they? From March 30th, 2013 until May 31st, 2013, 70 text messages between them. 70 text messages. And Jarrell Pierre doesn't seem to have any problem remembering when he was shot in these text messages. He's talking about it to Aaron Hernandez. I was just shot 2 weeks ago. It's a friendly relationship. He's talking to Aaron Hernandez about his shoulder surgery, too. They're friendly. And these are just the text messages we have. Keep in mind, the cell phone that Aaron Hernandez had when he shot Alexander Bradley has never been found. It's lost. Similarly, the iPhone 4 that Aaron Hernandez had during the murders in July of 2012, that's also mysteriously lost, never to be found. What does that tell you? And then, if you need any more evidence that Aaron Hernandez shot Alexander Bradley down in Florida, how about the defendant's own words, his own hands? You probably didn't even notice when I put this up on the screen when we introduced the medical records of significance. The phone number for St. Mary's Medical Center. Why is that important? Because Alexander Bradley told you one of the first phone calls he made, you now know probably after the phone call to Robert Lindsay, one of the first phone calls he made when he woke up out of surgery and the detectives finally left him alone was to the man who just shot him, the man he thought was one of his best friends. And he told me he called him again and again and again. And that Aaron Hernandez hung up the phone on him. He would tell him, hey, I'm alive, I'm going to kill you. And the phone would be hung up. Look at this. 1, 2, 3, 4, 5. 5 phone calls from St. Mary's Hospital, Alexander Bradley, to Aaron Hernandez. And Aaron Hernandez wants you to believe this is his best friend. Some random drug dealers from Florida shoot your best friend in the face, and you just fly off to do your shoot. You fly off to do your muscle milk thing. You fly off. You don't do anything. You hang up on your best friend? No, you hang up because you're shocked. You thought you killed him. He called you and told you he was alive. That's why these are hang-ups. And what's important about these phone calls from Aaron Hernandez that show his lies? What about what happens next? What about the phone calls and the text messages with Aaron Hernandez and Brooke Wilcox? Remember, they start on the 13th, the very day that Alexander Bradley is shot. When Aaron Hernandez thinks Alexander Bradley is dead, he's calling Brooke, and he's setting up his alibi. You heard it. He's playing Mickey the Dunce. Oh, Brooke, where's Alex? I don't know where he is. Jeez, I got to get on this plane. I think he went off with some girl or something. I don't know where he is. He knew exactly where he was. He thought he was dead. He was setting up his alibi. But think about it. These text messages, these phone calls between Brooke and Aaron, they go on. They go on to a point where it goes into the 16th of July. Clearly, at some point, Aaron Hernandez knows from the phone calls he's gotten from Alexander Bradley that he just saw in the hospital records. He knows Alexander Bradley's alive and out of hospital. Does he ever say to Brooke, hey, I did finally get in touch with Alex. Someone shot him in the face and he's down at the hospital? No, he doesn't do that. Why? Because he's still setting up an alibi. Even now he knows he hasn't succeeded. He didn't kill Alexander Bradley. Alexander Bradley's going to survive. He still thinks Alexander Bradley is going to stick to the street code. He's hoping Alexander Bradley is just going to work it out and not say who shot him. So he's setting up his alibi with Brooke Wilcox. Isn't that pretty compelling evidence, ladies and gentlemen? Right from his own mouth, from his own fingers dialing the phone or texting. Is there really any doubt who shot Alexander Bradley in the face and why he shot him in the face? And then there's Shayana Jenkins Hernandez. I'm not going to spend a lot of time on this, but I've put her in a category of another witness who's so bad she was good, wasn't she? Shayana Jenkins Hernandez, who actually took the stand and told you, here is a college-educated, incredibly articulate, clearly intelligent woman who tells you she asks no questions. She knows her role. She cooks and she cleans. Did we do a time warp back to the 1950s? Seriously? There's another role you now know that Shayana Jenkins has from her testimony. She covers for Aaron Hernandez and the violent deeds that he committed in this case. She tells you she doesn't even know he was in Costa Rica. She's 5 months pregnant with their first child. They've moved in together, and she wants you to believe she has no idea he's in Costa Rica. She doesn't even remember she's in Florida, doesn't remember a phone call at 2:37 in the morning. Didn't talk about any of the phone calls they had earlier that night that were over 2 minutes. Oh, but that's right, she doesn't ask any questions, does she? But does that make sense? She doesn't ask any questions, but yet she can give somebody a look and they know what it's about. She saw a gun in the house. I remember her testimony on the gun. At first, she's outraged. She has a child on the way. Doesn't want to, or at that point, I think the child had been born. Doesn't want a gun in the house. But then the next answer, she's saying, well, a gun's not a big deal because, you can use it for protection. Really? Did any of her testimony make sense? Wasn't she, again, the witness was so bad, she was good, she so clearly was trying to cover for Aaron Hernandez? What about the tattoos? She wants you to believe that something that's permanently on her hip, presumably for the rest of her life, she has no idea what it says? It's a love poem that she picked out for the defendant and her, and she doesn't know what's on her hip? You believe that? And as if it couldn't have gotten worse, what about the whopper of a lie that she told at the end of her testimony, ladies and gentlemen? When she actually is trying to give him an alibi for the time of the murders. On July 16th, 2012, I remember that date. Yes, I definitely remember that date. I don't remember anything else, and I don't ask any questions, but I remember that date, and I know we spent the night in a hotel in Plainville. Really? Don't this phone records clearly show that Aaron Hernandez is still in Hartford, Connecticut on the 16th until about 7 o'clock at night? Doesn't his phone stay dead until it pops back up on the 19th of July, and he's still down in Bristol? Those phone records prove that that was a lie. And what about what Shayana Jenkins Hernandez told you about Alexander Bradley's shooting? Seriously? Does this strain credibility or what? She says he's one of Aaron's best friends. She gives us that, right? Or gives you that. But he all of a sudden disappears. Aaron Hernandez never says a word to her about it. Never says a word to her about him being shot in the face. She learns from the street. And then, I may have had a conversation with him, but I don't really remember what he said. Well, yeah, he told me he was with him, but I don't mean with him when he got shot. I mean generally with him. Seriously? Does any of that testimony make sense? And then, as if you needed more evidence, and this is, again, without Alexander Bradley uttering a word to you from that stand about the murders from 2012, the tattoos, something else that Mr. Baez didn't really say anything about other than we're leaping to conclusions. The tattoos. Think about it. 6 months after the murders, 1.5 months after Bradley's shot. Remember, the date of these tattoos is about March 30th, 2013. What does Aaron Hernandez do? He goes to a tattoo artist and gets this. The cylinder of a revolver with 5 bullets and 1 empty chamber. Random? Doesn't mean anything? Why on earth would somebody ask for 1 chamber to be empty? What possible explanation can you possibly think of for that tattoo? And Mr. Baez in cross-examination, oh, Rihanna has a tattoo, and someone else has a tattoo. Any tattoos with just 5 bullets and 1 empty cylinder? Especially when you now know, ladies and gentlemen, that 5 is a very important number. That Michael Haig tells you that 5 shots at least were fired in that car. That's the only evidence he knows is 5 shots. You later learn from Alexander Bradley 5 shots. 5 is very important. 5 shots. 5 injuries to those deceased victims, Mr. Furtado, Mr. D'Abreu. You think it's random that the defendant chose 5 bullets in that gun with 1 empty cylinder? Really? And what's right above that? The words, God forgives. That is not random. That is not art. That is evidence. That is consciousness of guilt. And I would go so far, ladies and gentlemen, that is a confession to what he had done.
Overruled.
That's what the murder weapon looks like with 5 bullets in it. It's pretty close, isn't it, ladies and gentlemen? Can't you make a reasonable inference that when Aaron Hernandez has his tattoo put on, whether he's memorializing it, getting a trophy, or whatever, why he's doing it, asking for forgiveness, whatever it is, look at that. Doesn't that look the same? Isn't he indicating what he saw in that gun, either before he fired it or after he fired it? That is not random, ladies and gentlemen. That is evidence. That is a statement of guilt. And Mr. Baez may have made an issue about the cylinder being in the wrong way. This is a defendant who you learned his car ran out of gas and he called technicians. Do you really think there was an issue as to whether or not he may have had the cylinder the wrong way? But he not only admitted and had consciousness of guilt and confessed to the murders in 2012 through those tattoos, he's admitting to doing something else too, isn't he? The very same tattoo day, that very same session, what does he get? A semi-automatic pointing right at your face. And remember, David Nelson, the tattoo artist, said he wanted it pointing, like looking straight ahead, as if it's coming at your face. And 1 smoking shell casing and a smoking gun. What does that remind you of, ladies and gentlemen? Something that may have happened about a month and a half prior. Alexander Bradley shot right between the eyes. When he woke up, what did he tell you? First thing I saw, the barrel of the gun right in my face before I was shot. 1 shell casing on the ground. God forgives. That's a confession. That's conscious of guilt. Meaning of the tattoos? You've seen the pictures. We don't have to go through them. How many of those tattoos were dedicated to his father, who was obviously very special to him? All over his body, tattoos that mean things. Sayings that are important to him. Sayings of his father. You can go through the pictures, and almost every single tattoo, you're probably going to be able to figure out the special meaning based upon the evidence you've heard. Again, Shanna Jenkins Hernandez, oh, I don't know, some mean something, some don't. Really? Don't take my word for it. Take his word for it. They all got a lot of meaning. No, Miss Jenkins Hernandez, not some of them occasionally have some meaning. All of them have a lot of meaning. They all have a lot of meaning. And guess what? Those gun tattoos, they had a lot of meaning too. They had a lot of meaning to the things he was admitting that he did through those tattoos. Now, ladies and gentlemen, that is the case. Think about it. What I just went through for the past, I don't know how long I've been speaking, but that was the evidence without Alexander Bradley. Without him telling you a thing about what happened in July of 2012. You can convict the car. You can link the defendant to the car. You can link the defendant to the murder weapon. You can link the defendant to an interaction with the victims. He fits a description of the shooter by the closest eyewitness. You can place him at the scene of the crime, fleeing in the SUV, both through the cell records and from the video. He disposes of evidence, the cell phone, the murder weapon, the car. He tries to kill the only eyewitness to the crime, and there's a tattoo confession. If that was the entire case that you heard, and I stood up in front of you, couldn't I stand here with a straight face and tell you, you should convict Aaron Hernandez because the evidence proves beyond a reasonable doubt that he did this crime? Couldn't I? Yes, I could. But you have Alexander Bradley. Even though you don't necessarily need him, you have him. So let's talk about Alexander Bradley, ladies and gentlemen. I'm not going to spend a lot of time. You saw him on that witness stand for 3 straight days. You saw him subject to cross-examination from a skilled defense attorney. You have your God-given common sense, your life experience. You know when people are telling the truth. You know when they're not. I'll just give you some helpful hints as you evaluate Mr. Bradley's testimony. Think about what he said, the circumstances of what he said, how he said it, and is it corroborated through independent sources. Just very quickly on a couple of things with Mr. Bradley, I'm going to give you another statement that may help. Good faith, inconsistencies, and mistakes are the hallmark of credibility, both of a witness and of the investigation. But what do I mean by that? What I mean by that is, think about it. When everything fits too nicely, when a bunch of people say exactly the same thing, doesn't that make you a little suspicious? Don't you know enough about human nature that when everything is just perfect, everyone says the same things? It almost fits into one of Mr. Baez's conspiracy theories. Instead, don't you know from your own life experience that not everyone sees things the same way? You've heard from Justice Locke in the middle of the trial. You'll hear from him again at the end when he gives an instruction on identification, that human beings aren't video recorders. And think about it. Mr. Bradley said this during his testimony. Mr. Baez brought it up when he said, you can be truthful but not accurate. Mr. Baez makes fun of that, but that's actually a pretty important thing to think about. And we had an incredible illustration of it in the middle of the trial, if you think about it, completely unscripted. Remember the testimony of Mr. Mingle and Mr. Riddle? Again, I don't think any side would contest that they were being forthright and truthful in what they saw. If anything, they were more helpful to the defense because Mr. Bradley told me he didn't see anything. But you probably liked the two of them. They seemed earnest and forthright. But did you hear what they said when they were asked if you saw any bleeding on Mr. Bradley? Mr. Mingle said he was barely bleeding at all. Mr. Riddle said he was bleeding profusely. Is there any question that they were there? Of course not. They were both there. Is there any sense that either one of them is lying? Of course not. It's just not the way human minds work. You could probably think of 100 examples in your daily lives. You could think of multiple examples in this trial. Who remembers what day we went on The View? Who remembers what tie and suit Mr. Byers was wearing when he did his opening? Who remembers what day Judge Locke gave his John Adams speech? Now, some of you may have those minds, and maybe you'll get all of my quiz questions right. But there'll be a number of you who will get them wrong. That doesn't mean you weren't here. That doesn't mean you're lying. It just shows the way human minds work. So when you evaluate Alexander Bradley's testimony, think about the things that he got wrong, because I suggest to you that that's more indicative of his credibility than anything else. And more than anything, think about what Alexander Bradley told you about the murder weapon. Now think about it. Again, it's all how the circumstances of the statement. He knew that the murder weapon had allegedly been recovered. You heard that from Burke Wilcox, you heard that from him, he's seen the news, he said that's not the murder weapon. If you believe Mr. Baez, he keeps calling this the deal of the century. What's the deal of the century? Alexander Bradley was not charged with this crime. He was not held as a suspect in this crime. He was brought up as a witness. The police didn't even know he was the driver. He was brought up as a witness. He was only in custody because he refused to come up. And he knows, again, Mr. Baez's theory that he's supposed to make us happy or make the prosecution happy. Why wouldn't he, if he were really lying, if he were really the killer, why wouldn't he say, oh yeah, Aaron must have taken a gun to his cousin's house and must have gotten to that woman that way? He'd make something up. No, Alexander Bradley stuck to what he believed. He was mistaken. We know the murder weapon wasn't thrown out the window. But doesn't that prove that he's being forthright and honest? Doesn't that prove that the detectives and prosecutors didn't coach him and tell him what to say? Because Alexander Bradley would have every motive in the world to say, oh, yeah, you know what? Yeah, I guess I didn't see the murder weapon thrown out the window. But he doesn't do that. The same thing with seeing the victims cross the street. Keep in mind, Alexander Bradley tells you Aaron Hernandez thought they crossed the street as well. That's where he first made him look over. But he tells you, yeah, it looked like them. He's wrong. But again, doesn't that speak volumes? The detectives didn't try to coach him. Prosecutors didn't coach him. He's never changed that story. So there are minor inconsistencies that make him credible. And another thing about Alexander Bradley, didn't he tell you the good, the bad, the ugly? Did he ever seem like he was trying to gild the lily, or he was trying to keep facts from you, or do anything like that? Did he seem like he was trying to hold back? If anything, at times, didn't Alexander Bradley almost seem like you could call him honest to a fault? And what do I mean by that? When I asked him, were you the same Alexander Bradley who was convicted of dealing marijuana back in whatever year? Oh no, that was cocaine. Mr. Baez asked him, wouldn't you call yourself lucky the fact that you haven't been caught more for drug dealing? He said, yeah, I guess I would. When Mr. Baez asked him, isn't drug dealing a violent business sometimes? He said it can be. Did he ever try to hide those facts? The text messages. How easy would it have been for Alexander Bradley to say, you know, when I'm referencing whatever the guns were that he had, a Mac 11, Mac 9, I was just trying to make him scared. I didn't really have the guns. What did he say when he was asked about it? Yeah, I had those guns. Yeah, I had a bulletproof vest. Again, are these the actions of somebody who's lying? Are these the actions of someone who's trying to curry favor to get the deal of the century? Or are these the statements and actions of somebody who actually told you the truth on a stand? That's up to you to decide. But think about that when you evaluate Alexander Bradley's credibility. And then we get to the independent corroboration of Alexander Bradley. How much independent corroboration is there? There is a ton. The Cure and Tufts video. I know you've watched this a number of times during a trial, but look at Aaron Hernandez's expressions. Right here, coming up. Right there. And what is Alexander Bradley doing? He's doing exactly what he testified to. He's trying to calm him down when they leave 9 minutes after this incident in the club. He's trying to calm him down. Aaron Hernandez is the aggressive one. And then out on the sidewalk, who's the angered one and who's the peacemaker? Look at him. He's throwing his hands down at Hernandez. Alexander Bradley. Hey, you're going to see a lot of this from Alexander Bradley, too. Arms outstretched. And Mr. Baez says we're just asking you to speculate what's being said. No, we're not asking you to speculate. Alexander Bradley told you what's being said. He told you that he's saying to him, listen, you're a professional athlete. You have to stop getting so mad at things. People aren't trying to test you. You got to mellow out. And you can almost see the words being said. Look at Alexander Bradley right now. Look, you got to stop doing this. You're a professional athlete. And look at Aaron Hernandez. What is his body posture telling you? He's got his hands on his hips. Look at him right now. He's going like this. That's corroboration of Alexander Bradley. If you do nothing else, when you go back in that jury room, at some point, watch this video from the beginning to the end and watch the expressions. The Tufts video. Ugo Ojimba, we've already talked about that, completely corroborates Alexander Bradley. Very quickly on Ugo Ojimba, the defense wants you to believe that Ugo puts Aaron Hernandez up by the W at 2:30. You heard Ugo's testimony. He said he wasn't sure of the time, and the one key factor for him is he said, I know when I saw him, he was with the same guy he was standing with, so that's Alexander Bradley, so that should tell you a lot. But also, what caught my attention is he was walking in a different direction from where I saw the people I later learned to be the victims. So that proves it didn't happen at 2:30. Mercedes Sanchez and Aquilino Freire, when Alexander Bradley gives his statement, when he says those terrible words that were stated right before the murder shots were fired, when he says, yo, what's up now, the N-word, does Alexander Bradley have any idea that Mercedes Sanchez and Aquilino Freire are going to say the exact same thing? He doesn't even know them, but they corroborate that. Michael Haig, when Alexander Bradley comes into the grand jury, and we went over this to the point where you're probably sick of it, but Alexander Bradley, nor the police detectives, nor anyone involved had any idea what significance 5 shots had. The tattoo artist hadn't been found. There was nothing at all. Alexander Bradley said 5 shots in the grand jury. He initially said, well, maybe 6, because I know I heard the clicking. Then he said, well, 5 or 6, and then he stuck to his memory of 5. No one coached him on that. And the corroboration from Michael Haig is 5 shots he knows were fired. At least 5 shots. He can't say whether or not there were more, but 5 shots is the one thing there's evidence of. Cell towers, we've already gone over that. That completely corroborates Alexander Bradley, not only for the Boston murders, but for Florida. Brooke Wilcox, and this is something I just want to spend a little bit of time on. Again, this goes towards credibility. The defense would probably argue, if they had a chance to get up now and say, Brooke Wilcox, well, she's just going to say what her boyfriend says. Remember, Alexander Bradley says, when I came to see Brooke, I told her that idiot or that crazy person just did some effed up stuff. He just shot 2 people in Boston. That's not what Brooke said. Brooke said something different. Again, that's one of those things that shows credibility. It's a minor inconsistency, but it's important. The computer search, that corroborates what Bradley said. Phone records corroborate what Bradley said. Tanya Singleton, the fact Alexander Bradley told you that, the defendant told him, I'm going to have Tanya clean that car and hide it. That car was cleaned really well on the inside and it was hidden. Tanya Singleton, although she's deceased, corroborated Alexander Bradley's testimony. Jack Fox, we've already gone over that. He corroborates Alexander Bradley. Jeff London corroborates that Aaron Hernandez, prior to 2012, would get upset at clubs. He had arguments with people in clubs. He testified that afterwards he started to do things like get paranoid as far as calling the Fed. Jeff London corroborates Alexander Bradley. Shanna Jenkins Hernandez unintentionally corroborates Alexander Bradley because she too sees a gun at their home at North Attleboro. The Belgrade group, we've already gone over those people with all the lack of memory. They corroborate Alexander Bradley. The tattoos. Alexander Bradley has no idea Aaron Hernandez is going to get those tattoo confessions, but he does. And that corroborates Alexander Bradley's 5 shots. It corroborates the fact he was shot. And then the text messages between Mr. Hernandez and Mr. Bradley. I'm not going to spend a lot of time. I know you've been listening for a while, but wasn't the case in many ways over the moment you listened to Alexander Bradley read those text messages back and forth? Wasn't there something about those text messages, not only so much of what was said, but what wasn't said in those text messages, that not only spoke to Alexander Bradley's credibility, he never wavered. You shot me. You know what you did. You're going to pay. Over and over again, I know what the car looked like. They have records. They can prove this. I'm not going to the police. It's not what I do. Over and over again, Alexander Bradley being completely consistent with what he's always said. And what about Aaron Hernandez? Does he ever in those text messages, again, explain anything? Like, why didn't you come to the hospital when I got shot? Why doesn't Aaron Hernandez ever say anything about the people who really shot him? Mr. Baez throws out this statement, oh, Alexander Bradley's mad at Aaron Hernandez because Aaron introduced him to the people who shot him? What evidence is there of that? What evidence? Where in the evidence did you see that? These text messages were devastating because they corroborate Alexander Bradley and they show Aaron Hernandez and what he didn't say. And what about this text? He calls him AA. And you may have again thought it wasn't a big part of the case. But remember Alexander Bradley in cross-examination from Mr. Baez? Mr. Baez was saying, oh, well, AA, it must just be because the 2 A's before your first name, and back and forth between he and Bradley. And then Bradley eventually said, well, all I can tell you is nobody called him AA before the murder. And then he wanted to be called AA after the murder. But guess what? Remember the stipulation that was put in towards the end of the case? And remember my questions of his very best friend from home, Ryan McDonald, who's known him practically his whole life? My questions of Shanna Jenkins Hernandez? They've never heard of him referred to as AA. And that corroborates what Bradley said. But that stipulation, there was a person who heard him referred to as who referred to him as AA after the July 2012 murders. In 2014, I think the evidence was. The defense arguments, and I just want to be very clear on this. The defense, as Judge Locke told you and will tell you again, the defense has absolutely no burden in this case. They don't have to prove or disprove a thing. So what I'm going to talk about now in no way think that I'm suggesting they have to prove a thing, but I do think it's helpful to go through some of the things that Mr. Baez said in his opening statement is what the evidence would show, and it will also dovetail to a lot of what he just said in his closing. D'Abreu and Bradley recognized each other. Really? I would say the defense can be summed up in 2 words. Fertile imagination. And what do I mean by that? The most innocent gesture is suddenly turned into reasonable doubt, turned into grand conspiracy. Because Daniel D'Abreu, while he's standing in line, looks over and then looks down. To Mr. Baez, that's proof that Alexander Bradley and Daniel D'Abreu knew each other. Because Alexander Bradley goes like this as he's outside with Aaron Hernandez. He's pointing to Mr. D'Abreu. Really? Is that what the evidence shows at all? No. Bradley had issues with the Abreu. What part of the evidence suggests that to you? What part of the evidence, besides wild speculation from the defense attorney?
Counsel, may I see both?
And welcome back. I'm Stephanie Willis here on LawNewz. And if you see, we're here with another sidebar. It seems like we're back in trial again. But there's another sidebar with Judge Locke where he called up both attorneys to the stand. We don't know exactly what he's going to speak with them about. But I have Charo here with me today. And how do you think the prosecution's going? How do you think the prosecution's closing argument is going so far?
He's putting on a great story. He's working again with all circumstantial evidence, but he's embellishing the witness's testimony where he needs to. He's downplaying other witnesses where he needs to, and he's creating a very strong case in his closing argument, a case that wasn't so strong for the prosecution, that he's and he's going to have the last word now.
You know what? That's so true. Because I was just thinking about that during his closing arguments. I was thinking to myself that, with all of the complaining that we did throughout this trial, and I know that, some of our viewers online, they said the same thing, that we couldn't understand why they were calling so many witnesses, why it was so meticulous. But you see how he's essentially tying everything together right now. So he mentioned Brooke Wilcox, which is the mother to Alexander Bradley's daughter. And, I thought that it was very important that he brought her up due to the fact that it's important that Alexander Bradley's testimony has some corroboration. And I don't know if you saw that yesterday, but that was one of the things that they were arguing about during their jury instructions or the jury charges. So one of the things that has to be shown is that, I just heard that they're back in court. So we'll talk about that a little bit later.
Okay, perfect.
Thanks.
Just as far as what Mr. Baez just said in his closing, he said that the time frame doesn't make sense, that somehow the witnesses disprove the case. Is that really what the evidence shows? Think about what Mr. Antoine Salvador said and what that proves. Again, nothing was hidden from you. Mr. Salvador's statements essentially were given to you by Jamie Furtado. The timeline still fits. Andrew Wallace said 2:15. The defense suggests that the timeline is destroyed. That's not true. What else did the defense tell you? They told you that this whole investigation was a culture of deception. Is that what you think is from the evidence that you've heard in this case and the witnesses that you've heard? They told you all kinds of things about forensics. He told you a lot about forensics. This is not a forensics case. It's a drive-by shooting. Drive-by shootings don't leave the type of forensics that we're talking about here. Dr. Jamie Downs, I'm not going to spend a lot of time on him, but didn't his testimony, the credibility of it, go right out the window when he tells you, I only testify to the truth, and yet then he's drawing a picture of Sfero Furtado holding a gun. He says that that's the anatomical position, someone leaning out the window holding a gun. And what about when he was asked if that wasn't a graze wound on Mr. Frere's arm, would that change your opinion? Oh no, because I have a bunch of other 6 shots. I have multiple 6 shots. Was that credible at all? Ladies and gentlemen, you've heard the evidence. Do not be misled by unreasonable or imaginary doubt. Do not engage in the speculation, guesswork, conjecture, and the wild conspiracy theories that are put forth by Mr. Baez in his closing argument. Every little thing turns into something else. Alexander Bradley's engaged in a drug deal. Alexander Bradley's doing this. He's downstairs at Cure in a drug deal when the evidence doesn't support any of that. That is not reasonable doubt. That is unreasonable doubt. That is speculation, conjecture, and guesswork. Follow the evidence, ladies and gentlemen. The word verdict means to speak the truth. Speak the truth through your verdict. You know who committed this crime. The why will never make sense to you, but you know who committed this crime, not from what I tell you or Mr. Baez tells you, but from the evidence. The tattoos. permanently imprinted on his arm, permanently imprinted, God forgives. Right above and below, what is he asking God to forgive? The shooting of Alexander Bradley above, the murders of July 2012 below. God forgives. His statements, his words. That is a confession. But this is not a church, this is a court. What matters in this room is accountability. What matters in this room is a fair and just verdict based on the evidence and not based on wild speculation, conjecture, and conspiracy theories. It has been 5 years since Safira Furtado and Daniel D'Abreu were gunned down in cold blood. Their lives matter in this room as well. And what matters in this room is speaking the truth through your verdicts as to who killed those 2 men in cold blood. 5 long years. The time for hiding evidence is over. The time for trying to kill the one eyewitness who can hook you on this is over. The time for those wild conspiracy theories and speculation is over. The time for accountability is right now. His time is right now. Speak the truth through your verdicts and find him guilty.
All right, members of the jury, we're going to recess.
I'm here on LawNewz. We just finished with the prosecution's closing arguments. Judge Locke has declared a recess for the day, and I believe the jury members are going to lunch before they come back for their jury instructions. And jury instructions essentially is when Judge Locke is going to read the instructions to the jury as to how they will proceed forth back in the deliberation room. So, Chara, we're back.
Yes, we are.
So prosecution is finally finished with their closing arguments. I think that he did well towards the end, tying in everything together. He really just, I guess I want to say, he brought up Alexander Bradley, he brought up Brooke Wilcox, and I really liked how he tied in the video to show that Aaron Hernandez, excuse me, too many A's. Aaron Hernandez was the aggressor at the Cure nightclub. What did you think of that video?
Again, the prosecution keeps using words like wild speculation, your imagination, and it is all speculation. Although the body language does show, it shows there's no voices, nobody can hear what's being said. It shows, It shows Hernandez, in a position that he's holding his hips and his arms. But the prosecution wants you to believe because Bradley has his arms out and he's saying, come on, Aaron. Come on, Hernandez. Come on, Aaron. That the prosecution is allowing to paint this picture to the jury of what the story of what happened that night. And again, it's not. It's all circumstantial evidence.
Right. So it's open to the jury up for interpretation, especially since we don't know exactly what
we don't know what was said, what was done that night. It's all the picture. The prosecution did a great job painting this picture. Mm-hmm. He did a great job with the. If we looked at the trial in the last month, we said, "What is the prosecution? This is a terrible case." Prosecution today says, our witnesses were so bad that they were good.
Yeah,
they were
think that
so
that was a
bad
good point.
that they were good.
Right.
And with that, he ties it all together. He embellishes all their testimony, and he says, you have to go with your common sense. You have to go with life experience. You have to convict.
You know what, and that's so true, because one of the things that Prosecutor Hagan tied in on in this situation is the fact that we as humans, we make mistakes. So, and I think that he was referring to the testimony of Alexander Bradley, and other witnesses. We remember certain things differently than other people may. So I thought that he did a great job with tying in their life experiences and their common sense. Great. Great way to bring that up. So, another thing that I wanted to talk about is this braided beads. You know, we heard from McMaster that he saw somebody at the scene of the crime who essentially looked like a woman or somebody who had cornrows. Now, Prosecutor Hagan then came back and he did exactly what Jose Baez said that he was going to do. He referred to Alexander Hernandez's necklace that was at the scene of the crime, or not at the scene of the crime, but what he was wearing on that day. Do you think that he did a great job of explaining that? Or
the prosecution does, you know, in his tone and in his demeanor, is very convincing. And remember, you're dealing with lay people.
Right.
The only people the prosecution has to convince is the jury, and he's convincing. Was his argument the best argument? No, but he embellishes the situation to a point where I believe the jury will believe what he's saying, but how much of the jury instructions that the judge gives, that Judge Locke gives, will they be able to say, well, is this beyond a reasonable doubt? Could it be? Would it be?
It's a good point. That's a very, very good point. So now, since we're on recess right now from the Aaron Hernandez case, I'm going to talk a little bit about the Steve Jones case.
Oh, boy.
Now, oh boy is correct. For our viewers out there, the Steve Jones case is a case that occurred in Arizona. It happened on the campus of a college in Arizona. I think it was NAU. And essentially what happened in that case was there was an individual by the name, the defendant in this case by the name of Stephen Jones, and he shot some individuals. There was one person who died, and there were, I believe, who were injured as a result of his shooting, but that did not die as a result of the gunshots. Now, here we have someone who is claiming self-defense. Now, if you're familiar with the case at all, you'll know that Stephen Jones was with some colleagues. He was in a fraternity. They were passing by another frat house, I believe, where there was a party occurring. Now, one of his friends went up to the door, knocked at the door, and then they essentially came back out, and then there was like a scuffle. Now, what happens is, according to the opening statements by the prosecution, is that during the scuffle, Steve Jones was sucker punched. And then as a result of being sucker punched, he decided to go to his vehicle. Speculation as to how far away it was, but it was 90 to 150 feet away from where the actual scuffle occurred. Now, the defense in this case, they are claiming self-defense. Now, we know as attorneys that when you're claiming self-defense, it's one that has to be reasonable. And that's the same, laws vary throughout the states, but it's the same in Arizona, that there has to be a reasonable fear of your life. And you have to, the actions have to be reasonable. Now, in this case, Steve Jones was sucker punched. He was punched, but yet he decided to go from the scene to his vehicle, pick up a gun, and then come back. What do you think about that?
Well, from what I heard as well, he's going to claim he's been bullied. This isn't the first time. And when he got sucker punched, yes, he went back, but he never meant, it was just meant to scare them, so he wouldn't, he could have left. Right, listen, he could have let as much time as it took to go to the car. He could have gotten his car and just left.
Not only that, but if you were able to get to your car and you were so afraid, why not just leave?
Right. So that's going to be a major point and a major issue here. Why didn't he leave? And more will come out about that gun, from what I understand.
Exactly. So why didn't he leave? He had time to leave the scene, decide to pick up his gun, and then bring it back, and then, we're still making a claim of self-defense. Now, another thing that's probably going to come out is the statements against interest in this case. So what happened was when the police officers arrived, he said something to the fact that, I believe it was something like, it was all my fault. I'm the one who did something bad. Does that come in?
It may not. It depends on the statements of interest. It depends on how much time lapsed. The prosecution doesn't want. I believe that Steve Jones said, it's in self-defense. It's in self-defense, and the prosecution is going to object to this, saying he had too much time to think about it, and they're not going to want these statements in.
Right. Well, you know what? Let's go to a clip. We're gonna go to a clip. Oh, you know what? Actually, let's go to live trial. I believe that they are back in the room for the Stephen Jones case. And so
where are you
we're gonna
from?
go to
I'm
the
from Chandler,
victim. I
Arizona.
believe his name
All right.
is
And do you live here now in Flagstaff?
So,
I do.
We'll take
And
you
why is that? What are you doing?
to the live
I'm about to
case.
graduate in May, so I'm on my last semester here at NAU. All right. And if you could bring that mic close to you
yeah.
so we can hear you a little bit. You can move it.
Apologies.
You move it right up to your mouth. Yeah. And just
Better?
get used to pretending it's not even there.
Okay.
So how old are you right now?
I'm 22.
And you said you're graduating. What are you graduating in?
I have my bachelor's in business administration and finance with an emphasis in international business studies.
All right. That sounds pretty fancy. So are you going to work somewhere after this?
I plan to work in Scottsdale, yes.
All right. With whom?
I'm not sure yet. A financial firm, preferably.
All right. Well, good luck.
Thank you.
Nick, did you know Colin Brew?
I did.
And who was he to you?
My best friend.
All right. Did you also, were you a roommate of his as well at some point?
I was. We met freshman year in the dorms and had lived together ever since.
Were you part of the same fraternity as well?
I am.
And what was that fraternity?
Delta Chi.
Okay. Nick, I want to ask you about the night of the shooting, okay?
Okay.
Can we talk about that?
Sure.
Do you recall that being, and if you don't, just let us know, the evening of October 8th into the early morning hours of October 9th?
That is correct.
And this is 2015, right?
Correct.
Where did you live at that time?
We lived at 262 East Franklin Avenue in that apartment complex right off of Franklin.
Okay, and we've been seeing some visuals. You were here for that? Did
Correct.
you see some of that testimony? Okay.
Yes.
And we'll go back to that a little later, all right? Describe that complex area. Who lived there and how many people were there?
So each unit, I believe there's 8 units. Each unit has 3 people per unit, and there are 2 units with a courtyard section in between that separates them.
And it's been referred to, this area, as the courtyard.
Correct.
Is that why? Because there is an actual courtyard?
Because of the courtyard area in between the 2 buildings, yes.
Thank you. And so you lived in the building closest to Franklin Avenue?
Unit 1, yes.
Unit 1. And besides Colin, who else lived with you?
Michael Mullen.
Just the 3 of you?
Correct.
All right. And at that time, what year in school were you?
I was a junior. We all were at that time.
So how old were you?
I was 20 at the time.
And did you know the other people that lived across the courtyard in those other units?
Correct. Next door, I can't remember exactly their names, but we're a couple of friends of ours who are a part of the Sigma Chi fraternity. Across the way, we had friends, Nick Acevedo, Brandon Emerine, and Mitchell Highland.
Okay. And would you have parties out there in the courtyard with all these folks?
I have before, yes.
Okay.
Never hosted one, but there have been parties there.
All right. And it seems like almost a perfect location for a party. It's enclosed. There's a fence on one side of that courtyard area. Is that correct?
Yeah, you could say so.
All right. So that evening, let's go back then to that evening. It's October 8th. Is there a party going on that evening?
Correct. Yes, there was.
And what time did that start, approximately?
Approximately 10:30, 11, perhaps.
Do you remember what day of the week it was?
It was Thursday night.
Okay. And were you hosting the party, or was someone else hosting the party?
We were not hosting the party. It was in the opposite building, across the courtyard.
Across the courtyard area?
Correct.
In that same complex?
Caddy corner to our unit.
Understood. And how many people showed up for this party?
Approximately 20, 25 people.
Okay. Did you know all of them?
At the time in the building, I knew all of my friends except for a couple of females that I had not met before.
Okay. And was there alcohol present?
Yes, there was.
And did you consume any alcohol?
Yes, I did.
Today, do you recall how many drinks you had?
I was not counting at the night, no.
And was it beer? Was it something else?
Mostly beer, but I'm sure I had perhaps a couple shots.
Okay. Other people were there. Were they drinking?
Yes.
And any drugs that you had or saw being used?
No.
Okay. So at this party, was it what happened? People just drinking? Was there music?
Yeah, there was music. People were drinking, talking, laughing, having a good time. Typical party environment.
All right. At any point, did someone tell you to turn the music down, or you guys are being too loud?
Yes, less than an hour before the shooting, myself, I had personally spoke to 4 security guards, property security guards, on the street perpendicular to Franklin. I'm not sure the exact name. And I had spoke to them. They told me that we needed to turn the music down or they would inform the police. And so that's exactly what I did.
All right. Didn't want the police to show up, so you guys turned the music down?
Correct.
And what time of the night was this? Was this into the party a couple hours, or?
Yeah, this was approximately 40 minutes before the shooting, less than an hour, I'd say.
Okay.
So I guess that'd be around 12:30 or so, 1 o'clock maybe.
I'm going to ask you about some names, people that may have been there. Was Colin there?
Yes.
What about Nick Prado?
I do not recall, but I believe so.
What about Kyle Zantek?
Yes.
All right. After you turned the music down, did anything else happen during that party that caught your attention?
No.
So pretty uneventful that whole night?
Correct.
At some point, did you leave that party and go somewhere else?
When I heard Colin's voice, yes, I left that area.
All right, I want you to describe that. Where were you when you heard his voice?
So I was in the courtyard in between the 2 buildings. I was outside kind of monitoring, making sure people weren't coming in and people were leaving. Colin's voice, and so if you bring up the diagram, I can explain a little bit easier. I came around into the parking lot of the courtyard complex, across the grass, across the street, into that driveway of the Mountain View parking lot and dorm.
Okay. And what about Colin's voice caught your attention?
Well, he was the only voice I recognized, and since I said I lived with him for the past 3 years at the time, I heard his voice and I recognized that he was in a verbal argument with other individuals.
Okay. Now, were you part of any type of confrontation occurring in Franklin Avenue in the street?
No, I was not.
Do you recall anybody knocking on a door and you exiting that unit?
No, I do not.
So you were outside of the courtyard area in the parking lot when you heard Colin's voice?
No, in between the 2 buildings in the stone pathway, if you will. Not the parking lot, but adjacent to it.
All right. And did you investigate what was going on?
I did.
So where'd you go?
So at that point, like I said, I went into the parking lot of Courtyard, across the grass towards Franklin Avenue, across the street into the driveway that separates the Mountain View parking lot and the dorm.
And what did you see as you approached that direction?
At that point, I saw Colin talking to 3 individuals, well, yelling back and forth, 3 individuals and him, and they had proceeded to just yell at each other verbally and a lot of chest puffing, I guess, if you will.
Did you see anybody punching anybody?
No, I did not.
Anybody kicking anyone?
No.
Anything physical at all?
Nothing physical at all.
Did you see anyone with weapons at that point?
Not at that point.
Later on, did you see someone with a weapon?
I never did see the gun. I only saw the flashlight.
Okay. So did you approach that interaction?
I did.
And were you running, walking?
Jogging. Up until I reached, until I saw Colin fall, and at that point, I sprinted and jumped over the bushes that you had pointed out earlier on the scene.
Okay. And let's take this just a step at a time, Nick. I know
Okay.
it's, I know we want to talk about what happened, but let me just take it a step at a time with you. As you're walking up or jogging up, as you described, did you see anyone else in the area besides Colin and these 3 other individuals?
I did not, no.
Did you recognize these 3 other individuals?
I only recognized Colin.
Do you recall what Colin was wearing that night?
I don't recall.
Okay. Do you recall what anyone else was wearing of those 3 people you talked about?
I do not.
As you were jogging up, did you hear what was being discussed?
A lot of derogative terms. Would you like me to express them?
Sure.
It was a lot of "fuck you," "you guys need to leave," and then from their end, it was basically "you guys can't kick me out," blah blah blah, and just back and forth. A lot of cussing, calling each other more derogative terms.
At any point, did you hear someone say, "I'm going to kill you"?
I did not.
Or "I'm going to hurt you"?
I did not.
It was words to the effect of "get out of here"?
Yeah, and Fuck
then the
you,
profanity?
Profanity, yes.
Okay. As you got closer to what was going on, what did you see happen?
At that point, Colin was still talking to those three, or yelling with those three individuals. And I noticed, and I guess he noticed at the time, a flashlight coming from the Mountain View parking lot, which would be the west side. And at that point, he turned from talking to these three individuals looking south to that rocky area looking towards the parking lot, where I saw him fall in the rocks.
Did you see where Colin was standing before he turned to that location?
I believe he was on the driveway, and then I think he took a step over into the rocks, 2 steps maybe.
Okay, so he was on the pavement on that sidewalk that we've seen?
Correct.
And then he had to step over that curb to get to the rock section?
That would be correct.
And you said he fell. Describe what preceded that.
Well, I didn't hear the initial gunshots, and I saw him fall, and I wasn't sure why I didn't put the 2 and 2 together. So I didn't know what happened before that. He was yelling at those 3 individuals. He turned, took 2 steps maybe, and then collapsed in the rocks.
Okay. When you saw this, you described it as a flashlight. If you need to take a moment, just let us know, okay?
That's fine.
You described a flashlight coming from the direction of the parking lot?
That is correct.
Did you see who was holding it?
I did not recognize who it was because of the light.
Go ahead and take a drink, Nick. Describe how bright this light was compared to the lighting around.
I assume it was an LED light. It was quite bright. At the time, I thought it was like an NAU police officer or another officer who came to perhaps like break up the argument.
Okay. Did you hear anything that this person with the light said?
At one point, I think I heard stop.
Anything about a gun?
No.
When you saw Colin fall in the rocks, you said you didn't hear the gunshots?
Yeah, correct. Sorry.
Okay. Or you don't recall today?
Mm-hmm.
I don't want to, it's yes or no, sorry, just for the record.
No, I did not hear the gunshots.
Thank you. And then you described earlier that you jumped over this bush or hedge area.
Correct.
And why'd you do that?
To get to Colin.
Why?
Because I saw him fall.
Did you know at the time that he was shot?
I did not.
As you went to Colin's aid, what happened?
As I jumped over the bush, I was shot in my, well, first of all, I saw the flashlight turn to me. I was shot in my right arm, and at like a momentary second after that, I was shot in my left hip, and I fell from that jumping position into the pavement of the parking lot on my face.
Did you know at the time that you were being shot?
I didn't know. I didn't register it until afterwards, and then I realized when I saw a bunch of blood that I had been shot and we had been shot.
And I know it's difficult in a court setting. You know, we're breaking this down into second by second. How fast did this all happen?
It was very fast, perhaps less than a minute.
Did you see any interaction between Colin and this person with the flashlight that ended up shooting him?
No, I did not.
Did you see Colin lunge at him?
I did not see him lunge.
Did you see Colin, or did you hear Colin say anything to him?
I do not recall him saying anything.
Did Colin have any weapons?
No, he did not.
Did he have anything in his hands that you saw?
No.
And you described Colin taking a step or 2 forward before falling, is that correct?
Correct.
Once you noticed that you were shot, and did you have an opportunity to look over at Colin to see what was going on with him?
I did. At the point when I was shot, like I said before, I fell to my face, and at that point I rolled over to my back where my head was, I believe, facing the direction of Colin. So I tried to look over my shoulder and see, and at that point I saw he was unconscious in that rocky area between the rocks and the pavement of the parking lot.
Okay. Did you ever see him move or make any noise?
No, I did not.
After you rolled on your back and you saw what was going on, what do you recall happening after that?
After that, at the time, Nicholas Prado's girlfriend, Abby, came up and put pressure on my wounds, along with Nicholas Plecky and someone else who I didn't know at the time, whose name is Mikey. She also came up to help put pressure on my wounds.
Okay. You mentioned Nicholas Plecky. Was he a person that was at this party in the courtyard area?
Yes, he was.
You recall him being there?
I believe, yeah, yes.
And then you mentioned Abby Norcutt. This is Nicholas Prado's girlfriend at the time?
At the time, yes.
And was she also at the party?
I believe so.
And then you mentioned a third name, which is Mikey.
Correct.
Was she at the party?
I don't believe so. I believe she came out of Mountain View.
Okay. And they were attempting to assist you?
Correct.
What were they doing to help?
Nicholas Plecky had put pressure on my right arm. I believe Abby had put pressure on my left hip, and I think Mikey was putting pressure on the backside of my arm as well.
Just describe for the jury what you were feeling at that time.
At that time, I didn't feel any initial pain. I did feel like numbness in my hip, and I was unable to move my leg. And I was in a ton of shock, so I was yelling a lot of profanity.
Okay. Did you see what was going on with this person with the light who ended up shooting Colin and yourself? What was he doing?
I didn't see what he was doing, but there was a pause between when Colin and I were shot until I heard more gunshots.
Okay. How many gunshots do you recall hearing, if any, at this first moment when Colin was shot and you were shot?
Maybe 4 to 5.
All right. And then you said there's a pause?
There was a short pause, yes.
How long was that pause, if you know?
It felt like forever, but I think it was perhaps maybe 30 seconds, if that.
Okay. And were you moving your head around? Were you trying to see what was going on?
I was trying to, but I couldn't see the defendant at the time.
Was it difficult to move?
It was.
And these people you mentioned earlier, Nick Plecky, Abby Norcutt, Mikey, were they all with you during this entire time?
Until the police officers got there and the paramedics, and until they told them to relieve pressure from my wounds, they were there, I believe.
Okay.
Abby might have actually ran off, but I can't quite remember.
But you remember Mikey and Nick Plecky being there?
I remember Mikey was there definitely the whole time.
Someone want to... Spencer, can you find out where that is? Could we have that person go outside, please?
All right.
Just a second. Yeah. Go ahead. What was it? She with the media. She with the media? Is she with the media? All right, folks, I'm going to remind the media, you need to make sure that those disruptions are non-existent. Otherwise, I'll either start removing people or removing cameras. Go ahead, Mr. Barker.
Thank you. Nick, before the interruption, I think we were talking about Mikey and Nick Plecky being there with you during that time. You said this time between shots seemed like forever, and you gave an estimate. What did you hear before those shots, if anything?
I was yelling, call an ambulance. So I mainly heard myself yell, call an ambulance, call the police, call 911. Mikey laid on top of me at that point and said to be quiet, that he was still shooting. And I think I yelled at her to get off of me because it hurt. And that's what I recall.
Okay. And how many shots did you hear this second time?
Perhaps another 4, 5 shots.
Did you see where the shots were going, or did you see anybody falling at that point?
I did not, but I think they were going in the direction they were going originally.
Okay. That is toward Mountain View dorm area?
That would be east, yes.
West to east, okay.
Yeah.
From the parking lot?
Correct.
And after you heard these shots, what do you recall happening?
After the shots, I remember the police and the paramedics showed up maybe 2 minutes after. There was just a bunch of chaotic yelling. I was yelling. Mikey had still putting pressure on my wounds, and then I think it was either the police or the firemen got there first and put like a bandage or something on my wounds to try to stop the bleeding.
Okay. Do you recall seeing Colin at all after that?
I do. When I was put in the stretcher, I recall seeing him. I was yelling because no one had helped him. He was still laying in the rocks. And I remember as they put me in the stretcher, they turned me so I was going head first into the ambulance, which was away from Colin, so I could see him at that point in the rocks still.
So let me just back up a little bit, Nick, and ask you directly. At any point were you part of any kind of physical altercation?
No, I was not.
At any point were you running or attacking the defendant?
No, I was not.
Were you attacking anybody?
No.
When you were taken from that scene by the medics on scene, do you recall that transport to the hospital?
Yes.
Recall kind of what you were feeling at the time?
What I was feeling?
Yes.
Yes.
Did you know that you were shot in those two locations at that point?
At that point, yes. I told the paramedics that my wallet was in my back left pocket. I didn't know my blood type. My insurance card was in there. Where I was shot, they cut my pants off to get to my hip wound. And I remember yelling at them to go help Colin. And then I asked if he was deceased, and they confirmed that.
Okay. When you got to the hospital, what do you recall from that experience?
I recall laying in a hospital bed next to Nicholas Prado, and I think Zintek was on the far side of him. And there were curtains in between us, but I could hear his voice.
Okay, and this was this type of a kind of a trauma bay that you were in?
I believe so, yeah. I've never been in one before.
Okay, these weren't individual rooms then?
No, it was one long room just separated with curtains.
All right, and were you being treated by medical staff at that point?
I was.
And what were they doing to try to help you?
They had put bandages on my wounds, and I believe they had put me on an IV and some sort of pain medication, perhaps.
Okay. How long were you in the hospital?
2 days. I believe I got out on Sunday, the following Sunday, so Friday and Saturday.
What was the result of those shots to your body?
Well, muscle damage. I had a cracked pelvic bone on my left side, and then muscle spasms.
Okay.
Still.
Are you experiencing anything today from that experience?
Occasional muscle spasms.
Okay. Nick, you referenced the scan and the images before. Let's go to those now, okay?
Okay.
Okay. We're showing you what's been admitted as 316 now. And I'm going to let Mr. Shea navigate us here as I talk into the microphone. And I'm going to be in the way, so I'm going to come over here. All right, Nick, can you see that?
Yes.
Do you have a laser pointer up there?
I do not.
Go ahead.
All right, Nick. Can you describe what we're looking at here?
So that is the courtyard area that I referenced before in between the two building units.
Okay, and let's just do a 360 scan here. Do you recall where the party was at?
In that right unit. Sorry, that one there.
That one you're pointing to the right, that right?
Correct.
Number 5?
Correct.
Okay. And where was your unit?
If you keep going, my unit is caddy corner and this far unit over there.
Okay. The one at the very end?
Correct.
So if I'm facing this direction, we're looking at a fence and a couple of houses in the background. Which direction are we facing approximately?
That would be west.
And is this the parking lot that is adjacent to the courtyard area?
Correct.
So when you described hearing Colin's voice, where were you?
I was in front of the unit where the party was taking place, directly in front.
We go back to that then.
Yeah, if you scroll, I was standing like in front of the housing unit in that area right there.
Okay, right in the middle of the courtyard.
Correct.
So you heard Colin's voice, and then where did you go?
And then from where I was standing, I ran into the parking lot and then left across the grass into the street and across the street.
All right, let's take a different view. All right, from this location, it looks like we're looking at Franklin Avenue and also Mountain View Hall. Is that correct?
That's correct.
From the location of the parking lot.
Yes.
And let me specify the parking lot attached to the courtyard area. Correct?
Yes.
All right. Describe again where you went from here.
So I came from this direction and I ran across the grass that is here, like in between the cars, across the street into this driveway that is the entrance of Mountain View and the parking lot.
Okay. What are we looking at here, Nick?
So this is the driveway where I ran across from here at the parking lot. I ran across the street into this driveway that separates the dorm and the parking lot of Mountain View.
And as we scroll to the right here, are we looking now down that sidewalk area?
Correct.
Toward where Colin was?
Yes.
Can you point out where you saw Colin as you approached?
As I approached from this direction here, he was probably in this area, slowly walking with those three individuals in that direction. And at the time I saw him turn, he was right at the end of these bushes here.
At any point, did you see anyone surrounded by a group?
I did not.
Let me take a different view, and now I'm going to station number 2. Now, Nick, as we look at this, this police tape wasn't there when you were there, correct?
Correct.
And it wasn't light outside at the time, correct?
That is correct.
Even still, could you see what was going on in front of you as you're walking up that drive?
Yes, I could. Yes, I could.
And I think we can see there are some lights around here, correct?
That is correct.
In fact, there's a light right there, right at the corner of that parking lot.
Yes.
All right, what are we looking at here?
Colin.
Is that where you recall he fell?
Yes.
Nick, describe as you ran up where you were. You talked about jumping over a bush. Describe where you jumped.
So I came from this direction and I jumped diagonal over this bush to get to Colin.
And then you described earlier that you were shot at that point.
Yeah, while I was jumping.
And where did you land? Show the jury approximately where you remember landing.
I believe I landed right here.
And is that where you recall Nick Plecki, Mikey, and Abby Norcutt trying to help you?
Yes.
If you can remember, Nick, where was the person with that flashlight that you later identified as a gun?
When I had seen the light, he was probably right here in this parking stall.
That's the first time you saw him?
Well, I didn't see him. I just saw the light, but
Okay.
yes.
You recall if that light was pointed straight forward or up or down? Anything about that?
Once I saw Colin fall and I had ran and jumped to get to him in this direction, I saw the light just directly in my eyes at that point.
Okay, facing right at you?
Yeah, like right at me, yes.
So the light wasn't pointed at the ground at that point?
No, it wasn't. It was quite blinding, actually.
Now I imagine you've been camping or something like that where someone's shining a light at your face. Is it difficult to see?
Yes, it is.
And was that the situation you experienced that night?
Yes, it was.
At any point were you able to identify who the shooter was?
I think I identified him at the time as a male, 6 foot tall, white, dark hair. That's about all I could get out of it.
May I have a moment, Judge?
Sure.
Thanks, Nick. That's all I have.
All right, folks, let's go and take our second mid-morning recess. Please remember the admonition, 10 minutes.
Welcome back to the Law News Network, everybody. We're listening to the Stephen Jones murder trial out of Arizona, and the court is taking its mid-morning break, so we'll be back to them in a second. We're also monitoring a motions hearing in the Aaron Hernandez case that we'll go to in a second, but first we want to get to a little bit of analysis about what we've heard. Two important things going on this morning. We're listening to testimony from a victim in this university campus area shooting case, and we had closing arguments in the Hernandez case from Boston.
Two very interesting trials.
We're being competed here for our time and attention. We have two streams for those of you who want to watch the raw feeds coming in, but the Hernandez case is also in a break right now as well. So we have two big trials and they're both in a break right now. So let's talk about the Hernandez case, because people are really watching that with an incredible degree of interest, because the characters are interesting, the counsel is interesting, and it's still not really clear who actually pulled the trigger, at least in my mind and in a lot of other people's minds too.
I agree with you, Aaron. I agree to the fact that the last thing we just heard was the prosecution put on this grand show of all the circumstantial evidence that they have, and they were very convincing. However, the judge will give strict instructions to the jury, tell them they need to be impartial, and that's what they're doing right now in the courtroom. The defense and the prosecution want certain words in these jury instructions, which will be favorable to their positions. And by the time the jury goes back and deliberates, I don't know how strong the prosecution's case, beyond a reasonable doubt. It's a very high standard.
We're hearing from the courtroom that the jury instructions will take about an hour and a half. That's one of the longest stretches of jury instructions that I can remember ever even being discussed, let alone delivered.
That's a very long, an hour and a half. And could you imagine the jurors having to sit there for an hour and a half to instructions? I'm sure some of them will tune out after a while anyway.
Yeah, that's tough. So let's look through some of the instructions that they're going to read. One of them is this Bowden instruction, which basically is a Massachusetts standard that says, in essence, that the jury can consider botched police work, an investigation that is missing evidence, an investigation that could have perhaps found more evidence, an investigation that maybe could have, should have, would have found more evidence, or an investigation that could have, should have, would have, maybe could have involved more scientific testing. And that came out of, I think it was a mid-'80s or early '80s case where a trial judge did not allow an instruction on shoddy police work, and the defendant was convicted, obviously appealed, and the appeals court said, wait a minute, if the police don't have enough evidence to be sure, that plays into reasonable doubt. So it gave rise to this instruction. I wrote about it on LawNewz. For those of you watching who want to read the instruction, we actually have it there. So that's one of the ones that they'll get. And then there'll be some other ones here. Apparently the judge is also going to tell the jury that they could consider whether or not Alexander Bradley, the key witness, was the shooter. He's immunized based on his testimony, but they could bring that into their deliberations in some way. That's what we're hearing from the courtroom this afternoon. So I'm sure the Commonwealth isn't happy about that.
No, they can't be happy. They can't be happy about it. They can't be happy with the fact that the judge will allow the jury to consider Bradley as a shooter. I mean, there is all the doubt, and that's exactly what Baez wants. Baez wants the jury to believe that Alexander Bradley shot and committed these two murders. And that's it. And that's all Baez needs is reasonable doubt. And as far as the other instructions, the should have, the would have, the could have, did the police do a good job? Did they botch up the evidence? You know what? That, in a way, will work for the defense as well. Because even if the police were the ones who could have, would have, should have, and it cleaned up this investigation, it still creates the reasonable doubt. And that's the most important part of the instruction that the judge will give.
Yes, we're also hearing that there's likely going to be an instruction that says that Massachusetts has jurisdiction over what went on in this shooting involving Alexander Bradley getting shot and losing an eye in Florida based on what I presume to be a long-arm statute or something like that. So that allegation of witness intimidation, the judge will tell the jury, even though it happened in Florida, the jury can, create a punishment for that in Massachusetts if they wish.
Well, you know what? It's almost consolidation. They're consolidating the cases. I mean, we see it all the time within our own state. We consolidate cases. So yes, the long-arm jurisdiction will be brought over. The jury will get to consider whether or not Hernandez was the one who shot Bradley. And this is what the prosecution wants. The prosecution wants to take all the circumstantial evidence and tie it together. If it works, if the prosecution case works, they will find Hernandez guilty of shooting Bradley and of these murders.
It'll be really interesting to see how long the jury deliberates on this, because it has been a trial that has just lasted forever.
March 1st, it began, correct?
Something like that, yeah.
Yeah, it's a long time. This is a long time. And an hour and a half for jury instructions. You know, that'll feel like a whole month in itself.
I mean, I suppose that if a trial is going to last that long, then the instruction should at least do it justice. But it's difficult. It's a difficult one. And we're, of course, not sitting there looking at the looks on the faces of the jurors. We wish we were in some way.
I know. I wish I can see how the jury's reacting. I wish I can see how the jurors were reacting, you know, when the prosecution was, you know, doing their closing statement, when Baez was doing his closing statement. But we can't see their faces. So we don't know.
Let's talk a little bit about this other case that we're following here. This is the Jones case out of Arizona, where there is a young man being accused of murder and a number of other counts related to the shooting on this, it's right on the border of the campus and the fraternity row, basically. And we had the first victim on the stand this morning, and he started to lay the groundwork of exactly what was going on. And, you know, so as the story goes, the defendant was walking around late at night, early in the morning with a couple of friends, and then one of the friends decides that it would be funny to knock on the door of this fraternity where there's a party going on. The fraternity members open the door, get into an argument, the argument spills out onto the streets, and then apparently somewhere in there the defendant gets sucker punched in the face, his glasses fly off, he goes to his car. There are different accounts of the distance. I think one time we heard in court that it was 90 feet, another time we heard 150 feet. I don't know if somebody on the prosecution just misspoke or confused feet with yards or what the deal was, but it was some distance away, and that's the critical moment. The prosecution is arguing that because he went to the car and then went back into the dispute, that's enough to make this murder.
Well, and what does the defense say? And the prosecution's right. But what's the defense saying? His glasses were knocked off. He couldn't see. So he started wailing. He had the gun low, and all of a sudden he got attacked again. So this will be very interesting to see how it plays out. And, you know, you have, you know, such a stark difference, you know, between the defense and between the prosecution in this case. And we're listening, you know, we're listening to one of the victims right now. And you know what? If there's mothers or fathers on you know, sitting as a juror, you know, it's difficult to listen to.
It certainly is. I'm going through here looking for a clip here because we did record some of the opening statements and some of the discussions that were had in court this morning, and I'm waiting for the document to load up here. I want to play some of Nick Peering's testimony from this morning where he talks about and this is the beginning of his testimony, so this is clip 13. If we can go to that, guys. We don't have it yet. So what do we have? Let's go to the let's go to clip 3 because this is some of the opening statements from the prosecution. And as soon as we go back into session here in either Jones or Hernandez, we'll go right back to one of the two courtrooms.
The defendant, Stephen Jones, murdered a young man and seriously injured 3 others because his pride was hurt. In the early morning hours of October 9th, 2015, the defendant was confronted by a group of college students, and he was punched one time in the face. Instead of punching back or walking away altogether, the defendant went to his car to get his gun, a fully loaded .40 caliber handgun, and then he went another 90 feet back toward that group to shoot 4 unarmed college students. Now these college students were Nick Peering, Nick Prado, Kyle Zentek, and Colin Brew. The defendant shot Nick Peering twice, once in his arm and once in his hip. He shot Nick Prado once through his neck. He shot Kyle Zentek twice in his back as Kyle was running away. Now, miraculously, these 3 victims survived. Sadly, Colin Brew did not survive the defendant's rampage. The defendant shot Colin twice in his torso, lacerating vessels to his heart, causing massive internal bleeding. Colin died within minutes after the defendant shot him. Now, before this night, none of these victims knew the defendant, never associated with him, didn't know him to like him or dislike him. But that night, to the victims, the defendant was an assassin emerging from the darkness, and they had no chance to protect themselves before the defendant unloaded 10 rounds from his gun and changed their lives forever. All this because the defendant wanted payback. Now, ladies and gentlemen, during this trial, you will learn that what the defendant did was not an accident. It was not self-defense. This was aggravated assault, and it was premeditated murder. Now, earlier that night, the defendant and 3 of his friends decided to go to a party off campus, off NAU campus, Northern Arizona University. And the defendant's 3 friends that night were Shay McConnell, Jacob Mike, and Hunter Todd. All of them were freshmen at NAU, all of them newly pledged members of the Sigma Chi fraternity. Now, the defendant was driving that night, and he and his friends to this location. This is a 2-scale diagram, you'll see this during trial, of the parking lot where the defendant parked his car, and ultimately the area where the defendant shot the 4 victims in this case. The defendant parked his car here, and then he and his friends walked across the parking lot and up Franklin Avenue toward an area called the Grove, where the party was at. Now, at the Grove, like many college parties across America, there was alcohol, and some of them had some drinks, but nothing excessive. And at around 1 a.m., the defendant's 3 friends walked back down Franklin Avenue the same way they had come, across this area near the courtyard. Now, the courtyard was a location that right across the street from Mountain View Dorm, just off NAU campus. And at around that time, there was another party, a separate party occurring at the courtyard. Now,
okay, we're going to interrupt that replay of the opening statements from yesterday. You were listening to the prosecutor because the victim in this case, one of the victims, Nick Peering, is back on the stand and court is resuming in Arizona. We will continue to monitor the Aaron Hernandez case in Boston, though, but for now, let's go to this case of the individual charged with shooting 4 people, killing one of them outside a college campus in Arizona.
For the record, Mr. Davidson allowed the state to reopen the direct.
thank you, Judge.
Go ahead.
Nick, I'm going to show you what's been marked as exhibits 304, 305, and 306. Can you take a look at those and see if you recognize what's depicted there?
I recognize them.
What do those photos show?
It shows the front side of a gunshot wound to my right arm. This one looks like the entry wound on my left hip, and this is the exit wound on my left lower back.
Move to admit 304, 306, I believe.
304, 305, and 306, I think
Yes.
is what I had.
Oh, Judge.
304, 305, and 306 are admitted.
And Judge, since we had to switch computers, I'm not going to be able to project it. Can I publish the old-fashioned way?
Sure.
Thank you.
Let me see counsel up here for a second, please.
Judge.
That's all I have. Cross-exam, Mr. Davidson.
Good morning, Mr. Peary.
Good morning.
It sounds like you and Mr. Brew were very close friends.
We were.
Lived together for several years, fraternity brothers.
That's correct.
As you are with Kyle Zinczak, correct?
Correct.
And Mr. Nicholas Prado, correct?
Prado, correct.
Prado, apologize. All four of you dealt with that.
Correct.
If I understood your testimony correctly, Mr. Peering, you were first alerted to the situation by hearing your roommate's voice, correct?
That is correct.
He was yelling, wasn't he?
That is correct.
Where were you when you heard your roommate yelling?
In that courtyard area in between the two buildings.
And you can't see the courtyard. From the courtyard, you can't see the parking lot, can you?
No, you cannot.
There's a building in the way, right?
Correct.
So you're able to hear Colin's voice on the other side of the building, correct?
Correct.
Across Franklin, correct?
At the time, I didn't know where he was, but by the time I got over there, he was across the street.
Okay. So he was on the other side of Franklin, correct?
At the time, like I said, I couldn't see him, so when I got over there, he was across Franklin.
Okay. And when you got across Franklin and you saw him in the parking lot, he was at the far end of the parking lot, correct?
He was on that pathway, not the parking lot.
The far end, though, correct?
What do you mean the far end?
The far end of the pathway where the parking lot ends.
Where the parking lot ends, yes.
Okay. So you heard him from quite a distance. You said you were jogging, correct?
Correct.
And if I understood your testimony correctly, the reason that you jumped over the bush and you ran to Colin was because you saw him fall.
That is correct.
And that prior to him falling, it was just Colin by himself and these 3 other individuals, right?
That is correct.
And that there was no one with Colin, right?
That is correct.
Just Colin and then these 3 other guys.
Mm-hmm.
Is that correct?
Correct.
And these 3 other guys, in response to Colin saying, you have to get out, F you have to leave, these 3 other guys said something along the line of, you can't kick me out.
From what I heard.
They were standing their ground.
Correct.
They were arguing back saying, we're not going anywhere.
Correct.
You also testified that you didn't hear any gunshots when Colin fell, correct?
That is correct.
Now, when you were transported to the hospital, the police talked to you, didn't they?
Not in the ambulance, but in the hospital, correct?
May I correctly assume that you've had an opportunity to meet with Mr. Barker and/or other members of the prosecution team prior to your testimony today?
I have.
And you've had a chance to review the transcripts?
I have.
You've had a chance to review your transcripts from that interview?
Oh, correct.
Okay. I'm not trying to be rude with you, it's just difficult for a court reporter to write down more than one person talking at a time.
My apologies.
You told the police a pretty different story that night, didn't you?
What did I tell them?
May I approach, Your Honor?
Yes.
Exhibit, counsel.
This is number 66.
Thank you.
How many times did you meet with the prosecution incidentally before testimony today?
I believe 3 or 4 times.
And we've never met before today, have we?
No, we haven't.
When you were interviewed by the police at the hospital, it was done in 2 parts, wasn't it?
Correct.
And Exhibit 66 has both parts of that interview, doesn't it?
Looks like it, yes.
So let's start at the beginning. Page 2. See that?
See.
Page 2?
Yes.
Okay. Direct your attention to line 8. Question. I'm listening. Answer. This is you speaking, correct?
Correct.
Okay. He was talking to one kid. He was talking to one kid. Some other kid was like, back away, said, we don't want any problems. Right?
That's what it says.
Okay. When you're referring to he was talking to one kid, you're talking about Colin, aren't you?
Correct.
And when you're saying some other kid was like, back away, said, we don't want any problems, you're talking about the kid that comes from the parking lot.
I believe so.
You go on to say this kid comes from the parking lot, the east side of Mountain View, correct?
Correct.
Okay. Then you go on to say, east side of Mountain View, comes through the parking lot, shines a flashlight, and says, back up. That's what you told the police, right?
Correct.
You go on to say, we're like, and naturally, everyone else is still like progressing because we wanted to like make them leave. Right?
Correct.
Who's we?
Well, at that point, it was just me and Colin.
Okay, so you and Colin are naturally still progressing after this individual approaches from the parking lot with a flashlight and says, back up. You said.
Well, that's what I said.
Okay. And then there's some pages that essentially cover interaction between you and the medical staff. Can we agree on that?
Yes.
The questioning then resumes later on page 11, correct?
Correct.
And you're asked where you saw this guy coming from, and you said the west side of Mountain View, right?
Correct.
You're referring to Mountain View parking lot, correct?
Yes.
Okay. And when you spoke to the police, you didn't tell them that you ran up because Colin had fallen, you told them that you ran up because you were trying to calm people down, correct?
Correct.
In fact, you told the police that you were, use your words, mainly trying to calm Colin down. Isn't that what you said?
That is correct, because I didn't know who else was there.
That's what you said to the police the night this happened, isn't it?
That is correct, because I didn't know who the other people were.
So you're running up because there's an altercation and you're trying to calm people down. That's what you told the police. And you explained to the detective that there's a 2-foot gap between the roadway and the parking lot, right?
Correct.
And we can agree that the roadway is at a higher elevation than the parking lot down below.
Correct.
You tell the police, not that Colin was shot and then, or fell and then you ran over, but rather you tell the police, and I'll refer you to line 17. And so I was trying to calm people down, and I went over there and I was like, hey, calm down, calm down. He said, step back. Now, when you say he said step back, you're referring to the person who had the flashlight, correct?
Correct.
He said step back, and at the exact moment he said step back, I jumped from the top to the lower part, and that's when I got shot. I got shot like in midair. Those were the words that you gave to the police the night this all happened, aren't they?
Correct.
Let's turn the page to page 12, please, sir. Line 4, as we covered before, you stated to the detective you were trying to calm it down, mainly trying to calm your roommate down, correct?
That's correct.
Okay. You noted that he was deceased, your roommate, correct?
Yes.
And that there were about 4 other people on the opposite side of us, correct?
Correct.
Now, let's back up to your testimony when Mr. Parker was asking you questions. You said these 4 people were like, we're not leaving, you can't kick us out, right?
Originally, it was 3 people. Stephen Jones would make the 4th.
Okay. 3 or 4 people, they were backing up, according to your testimony before, right?
Correct.
We're not leaving, you can't kick us out, correct?
Correct.
You even used the phrase chest bumping in your direct testimony, didn't you?
I did.
That's not what you told the police, though, is it?
Well, there was...
Chest bumping was the way he phrased it, not bumping.
Well, let's just look at what you told the police. I'll withdraw the question, Your Honor.
Okay.
Line 7. So let's put this back into context. Backing back up to line 5. And there were 4 people on the opposite side of us. That's what you said, correct?
Correct.
The next thing you state is 3 of which were like, okay, okay, we're leaving, we're leaving. That's what you told the police, correct?
Correct.
We're leaving is not the same as you can't tell us to go, is it?
I believe not. There were multiple words exchanged.
So you're referring to these 3 guys essentially saying that they're going to leave, and then you go on to talk about how this other guy, who we later determine is Stephen, comes from the parking lot with a flashlight, correct?
Correct.
And he says, or is like, step back as you're jumping.
Correct.
You told the police that Colin was kind of like headed towards his way, kind of, I think, maybe towards someone else, and he put the flashlight up, and as soon as he did, started shooting, correct?
Correct.
That's what you told the police when you were interviewed just
in the hospital?
Shortly after this incident occurred on October 8th, 2015, correct?
When I was in the hospital, correct.
Okay. So on October 8th, you recalled hearing gunshots, correct?
I do.
October 8th, you clearly told the police that it was not until after you heard Stephen giving commands back up and lifting up his flashlight that you heard shots, correct?
Correct.
And it's not, according to what you told the police originally, it wasn't until after you heard shots that you saw Colin fall, correct?
Well, I didn't hear the first shots that hit Colin, like I said before.
Well, I know you said that before today. I'm talking about what you told the police originally. What you told the police originally is that you heard shots and then you saw Colin fall, didn't you?
I believe so. I was in shock.
Let's go ahead and skip to the second part of your hospital interview with the police.
And which page is that?
I would assume because the first one is 16 pages, that would be the 17th page. It should, the page numbering should start back over at 1. Please let me know if yours is different.
It's at 1.
Okay. So, again, just to remind the jury, you're perfectly clear both in direct examination and cross-examination that it was just Colin and these 3 other guys, right?
Correct.
Okay. Well, you told the police something different about that as well, didn't you?
And what was that?
Well, let's look at page 2. Talking about Colin on line 2. And he was like basically kind of cussing, like, get the fuck out of here. And I remember specifically 3 of them, they're like, okay, we'll leave. And then a couple other people came up and were like saying the same thing. Like, you guys got to go. You're not welcome. Blah, blah, blah. All this and that. That was what you told the police, isn't it?
Correct, but I don't know exactly who that was.
Well, these weren't people that were with the 3 guys who were saying, okay, we'll leave. You're saying these are other people that came up and started joining Colin.
I didn't say they joined Colin.
Okay, well, let's go back through it again. You can tell me who you're referring to.
I don't know who I was referring to.
And I remember specifically 3 of them, they're like, okay, we'll leave. And then a couple other people came up and were like saying the same thing, like, you guys got to go, you're not welcome, blah, 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 all this and that. So there were other people there, according to what you told the police originally anyways, also telling these people to leave.
I believe so.
And you again confirmed with the police, when you talked to them the night of the incident, that these 3 individuals were not chest puffing or chest bumping. They said, like, okay, we'll leave. That's what you told the police, isn't it, Mr. Moore?
Prior to that, they were yelling at each other.
Okay, wasn't my question. That's what you told the police, even this happens, what I just read, isn't it?
Yes.
And you go on to explain, this dude with the gun, he turned right to that kid, looks over at this kid, and starts walking toward him. He's not even charging or anything. The kid says, like, stop or whatever. When you say, he says stop or whatever, you're referring to the person who had the flashlight, Mr. Jones, right?
Correct, and then I go and state that he doesn't have a gun.
Okay. Like I said, he doesn't announce that he has a gun, correct?
Correct.
Okay. And you are probably 10 feet behind Colin at that point, correct?
Correct.
And he puts Mr. Jones puts the light up, correct?
Correct, I see the flashlight.
And after he puts the light up, and then, in your words, he just popped like 8 rounds, correct?
Correct.
So you, at least two occasions, tell the police the night of the incident that you did hear gunshots, didn't you?
I did hear gunshots, yes.
You told the police that Colin was looking straight at Mr. Jones when this happened.
He turned towards him?
You told the police Colin was looking straight at him when this happened, didn't you?
Correct.
Now, when you originally, let me back up. As of the time you're at the hospital and you're talking to the detective, you at that moment had no idea who the individual holding the flashlight or the gun was, did you?
I did not.
You didn't know if he was at the party that night, did you?
I did not know.
Okay. You don't know where he was prior to coming from the west side of the parking lot?
I did not.
Now, at some point, a couple days after you were released from the hospital, you were interviewed again, weren't you?
Correct.
And I believe Mr. Barker was at that interview, correct?
Correct.
And Mr. Shea?
Correct.
And Sergeant O'Hagan, right?
Correct.
And that interview was also recorded, correct?
Correct.
Approach the witness, Your Honor?
Yes.
Exhibit 67. Is that a transcript of your interview with Mr. Barker, Mr. Shea, and Detective O'Hagan?
Yes.
Can I direct your attention to page 4? Actually, before I ask you about that, between the time you were discharged, let me back up. Between the time that you spoke to the police at the hospital and the time that you spoke to the 3 gentlemen behind me, you obviously spoke to other friends of yours or people who were there about what happened, didn't you?
I mean, I spoke to friends about not necessarily what happened, but I'm glad that they came and visited me.
Okay. Well, let's look at page 4 then. Line 17. You tell these 3 gentlemen, and I never got to see this kid's face at all, but by the time, I had even seen Colin fall, this kid had already apparently gone, grabbed the gun, and came back, turned this light on, shined it at Colin. That's what you told these 3 gentlemen a few days later, correct?
Correct.
It would be impossible for you to have known that if you didn't know where this individual came from when he emerged from the parking lot, unless somebody else told you. True?
I saw that he came from the parking lot with a light.
Did you see him grab the gun?
No, I said apparently. So he grabbed a gun and came back.
He apparently had gone, grabbed a gun, and came back. Came back means he was there initially and then returned, doesn't it?
If you put it in that way, I guess, yeah.
Well, those are the words that you used, aren't they?
But I don't know if he was there originally.
Well, that's my point, is that you couldn't have known that because you didn't know where he came from when he first came out with the flashlight, did you?
Correct.
So you obviously spoke to other people about this case before you spoke to the prosecution, didn't you?
I don't recall when I was in the hospital who I spoke to.
Now, it almost sounded like Mr. Barker's trying to make the case that Mr. Brew didn't fall because he was shot, but because he tripped over this curb. You never said anything to the police in any of your interviews about Colin tripping, did you?
No, I said he fell.
I'm not asking about falling. You never said anything about tripping, did you?
I don't believe so.
You never said anything about the curb being an obstruction to him, did you?
I wasn't looking at the curb, no.
I'm not asking if you were looking at the curb, sir. I'm asking if you ever said anything to the police about the curb being an issue with him falling.
I don't believe so.
Just how much did you have to drink that night?
I wasn't counting. A couple of drinks.
Do you have any reason to disbelieve a toxicology report indicating that you were 2.5 times the legal limit?
No.
Was Mr. Zintek drinking that evening?
I believe so.
Was he smoking marijuana?
Not that I know of.
Was Mr. is it Prado?
Prado?
Was Mr. Prado drinking that evening?
I believe so.
How much was he drinking?
I didn't count his drinks either.
Was he smoking marijuana?
No.
Was Mr. Brew drinking that evening?
Yes.
Do you have a sense of how much he had to drink?
I wasn't counting his drinks either.
Was he smoking marijuana that evening?
No.
Well, you're nodding your head and you're saying no. Is it?
Oh, sorry, no.
Okay. Did you use any other drugs that evening?
No.
Have a brief moment. Sure. Thank you, sir. No further questions.
Redirect.
Thank you. Nick, let's bring this back to reality, shall we?
Okay.
Your Honor, move to strike.
It is stricken. Can I see counsel up here, please?
Nick, when you were shot twice by the defendant, where did you go after that?
To the hospital.
Okay, and for what purpose?
For medical care.
And were you in shock at the time?
Yes, a lot.
Were you in pain?
A lot, yes.
Were people treating you at the time?
Yes.
In fact, counsel talked about how while you were talking to the police, there were people there helping you. Is that right?
Correct.
And they were interrupting this conversation at times. Is that true?
Correct, and you can see it in the transcripts as well.
And I think counsel referred to that as well, didn't he?
I believe so.
So this very first conversation about what happened occurred at the hospital. Is that right?
I'm sorry, could you repeat that?
The very first conversation you had about this case occurred at the hospital. Is that right?
Correct.
And counsel talked about things that may be different than what you testified to today. Let's talk about the things that were consistent, all right?
Okay.
Were you consistent that there was no physical altercation at any point?
Correct.
Were you consistent that nobody else had a weapon aside from the defendant?
Correct.
That nobody else said, I have a gun?
Correct.
That Colin did not rush anybody?
Correct.
That Colin had nothing in his hands?
Correct.
That he said nothing aggressive to the shooter?
Correct.
That nobody was ever surrounded by any group, is that correct?
That is correct.
Those are all consistent with what you testified to and what you said back to the police, is that right?
That's correct.
Did counsel refer in the transcript where it is he purports there's a prior consistent statement of what he just said?
Granted.
Well, let's go through the whole statement then. Okay. Do you have that exhibit?
66 or 67?
Your Honor, asked and answered. It was just as to the last comment. Counsel asserted that there was a prior consistent statement in the transcript that this witness said in his prior out-of-court statement that there was no one surrounding the group. I'd like counsel to identify where in the transcript that prior consistent statement.
Well, let me rephrase, Judge.
Okay.
Is there anywhere in the transcript where you say that someone was surrounded by anyone?
No.
Okay. And today, did you say that there was anybody surrounding anybody?
No.
Let's go through the transcript, what counsel was talking about as far as things that were different. On page 2, this is the first exhibit, I believe it's 66. Counsel referred to this section where he said, where the police officer said, I'm listening, and you talk about, he was talking to one kid, and he was talking to one kid, and some other kid was like, back away, and we don't want any problems. Is that different than what you testified to before?
No, I believe so.
And then this kid comes from the parking lot. Who was that kid?
The shooter at the time.
Is that different than what you said before?
No.
Comes through the parking lot.
I think counsel misread that quotation. I'd like to have it reread.
I'll read the whole thing again.
I just want lines 9 through 11 read, Your Honor.
9 through
I'd be
11,
happy
please.
to. He was talking to one kid, and he was talking to one kid, and some other kid was like, back away, said, we don't want any problems. This kid comes from the parking lot, the east side of Mountain View. Anything different there that I'm missing?
I think when I said this kid comes from the parking lot, I think the defense is getting it confused with the kid that Colin was talking to.
All right, thank you for that clarification. So there were multiple kids you're referring to in this paragraph.
Correct.
And then further, counsel had you read lines 13 through 15, east side of Mountain View, which would be the parking lot? Or,
correct.
Okay. Comes through the parking lot, shines a flashlight, and says back up. Now, earlier you said you heard stop. Is that correct?
Correct.
Is there a big difference in your mind about whether it was stop or back up?
No, there's not.
Did he say anything about a gun?
No, he did not.
We're like, and continuing on, we're like, and naturally everyone else is still like progressing because we wanted to like make them leave. What are you referring to when you say we're like, and naturally everyone else is like still progressing?
So at that point, Colin and the other kids were still in an argument, and they said they were going to leave. They weren't leaving. They were, like I said before, kind of standing their ground. And so at that point, I was getting closer to Colin, progressing. And then when I saw him turn is when I jumped, and he fell, and I jumped over the bushes.
Thank you. Let's go to page 11. Counsel had you read lines 9 through 10. You said, I don't know, so I ran up because I knew there was an altercation. I was trying to calm people down. Who were you trying to calm down?
Colin and the kids who were yelling at him.
Because people would imply multiple persons, is that correct?
Correct.
All right, so not just Colin, but the other people?
Correct.
But Colin was one of them, as you testified to, right?
Correct.
And then skipping down to 17 through 20, counsel referred to, and so I was like, I was trying to calm people down, and I went over there and I was like, hey, calm down, calm down. He said, step back. Who are you referring to at that point?
I believe the shooter.
So step back. Anything about a gun there?
No.
And I, at that exact moment, he said, step back. I jumped from the top to the lower part, and that's lines 4 through 5. Trying to calm it down, mainly trying to calm my roommate down. Who are you referring to?
Colin.
Who's dead, you said, and there was about 4 people on the opposite side of us. Who were the 4 people?
I don't know who they were.
So you weren't able to identify who those people were at the time?
No. Like I said, I was focused mainly on Colin.
Was one of the people that you were referring to the shooter?
As he came from the parking lot?
Yes.
Yes.
Let's go to the next exhibit, Exhibit 67. So, Nick, just let's put this in perspective a little bit. When you were meeting with myself, Sergeant O'Hagan, Brian Shea, well, let's put this in a timeline. When were you released from the hospital?
Sunday morning, Sunday afternoon.
And do you recall when you had the conversation with us?
I believe it was Monday, Tuesday.
Were you still bandaged up?
I was.
Did you have a hard time walking at that point?
I did.
And you met with us, and you met with also another individual who works for Victim Witness, is that correct?
Correct.
Because you're a victim in the case?
Sustained.
May we approach the...
No. Please continue.
So counsel had you refer to page 2 of that transcript. Do you have that there?
Yes.
And he said, and he had you refer to a pretty lengthy paragraph that he summarized, but let's read the whole thing.
Objection, Your Honor. This states I had referred to page 4.
Sustained.
I don't recall that, Judge, but I'll go to page 4 as well. If counsel could refer me to what lines he thinks he...
Lines 17 through 19.
Okay, let's read the whole thing under Rule 106, Judge, for completeness. Your answer...
I'm sorry?
We approach on the request for the 106 reading.
Sure.
My person witness give the exhibit.
Raise. I was on the wrong exhibit. Exhibit 66. It renumbers. So go to the second section on page 2. Counsel asked you about, you said you heard, or he just popped like 8 rounds. And counsel asked you if that was different than what you testified before, because you indicated you didn't hear any gunshots. Is that correct?
The initial.
Welcome back to the Law News Network, everybody. I'm Aaron Keller. You're listening to our live stream from the trial of the young man accused of shooting 4 people, killing one of them at a Arizona college campus. We're going to take you back to the Aaron Hernandez trial in Boston, however, where the judge is reading instructions for the jury. If you'd like to listen in to the trial that we're on right now, however, you can go to the top of our website on lawnewz.com and click on the live button where you can watch the raw stream coming out of the Arizona trial.
You've heard in this courtroom and nothing else. The opening statements and the closing arguments of the lawyers are neither evidence nor a substitute for evidence. They are intended only to assist you in understanding the evidence and the contentions of the parties. If counsel stated something in their opening statement that was not developed by the evidence at trial, you are to disregard it, for you may decide this case based solely on the evidence presented. And my instructions and anything I've said in passing during the course of trial is not evidence. If your memory of the testimony differs from that as stated by the attorneys or from anything I may say, you're to follow your own recollection. Now, I permitted you to take notes during the testimony of the witnesses. Your notes are not evidence. They're not an official or even unofficial transcript of the testimony. And during deliberations, you're not to use your notes to attempt to persuade fellow jurors as to what the testimony was. Instead, you're to be guided by your memory of the testimony, and each juror's notes are personal to them and serve only to assist the note-taker in their recollection of the evidence. When you deliberate, it is your recollection of the testimony, to the extent assisted by your own notes, that determines what the evidence shows. During trial, you were taken on a view of certain areas, including the Cure Lounge at 246 Tremont Street in Boston, the Tufts Medical Center parking garage on Tremont Street, the intersection of Shawmut Avenue and Herald Street, and a police evidence storage facility where we viewed a Toyota 4Runner. The view was permitted to assist you in understanding and evaluating the evidence by reference to observations you made about the location and configuration of streets, businesses, and buildings, and surrounding features, including the location of surveillance cameras. The observations you made during the view may be used as evidence to the extent that the things observed during the view were in the same condition as they existed in July 2012. That is, with regard to the location and configuration of various streets, the location of buildings, surveillance camera positions, and the like. You may rely on your observations in assessing the evidence presented at trial. Now, the defendant, Mr. Hernandez, did not testify at this trial. As I informed you at the outset of this case, a defendant in a criminal case has an absolute right not to testify, established by our Constitution and in our statutes. The fact that the defendant did not testify is not evidence of anything, and you may not draw any adverse inference against this defendant because he did not testify. It's not a matter to be considered by you or even discussed during your deliberations. Rather, you must decide whether the Commonwealth has proved its case beyond a reasonable doubt based solely on the evidence you have heard and the reasonable inferences you draw therefrom. The fact that the defendant did not testify is absolutely not to be considered by you in your deliberations. Now, consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you have gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. Now, generally, there are two types of evidence that you can use to determine the facts of a case. And they're phrases I'm sure you've heard before. There's what's called direct evidence and circumstantial evidence. You have direct evidence where a witness testifies directly about some fact that is to be proved based on what he or she claims to have seen or heard or felt with their own senses. And the only question then is whether you believe that witness. You have circumstantial evidence, where no witness can testify directly about a fact that is to be proved, but you're presented with evidence of other facts, and then asked to draw reasonable inferences from them about a fact that is to be proved. Let me give you an example of the difference between direct and circumstantial evidence. Suppose that an issue to be decided is whether it's raining outside. And imagine as we sit here, the blinds are raised, and you're able to look out and see out the windows. And looking out the windows, you see clouds in the sky, you see water falling from the sky, you see puddles on the ground. That is direct evidence that it's raining outside. It's based on your personal observation, your sense of sight. Imagine, on the other hand, as we sit here, and as they are now, the blinds are closed. And imagine you cannot see directly the weather outside. But you recall that when you arrived here this morning, the sky was gray and threatening. And as you sit here, you see people entering the courtroom from the public door, coming in with wet clothing, shaking water off raincoats, closing umbrellas. That is circumstantial evidence that it's raining outside. You haven't seen it directly, but based on other observations you have made, you draw an inference or infer that it is raining outside by applying your common knowledge, your common experience, and your common sense to one set of facts, resulting in a conclusion of fact. You're entitled to consider both kinds of evidence. There is no difference in the probative value between direct and circumstantial evidence. And indeed, circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant guilty beyond a reasonable doubt from all the evidence in the case. Where the Commonwealth's case is based solely on circumstantial evidence, and that is for you to say, you may find the defendant guilty only if those circumstances are conclusive enough to leave you with a moral certainty, a clear and settled belief that the defendant is guilty and that there is no other reasonable explanation for the facts as proven. The evidence and inferences you draw from the evidence must not only be consistent with the defendant's guilt, it must be inconsistent with his innocence. Now, an inference is a permissible deduction that you may make from evidence you have accepted as believable that leads to a conclusion, again, based on your experience, your common sense, and your general knowledge. For instance, when you see people entering a building with wet clothes or closing umbrellas, shaking water from them, you may draw an inference or infer that it's raining outside by applying your common knowledge and experience to a known fact, resulting in a conclusion of fact. You may draw an inference, even if it is not necessary or inescapable, so long as it or they are reasonable and warranted by the evidence you have found to be true. In order to draw an inference, the facts necessary to establish that inference must be proven beyond a reasonable doubt, and you may not use conjecture or guesswork in drawing inferences. An inference that is merely possible is not acceptable. It must be possible and reasonable and based on evidence that you have accepted as true. In order to convict the defendant, you must find that all the evidence and the reasonable inferences taken together and that you have drawn prove that he is guilty beyond a reasonable doubt. If it does not, you must acquit him. Now, during the trial of this case, the attorneys have introduced over 380 items as exhibits. And these include photographs, cell phone records, records relating to cell tower locations, surveillance videos, still photos, and still photographs from videos, some clothing, hospital records, 2 death certificates, a purported firearm and ammunition, other ballistics evidence, and other items. Exhibits are one form of evidence offered to assist you during your deliberations. Exhibits are those items that are marked with a numbered exhibit tag, as distinguished from other items, blow-ups or charts that served as demonstrative aids and were given a letter designation for identification. These items, which were referenced or shown during the trial, will not be available to you during deliberations because they were not formally received into evidence as exhibits. But as to the exhibits with numbered tags, you will have all of those items available to you during deliberations, so you may examine them to whatever extent you wish. With regard to physical items that are within evidence bags, please exercise caution in handling those items. Our court officers will provide you with latex gloves for your use in handling these items during deliberations. And a number of the exhibits in this case are in electronic form, either on thumb drives or CDs or discs. If you're unable to access any exhibit electronically, please send me a note and we'll attempt to correct the technological problem. Now, as with the testimony of witnesses, you may give exhibits whatever weight or value that they deserve in helping you to make your ultimate judgment about whether the Commonwealth has proved its case against this defendant, Aaron Hernandez. You're not required to believe something simply because it's written on a piece of paper or appears in a photograph. You're not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give each exhibit. Now, several photographs were introduced during the trial that may be considered upsetting, disturbing, or graphic, showing the location of apparent injuries to each of the decedents. These photographs were admitted into evidence to assist you in determining the facts of the case, but you cannot be influenced by any sympathy, sorrow, or pity, nor by anger or outrage. You may consider such evidence only to the extent it helps you to understand and determine the facts, but you must be dispassionate and rational in assessing whether the Commonwealth has met its burden of proof. Now, it will be your duty to decide any disputed questions of fact. You will have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it is your function to resolve those conflicts and to determine where the truth lies. You may believe everything that a witness says, or only part of it, or none of it. If you do not believe a witness's testimony that something happened, of course your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means you have to look elsewhere in the evidence for credible evidence about that issue. Now, in evaluating the credibility of a witness, you may use various tools. You may consider the ability, the opportunity, and the reliability of a witness to see or hear something in the past and then remember and later testify before you in this courtroom. You may consider the appearance of a witness while testifying before you. Any inconsistency you may have found in the witness's testimony, the witness's conduct while testifying before you, and whether the witness's ability to perceive, remember, or relate events was affected by the ingestion of drugs or alcohol. You may consider if the witness has any interest in the outcome of these proceedings and any bias or prejudice or hostility that may have been demonstrated by the witness while testifying before you, the level of accuracy of the witness while testifying before you, and the reliability of their testimony as it developed before you, the members of this jury. Now, one witness, Alexander Bradley, testified under a cooperation agreement with the Commonwealth, where, in exchange for his truthful testimony, he would not be prosecuted. Where a witness testifies pursuant to an agreement that provides a benefit to the witness, you should examine that witness's testimony with great care and caution. In addition to all the other factors I've mentioned bearing on credibility, you should consider whether the witness's testimony has been affected by his interest in the outcome of the case and any benefit that he has received or hopes to receive in the future. You should also consider the fact that the Commonwealth does not know whether the witness is telling the truth in his testimony. That is a determination only you can make. Similarly, a number of witnesses, including Alexander Bradley, testified under grants of immunity from prosecution. These witnesses also included Cheyenne Jenkins Hernandez, Tyrone Crawford, Jarrell Pierre, and Oscar Hernandez. Where a witness testifies under a grant of immunity, you should examine that witness's testimony with great care and caution. Under Massachusetts law, a defendant cannot be convicted based solely on the testimony of an immunized witness. There must be some corroboration of that witness's testimony as to at least one essential element of the crime or crimes charged. Now, recall what I said and instructed at the outset of this case, that all witnesses are to be treated equally and the same in terms of your assessment of their credibility and their testimony. The fact that a witness is a police officer or associated with law enforcement does not mean, standing alone, that his or her testimony is more or less credible than any other witness. Now, during the course trial, counsel have questioned some witnesses about prior statements that they made to the police or others outside of court. In evaluating a witness's testimony in court, you may consider whether that witness made any earlier statement that differs from or contradicts in any way his or her in-court testimony, and we call these prior inconsistent statements. To qualify as inconsistent, it's not necessary that the prior statement contradict in plain terms the testimony of the witness. It is enough that the statement taken as a whole, whether by what it says or by what it omits to say, affords some indication that the fact was different from the testimony of the witness. The earlier statement is admitted into evidence solely for your consideration in evaluating the witness's credibility. As to prior unsworn statements, you may not consider the earlier statement as evidence or proof of the truth of any fact contained in that earlier statement. And if a witness has been impeached by a prior inconsistent statement, give the testimony of such witness or that witness such weight as you see fit. Keep in mind that an innocent misrecollection, like a failure of recollection, is not an uncommon experience. In weighing the effect of any discrepancy in a witness's testimony, consider whether it pertains to a matter of importance or an unimportant detail, and whether you feel that discrepancy results from an innocent error or whether the witness has intentionally and purposely given false testimony. And a similar rule applies with regard to any prior statements that were consistent with the witness's in-court testimony. If a witness is impeached by a prior statements that are inconsistent with their in-court testimony, you may consider the fact that the witness gave an earlier or prior statement consistent with their testimony in court to rebut a claim that the witness's testimony is a recent contrivance or a fabrication or is motivated by some promise or hope of reward or inducement. Again, that earlier statement is not admitted as substantive proof of the truth of any fact contained in that earlier statement. Now, certain witnesses were questioned about prior testimony they provided at a grand jury proceeding, and their grand jury testimony was presented as substantive evidence, that is, for the truth of what they said under oath at the grand jury. In these instances, you may consider the witness's prior grand jury testimony for all purposes, that is, not only in showing a prior inconsistent or a consistent statement, but for the truth of what was said as well. Finally, there was a portion of a recorded police interview with Rashidis Gomes Sanchez that was played regarding Mr. Sanchez's description of the shooter. Although that was a prior statement, it was admitted as substantive evidence and may be considered by you for all purposes. There's one more point about witnesses to address, and this relates to so-called expert witnesses. This term refers to witnesses who have some specialized training or experience in a given field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their personal knowledge, that is, things that they've personally seen or heard or felt. However, in a variety of cases, issues arise that are beyond the experience of laypersons, and in those types of cases, we allow a person with some specialized training or experience, called an expert witness, to testify, and to testify not only to facts, but also to opinions and reasons for their opinions on issues that are within that witness's field of expertise and that are relevant material to the case. In this case, a number of witnesses have testified to things that they did or reviewed based on some professed specialized knowledge or expertise. These include a medical examiner, Dr. Catherine Lindstrom, who testified to the autopsy she conducted and opinions formed regarding the cause and manner of the deaths of Daniel De Abreu and Safiro Furtado. Dr. Jamie Downs, a forensic pathologist, who reviewed materials and gave opinions regarding the circumstances surrounding the deaths of Mr. De Abreu and Mr. Furtado, and offered opinions regarding the number and paths of travel of gunshots. We heard from Thomas Murphy and Detective Tyrone Camper, who testified to their respective examinations of a .38 caliber revolver and ammunition, and offered opinions regarding that handgun and ammunition. And in addition, as to Detective Camper, offered opinions about his examination and comparison of bullets or shell casings with ammunition test fired from the .38 caliber revolver that has been introduced as an exhibit. You also heard from various witnesses who examined cellular telephone records and data recorded in those records, or conducted forensic examinations of cellular telephones and a laptop computer. These witnesses included Sergeant Kevin Witherspoon, ATF Special Agent Matthew Kelsch, Senior Marshal and Senior Inspector of the U.S. Marshal Service, Anthony Vasali, Sergeant Timothy Latham, and Jacob Green, all of whom testified based on some professed specialized knowledge and training. You heard from various chemists and analysts from crime laboratories who testified regarding scientific testing they conducted and the results of that testing, to include John Biello, who spoke about gunshot residue testing, Stephen Lord, who testified about fingerprints, both from the Massachusetts State Police Crime Laboratory. And you heard from Kristen Tolan, Amy Reynolds, and Julie James, all of the Boston Police Crime Laboratory, who testified about forensic examinations for fingerprints, DNA, and trace evidence. And you heard from Michael Haig, who testified and offered opinions regarding the number of shots fired and the likely path of travel of bullets. Now, because a particular witness has some specialized training and experience in his or her field, does not put that witness on any higher level than any other witness. And you're to treat expert witnesses just like you treat all other witnesses. In other words, as with any other witness, it is completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that witness gave. It is also entirely up to you to decide whether you accept the facts relied upon by the expert and to determine what conclusions, if any, you draw from that expert's testimony. You're free to reject the testimony and opinion of such a witness in whole or in part if you determine the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. Now, on occasion, an expert witness may be asked to render an opinion based on assumed or hypothetical facts. And in those instances, the opinion rests on the truth of the assumed or hypothetical fact. In order to accept an expert's opinion under these circumstances, the facts that were assumed must be part of the evidence and accepted by you as true. Put another way, if an expert witness rendered an opinion based on assumed facts that you do not find to be true, then you should reject the opinion to the extent it relies on those assumed facts or on facts contrary to those found by you, the jury. Keep firmly in mind that you alone decide what the facts are. And if you conclude an expert's opinion is not based on the facts as you find those facts to be, then you must reject that testimony and opinion of the expert in whole or in part. And any expert's opinion cannot be purely subjective. Rather, it must be expressed as held, quote, to a reasonable degree of professional certainty in the particular field of expertise, for instance, ballistics, medicine, or some other science. Now, you must remember that expert witnesses do not decide cases. Juries do. In the last analysis, an expert witness is like any other witness, in the sense that you alone make the judgment about how much credibility and weight you give an expert's testimony and what conclusions you draw from that testimony. Now, during the trial, one or more of the Commonwealth's witnesses was questioned regarding scientific testing that was or was not performed, or investigative activity that was or was not performed. A failure on the part of the Commonwealth to conduct some scientific tests or otherwise follow standard procedure during a police investigation is a factor you may consider in evaluating the evidence presented in this case and whether the Commonwealth has met its burden of proof. With regard to this factor, you should consider three questions. First, whether the omitted tests or other actions were a standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the tests or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality or reliability of the evidence presented by the Commonwealth. Alternatively, you may consider whether the omissions tend to show the existence of some police bias against the defendant in conducting the investigation. All of these considerations involve factual determinations and are entirely up to you, and you're free to give this matter whatever weight, if any, you deem appropriate under all the circumstances. Now, a defendant in a criminal case has a constitutional right to present evidence that another person may have committed the crime. Thus, a defendant may introduce evidence that tends to show that another person committed the crime or had the motive, intent, and opportunity to commit it. In this case, the defendant contends that Alexander Bradley committed the crimes charged relating to the Boston shooting incident, and this is referred to under the law as third-party culprit evidence. Such evidence must be relevant and have a rational tendency to prove the third-party culprit defense that the defendant raises, and the evidence cannot be too remote or speculative. Moreover, the Commonwealth does not have the burden of proving that no one else committed this crime. It is the Commonwealth's burden to prove beyond a reasonable doubt that this defendant committed the crime. However, you may consider evidence that another person committed or may have committed these crimes in determining whether the Commonwealth has proved its case against this defendant beyond a reasonable doubt. Now, some evidence was presented regarding the defendant's activities or conduct after July 16, 2012, to include garaging the Toyota 4Runner at 114 Lake Avenue in Bristol, Connecticut, and disposing of certain items. Evidence was presented that after February 13, 2013, the defendant changed his cellular phone and spoke with Brooke Wilcoxon several times. Finally, evidence was presented that at some point the defendant obtained tattoos in California in 2013. If the Commonwealth has proved that the defendant acted in one or more of these ways, you may consider whether such actions indicate feelings of guilt by the defendant, and whether, in turn, such feelings of guilt might tend to show actual guilt on these charges. You're not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances of the case. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. But you should always bear in mind and remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. And please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, for such feelings are sometimes found in innocent people. Finally, remember that standing alone, such evidence is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. On the issue of the defendants obtaining various tattoos, please recall the instruction I gave at the time this evidence was admitted, that you may not consider such evidence as demonstrating anything about the defendant's propensity to commit crime generally or to engage in gun violence, nor as any evidence reflecting negatively on the defendant's character. Now, in the instructions regarding the specific crimes, I will refer on occasion to the defendant's intent, which must be proved as part of the element, as part of one of the elements of the offense charged. Intent refers to what a person's objective or purpose is. It is to be determined by you, the jury, from all the evidence and the circumstances developed at trial. Intent is a fact which may or may not be susceptible of proof by direct evidence. If it is not susceptible to proof by direct evidence, resort may be taken by you as finders of fact to reasonable inferences drawn from all the facts as you have found them. And there are two types of intent under the law. There is general intent and specific intent. A general intent is when we do things more or less routinely as a matter of reflex, such as sitting down in a chair or walking upstairs. Those are actions done with a general intent. We would not do them unless our mind resolved to do them, but they don't require any concentration or focusing of the mind. Specific intent, which must be proved here, is the act of concentrating or focusing the mind for some perceptible period. It is a conscious act with the determination of the mind to do the act. It is contemplation rather than reflex, and it must precede the act. Therefore, in the instructions to follow, when I refer to the defendant's intent to kill, or to cause grievous bodily harm, or to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, I'm referring to proof of specific intent, and the Commonwealth must prove the defendant acted as the result of some contemplation and thought, and not as the result of any routine or reflex. Now, one of the most important issues in this case is the identity of the person who committed the crimes. The Commonwealth alleges, and therefore must prove beyond a reasonable doubt, that this defendant was in fact the perpetrator of the crime alleged in the indictment. If you are not convinced beyond a reasonable doubt that the defendant is the person who committed the crimes charged, then you must find the defendant not guilty. Now, identity may be proved by direct evidence, by circumstantial or indirect evidence, and the reasonable inferences flowing therefrom, or by some combination of direct and circumstantial evidence, but it must be proved, as I said, beyond a reasonable doubt. Now, in evaluating the testimony of any witness who either identified the defendant or provided a description of the offender, it is not essential that a witness be free from doubt as to the correctness of his or her identification or description. However, you, the jury, must be satisfied beyond a reasonable doubt, based on all the credible evidence, that this defendant is the person who committed the crime before you may convict him. As with any witness, you must determine the credibility of a witness identifying or describing the defendant. If you conclude that a witness is not telling the truth regarding an identification or description, you shall disregard that testimony. If you conclude that a witness intended to tell the truth, you should still consider the possibility that the witness may have made a good faith error in their identification or description. That is, you should consider whether a witness could be honestly mistaken in his or her identification or description of the defendant or of an offender. Now, understand, human beings have the ability to recognize other people from past experiences and to identify or describe them at a later time, but research and experience have shown that people sometimes make mistakes in identification. Research has focused on the factors that may affect the accuracy of an identification, including the nature of human memory. As I think one of the counsel told you, I would be saying in my instructions, with regard to memory, the mind does not work like a video recorder. A person cannot just replay a mental recording to remember what happened. Memory and perception are much more complicated. Remembering something requires 3 steps. First, a person sees an event. Second, the person's mind stores information about that event. And third, the person recalls stored information. At each of these stages, a variety of factors may affect or even alter someone's memory of what happened and thereby affect the accuracy of their memory or testimony. Indeed, this can happen without the witness even being aware of it. I'm going to list some factors that you should consider in determining whether any identification or description testimony is accurate. And in doing so, I'm not expressing any opinion about the accuracy of any specific memory of any particular witness. You, the jury, must decide whether any witness's identification or description is accurate. Among the factors to be considered are, first, you should consider the opportunity the witness had to observe the person about which they provided an identification or description. For example, how good a look did the witness get of the person and for how long? How much attention was the witness paying at the time? How far apart was the witness from that person? How good were the lighting conditions? Did they observe the person only once or on multiple occasions? You should evaluate a witness's testimony about his or her opportunity to observe with care. You should consider whether a witness saw a weapon during an event. If the event is of short duration, the visible presence of a weapon may distract the witness's attention away from the person's face or features. But the longer the event, the more time the witness may have to get used to the presence of a weapon and focus on the person's face or features. You should also consider whether the person observed had any distinctive features or characteristics. You should consider the physical and mental characteristics of the witness when they made observations. For example, how good was the witness's eyesight? Was the witness experiencing any illness, injury, or fatigue, or under the influence of any drugs or alcohol? Or was the witness alert and focused? Was the witness under a high degree of stress? High levels of stress may reduce a person's ability to make an accurate identification. You should consider whether the witness and the offender are of different races or ethnicities. If a witness and the person identified appear to be of different races or ethnicities, you should consider that persons may have greater difficulty in accurately identifying someone of a different race or ethnicity than someone of their own race or ethnicity. You should consider how much time passed between the event observed and the description or identification given to the police. Generally, memory is most accurate immediately after an event and begins to fade soon thereafter. You may consider a witness's identification or description even where the witness is not free from doubt regarding its accuracy. But you should also consider that a witness's expressed certainty in the accuracy of their identification or description, standing alone, may not be a reliable indicator of the accuracy of that identification or description, especially where the witness did not describe the level of certainty when the witness first gave that description or made an identification. And you should consider the accuracy of a witness's identification or description and the fact that it could be affected by information the witness received between the event they observed and the time they gave that description or made an identification, or information received after they have done so. Such information may include descriptions given by other witnesses, or photographs or media accounts, or any other information that may affect the independence or accuracy of the witness's identification or description. Exposure to such information may not only affect the accuracy of the information provided by the witness, but may also affect the witness's expressed level of certainty and the witness's memory about the quality of his or her opportunity to view the event. The witness may not realize that his or her memory has been affected by such information. An identification made after suggestive conduct by the police or others should be scrutinized with great care. And if an identification occurs after or through an identification procedure conducted by the police, which involves the showing to a witness of a photograph or set of photographs, you should consider whether the witness identified the defendant under such circumstances. Consider all of the factors I have already described about a witness's perception and memory. You should also consider the number of photographs shown and whether anything about the defendant's photograph made him stand out, whether the person showing the photograph knew who the suspect was or could have been, and whether the person showing the photograph could have, even inadvertently, influenced the identification. You should consider that an identification made by picking someone out of a group of similar individuals is generally less suggestive than one that results from the presentation of a single photograph. You should also consider whether the police, in showing a photograph, followed protocols or policies of their police department in conducting an identification procedure that are designed to diminish the risk of suggestion. If protocols were not followed, you should evaluate the identification with particular care and consider whether the failure to follow the protocol affected the reliability of the identification. And you should consider whether a witness ever failed to identify the defendant or the offender, or made any identification that was inconsistent with the identification that the witness made at trial. In evaluating the accuracy of a witness's description or identification, you should consider all of the relevant factors that I've discussed in the context of the totality of the evidence in this case. Specifically, you should consider whether there is other evidence in this case that tends to support or cast doubt on the accuracy of a witness's identification or description. As I instructed earlier, if you are not convinced beyond a reasonable doubt that the defendant is the person who committed this crime, you must find him not guilty. Now, the defendant in this case, as in any criminal case, is presumed to be innocent. And you, the jury, must bear in mind that the law never imposes on a defendant in a criminal case the burden or duty of calling any witness, or indeed of presenting any evidence whatsoever. And this legal presumption of a defendant's innocence is not an idle theory to be discarded or disposed of by you, the jury, by caprice, passion, or prejudice. And furthermore, a defendant is not to be found guilty on any of these indictments on suspicion or conjecture, but only on evidence produced and admitted before you in this courtroom. The fact that the defendant may have been arrested, held in custody, or complained against is not to be regarded as a circumstance tending to incriminate the defendant or creating any unfavorable impression against him. And understand, an indictment is not evidence. The indictment is nothing more than the piece of paper we use in our system to bring the defendant before the court and inform the defendant of the charges that have been made against him. The defendant is presumed to be innocent until and unless you, the jury, decide unanimously that the Commonwealth has proved the defendant guilty of each and every element of the charged offense or offenses beyond a reasonable doubt. In this case, as in every criminal case, the burden of proof is on the Commonwealth, and the Commonwealth has the burden throughout the entire trial. A defendant never has any burden to prove his or her innocence or produce evidence. There is no duty resting on a defendant to prove or otherwise establish his or her innocence. The Commonwealth must prove each and every element of every charged offense beyond a reasonable doubt, and if from the evidence introduced before you, you members of the jury entertain a reasonable doubt, as to whether or not the defendant committed the crimes with which he is charged, then you must find the defendant not guilty. Now, the burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not so easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. And when we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt, again, to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. And this is what we mean by proof beyond a reasonable doubt. Now that completes the first and longest portion of my instructions. Why don't we all stand and take a short stretch break? You two. Now, as I turn to the second portion of my instructions, I'm going to have handed out a chalk. Do you have that, Mr. Sheehan? Well, unless you want to send him his paper airplanes. All right, ladies and gentlemen, let me depart from the written instructions for just a moment to say that what you've just received is what's called a chalk, setting forth the requirements, that is, the elements of each of the 8 separate offenses. So it is to be considered as an outline. It is not a substitute for the full instructions that I will give you, because many of the elements and the terms used in the chart have a specific and particular meaning under the law. So please use that as a guide, but don't let that distract you from listening to the instructions I now give as to the particular charges in this case. Let me turn now to the law as it relates specifically to this case. The defendant is charged with 8 separate offenses. 7 of the charges relate to the events of July 16, 2012. They are 2 counts of murder relating to the deaths of Daniel De Abreu and Safiro Furtado, 3 counts of armed assault with intent to murder relating to the 3 other occupants of the BMW, that is Aquilino Freire, Gerson Lopes, and Rashides Gomes Sanchez. A charge of assault and battery by means of a dangerous weapon relating to the shooting of Aquilino Freire, and unlawful possession of a firearm. The 8th charge is for witness intimidation, so-called, relating to the shooting of Alexander Bradley in Florida on February 13, 2013. Through your deliberations, you must determine whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of any or all of these charges. And you must treat each charge separately, and your verdict as to each charge must be unanimous, although it need not be the same verdict on all charges. Now, as it relates to the 7 charges arising out of the events of July 16, 2012, the Commonwealth has alleged, and therefore must prove, that the defendant personally committed these crimes. It is not sufficient to show that the defendant was merely present when such crimes occurred, nor would it be sufficient to show that the defendant acted in some way, or that the defendant in some way concealed evidence of these crimes after the fact. Now let me start with the crime of murder. Murder is the unlawful killing of a human being. An unlawful killing is a killing done without excuse. Not all killings are unlawful. A killing may be excused, for example, in the case of self-defense or defense of another, or in some cases, accident. The evidence in this case does not raise the issue of whether these killings were excused as the result of accident, self-defense, or defense of another. The burden of proof is on the Commonwealth to prove beyond a reasonable doubt that the defendant, Mr. Hernandez, unlawfully killed Daniel De Abreu and Safiro Furtado. And there are 2 different degrees of murder: murder in the 1st degree and murder in the 2nd degree. The degree of murder shall be found by you, the jury. Through your deliberations, you must determine unanimously if the Commonwealth has proven beyond a reasonable doubt that the defendant that the defendant is guilty of murder in the 1st degree, and if not, whether he is guilty of murder in the 2nd degree. You have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proven beyond a reasonable doubt, which, in the case of murder, is murder in the 1st degree. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of either murder in the 1st or 2nd degree, then your verdict as to these counts must be not guilty. Now let me explain what constitutes murder in the 1st and 2nd degree, focusing first on murder in the 1st degree and then murder in the 2nd degree. And in defining the elements of murder in the 1st and 2nd degree, it must be noted that the Commonwealth does not have to prove that the defendant had any particular motive for these killings. In other words, motive is not an element, or one of the elements, the Commonwealth must prove beyond a reasonable doubt. However, you may consider any evidence that you've heard relative to a particular motive for the killing in considering whether the Commonwealth has proved the defendant's guilt. Now, turning to 1st degree murder. As applicable here, an unlawful killing is murder in the 1st degree if it was committed with deliberate premeditation or was committed with extreme atrocity or cruelty. Here, the Commonwealth alleges that the defendant acted with deliberate premeditation. in the deaths of Daniel De Abreu and Safiro Furtado, and as to Mr. De Abreu, that his death is also first-degree murder based on extreme atrocity or cruelty. Therefore, as to the deaths of both men, you must determine whether the Commonwealth has proved the defendant guilty of first-degree murder based on deliberate premeditation. And additionally, as to Daniel De Abreu, whether the Commonwealth has proved the defendant guilty of first-degree murder based on extreme atrocity or cruelty. Now let me review each of these two theories in turn. Turning first to deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. First, the defendant caused the deaths of Daniel De Abreu and Safiro Furtado. Second, that the defendant intended to kill Daniel De Abreu and or Safiro Furtado, that is, he consciously and purposefully intended to cause the deaths of both men. Third, that the defendant committed the killings with deliberate premeditation. That is, he decided to kill after a period of reflection. Let me review each of these elements in more detail. The first element is that the defendant caused the deaths of Daniel De Abreu and Safiro Furtado. A defendant's act is the cause of another's death, where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant specifically intended to kill Daniel De Abreu and or Safiro Furtado. That is, he consciously and purposefully intended to cause their deaths. As a general rule, you are permitted, although not required, to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm. And a dangerous weapon is any item or object that by its design or by the manner of its use is capable of causing death or serious bodily harm. And I instruct you that a firearm is a dangerous weapon under our law. And the third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that the defendant takes no time to reflect on the action and then decides to do it. And when deciding whether the defendant intended to kill a victim and whether he formed the intent with deliberate premeditation, you may consider any credible evidence that the defendant was in some way affected by his consumption of alcohol or drugs. A defendant may form the required intent and act with deliberate premeditation, even if he consumed alcohol or drugs, but you may consider such evidence in determining whether the Commonwealth has proved these elements. In determining whether the Commonwealth has proved the second and third elements, that is, that the defendant intended to cause death and did so with deliberate premeditation, remember my earlier instruction on intent and specific intent. Now, the second theory of murder in the first degree is murder committed with extreme atrocity or cruelty. And this instruction applies only to the indictment for or regarding Daniel De Abreu. You shall consider this theory of murder in the first degree regardless of whether you find the Commonwealth has proved murder in the first degree with deliberate premeditation. That is, you should consider both theories of first degree as it relates to the indictment pertaining to the death of Mr. De Abreu. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Daniel De Abreu. 2, that the defendant either intended to kill Daniel De Abreu or intended to cause him grievous bodily harm or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. And last, that the killing was committed with extreme atrocity or cruelty. Let me discuss each of these elements in more detail. The first element is that the defendant caused the death of Daniel De Abreu, and again, a defendant's act is the cause of another's death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant either intended to kill Miss De Abreu, intended to cause him grievous bodily harm, or intended to do an act which, again in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. And as to this element, the second element, it has 3 sub-elements which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these 3 prongs beyond a reasonable doubt. The first prong, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant specifically intended to cause grievous bodily harm to Daniel De Abreu. And serious grievous bodily harm means severe injury to the body. And the third prong is that the defendant specifically intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. And let me help you to understand and analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that he intended to perform the act, then you must determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances as known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. Again, in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence.
Welcome back to the LawNewz Network, everybody. I'm Aaron Keller. We've been listening to jury instructions in the Aaron Hernandez double murder case out of Boston, and we're also waiting for testimony to resume in the case against Stephen Edward Jones, who's accused of shooting 4 people and killing one of them on a university campus in Arizona. If you'd like to keep watching the raw stream of the trial, you can go to lawnewz.com and click on the live button right on the very top of the page if you'd like to continue listening to the jury instructions. But here on the LawNewz Network, we're going to bring couple of guests who have been here waiting patiently to see if and when these are going to end, because they might go on perpetually, it seems. But Marie Napoli and David Eisbrook are both trial attorneys, and they're here to weigh in on what's been going on in the Hernandez case. So welcome.
Thank you for having us.
Good to be back. And being back and being here, I think, for the first time, right?
For the first time.
Okay, so it's easy, as David can tell you. We've invited him back multiple times. So what do you think of this case? I mean, we've been hashing around the arguments and the ideas, the openings, the closings. Is there reasonable doubt here? Marie?
Well, I do think that there's reasonable doubt, especially because their star witness has been given immunity. And quite honestly, if it was a drug takedown, then he had a reason to lie, because if it was enough drugs, a felony murder for this star witness. So he's getting something beneficial to himself to testify against the defendant in this case. So that in and of itself gives me reasonable doubt. Plus, just watching the witness on the stand, to me, he does not come off as credible.
David?
I agree with Marie. The case is riddled with reasonable doubt. And in Massachusetts, I think you went over yesterday, Massachusetts law, you can't convict solely on testimony from a witness who is under immunity agreement. There has to be some corroboration. So that was Baez's closing. He was building up the lack of corroboration outside of the testimony of Alexander Bradley. And the last 5 minutes of his closing, he was showing clips of Alexander Bradley, sort of like a life in the day of Alexander Bradley. How many times could he lie while he's on the stand? So, combine that with the fact that your star witness has an immunity agreement. He's a known drug dealer. He's a convicted drug dealer. Tough road to hoe in convicting this guy.
And he's also suing him civilly. Bradley's suing the defendant civilly in his own case. So he has opportunity to make money out of this. So
right, for the shooting when Hernandez shot him, in contemplation of him testifying against Hernandez. Exactly.
Yeah, let's go and listen to the first clip of closing arguments that we had from today. This is Jose Baez on closing and talking about faulty police work to start.
You might get lucky where the police didn't go looking. They didn't go looking for this picture because they knew that they didn't want to go looking. How upfront and honest is that with you? That's not the type of professional police work that we expect. Not anywhere. And they didn't go looking for behind doors that they didn't want to go looking for, because they knew of what they would find. This is why I submit to you that the police actually knew what was going on down there and what actually happened, and knows their famous saying, it's not the truth, but it's not a lie. The rallying around Alexander Bradley and his statements. You remember Detective McIsaac? It's not true, but it's not a lie. It's truthful, but inaccurate. What? How absurd. How stupid does he think we are? It's truthful, but inaccurate. That's what Alexander Bradley is. Truthful, but inaccurate. Because he's their pony. He's their case. He's everything and all they have, all they ever have, and all they ever will have. Because it's not true, but it's certainly not a lie. This is what they want you to believe. This is their case. This sums up the entire investigation as it relates to Alexander Bradley. And you see Aaron walking up by himself. You recall when we played the video, the first guy to walk behind Aaron is a completely different guy, because Bradley's downstairs doing his business. Now here's the thing. Clearly Aaron was out doing other things. Clearly you have evidence of that. While we have suspicions, and how we showed you how it appeared Danny De Abreu recognized Alexander Bradley, that's not our burden to prove. all we can do is point certain things out to you. We know this. We know that Alexander Bradley's a drug dealer. We know nobody crosses Sherrod. And we know what kind of weapons he carries. And we know what kind of life he lives. You live by the sword, you die by the sword. That's Alexander Bradley. What he's doing in that club, the things he's up to, what happens when he gets upset, that's Alexander Bradley. So when you have Aaron coming up, still with the 2 drinks in his hand, he didn't even have the time to finish his drinks. And remember Bradley said, well, they could have been 2 other drinks. Well, wait a minute. You testified to seeing him and him being close to you and going to the bar only once. You recall that he said he might have gotten 2 more drinks in addition to the 2 first drinks that he ordered. And he gives you this whole story about Aaron buying 2 drinks. No, that's Aaron's drink and Bradley's drink. That's simple. And what happens when Aaron comes out of the club? There's no spilled drink on him. There's nothing, 0, to indicate that anything has been spilled on Aaron. The Commonwealth wants to say to you, who are you going to believe? Us or your lying eyes? There's absolutely no proof that anyone ever spilled a drink on Aaron. To the contrary, there's proof of other things happening downstairs, other things that clearly explain and fall perfectly within the timeline. And then some. You go downstairs, walk all the way to the other end of the bar, come back, order 2 drinks, take a picture with a fan, come back, have more interaction with him. All of this makes perfect sense. It's reasonable. It's a reasonable doubt, ladies and gentlemen. From the very beginning of this case, from its inception, its actual core motive is all crowded with reasonable doubt. It's not sprinkled throughout this case. Reasonable doubt lives here. It lives here throughout this entire.
So that was some of Jose Baez's closing argument in this case. And David, you were talking about this clip just a little while ago. Your thoughts upon hearing it for the 2nd or the 3rd or the 4th time?
Well, it's classic, Baez. It's classic, punch holes wherever you can. Every moment of the testimony, you're going to separate what he's calling truth from fiction. His big moment, I think, in that clip is when he took out the photograph that Aaron Hernandez took with a fan in the back room of the nightclub that night. He's trying to paint the picture and lay out the scenario. Here's Aaron Hernandez having a drink. He's very calm. He's having a good time. He allowed a fan to take a picture with him. He walks out on camera very calmly. He separates that from the testimony of Bradley, where Bradley said he had to drag him out of there because he was about to get into a fight. So Baez is very effective there, in my opinion, showing the video footage of Hernandez leaving the club in a very, calm, mannerly fashion, and didn't look too upset at that point.
Marie, your thoughts?
My favorite part was the truth is not the truth. It reminded me of Trump's alternative facts. I think it was a very effective way getting across to the jury that what they're hearing is just not truthful. And that's all he really has to do is poke holes in the prosecution's case. And he's good at it.
Yeah, I thought that the visuals were helpful. The videos that we saw played in the defense closing were interesting and helpful because they point out some of the things that I wish we had the time to edit together here. Discrepancies all over the place between the various witnesses, even within the witnesses. Things that the witnesses could, interestingly enough, not remember. I started working through a lengthy list of all of the things that Hernandez's fiance couldn't remember. She was called as a prosecution witness, but she couldn't remember things that would seem that the average person would remember. I mean, for instance, if a car went missing from my garage, I'm sure that my wife, or when she was my fiance, would have said, "Hey, what happened to that car?" Right. She can't remember asking about it, having a conversation about it, anything. So how do these people wind up on the stand?
If I'm a juror in this case, and I'm going back to deliberate, the only thing I care about, and I said this when I was here before, I believe the only factor that's going to determine the verdict in this case is if you buy Bradley's story full out, hands down, no questions asked. Now, can you do that? Can somebody take a convicted felon under the circumstances that night, with all the surrounding circumstances, with a lack of physical evidence, and convict just on his testimony alone? All these minor discrepancies and inconsistencies, it's window dressing for the rest of the case. You know, Baez is very good at that. He's just painting the windows, and he's getting ready just to land the punch. You and I talked about the fight last time, the prize fight, the heavyweight battle, and he went toe-to-toe with Bradley, and I think Baez won. And I think at the end of the day, he's going to win. And all of this is, as I said, the undercard.
But I think memory is a funny thing. Even if everyone was truthful, there would be a lot of lacks of memory, because memories work different for different people, and you'd be surprised if you ask the three of us of what went on today, the different stories that would come out. So I don't think that the lack of memories is the biggest thing. It's the credibility of the witness.
And I think Baez made that point somewhere in his closing, that the prosecution's witnesses were all lining up with the same story exactly. And to Marie's point, no one ever has the exact same memory of the events. And in law school, they would teach us if there was an accident, if there was an incident, and you had three witnesses, you had three different accounts of the same incident.
Now, how does the jury deal with that, though? Does the jury just sit there and say, well, we believe this to be the way that it went down, and they try to stitch it together in a way that it most closely resembles rather a finished garment? Or do they just say nobody agrees it didn't happen?
No, I think that's how your mind normally works. You have pieces of a puzzle and you put it together the best you can and the best it fits, and then that's your story. But again, here I think the biggest problem, the biggest hurdle for the prosecution is the credibility of their star witness.
So if the jury's trying to piece together pieces of a puzzle, and they say, well, I don't have some of the pieces here, is that reasonable doubt?
The question is, how many pieces are missing? If there are a couple of pieces missing, no. If half the puzzle is missing, yes. They'll fill in the small pieces, you know?
Yeah, well,
what was also discussed by Baez toward the end of his closing is the prerequisite before you get to beyond a reasonable doubt is to basically have the need for a strong possibility of guilt. And he's arguing that they don't come close to that strong possibility of guilt before you even get to beyond a reasonable doubt. And that's where he's leading this jury. That's where he wants this jury to go. The state has the burden to prove it. High burden. In his closing also, I don't think we saw that. He had an exhibit, almost looked like a thermostat, and the very, very top of it, he had that beyond a reasonable doubt, the highest burden there is in American jurisprudence. Those were his words.
I'm curious to know if the jury has any idea of the other murder that he's serving time for, or are these people completely, innocent on that issue, or was it in the newspapers, or is this not really a completely fair trial? Because that would influence my decision, knowing that he had killed someone a year later, 2 years later.
I mean, we hope that the voir dire process wiped that off the map, but did it really wipe it off the map? We don't know.
We've spoke earlier during this trial also about jurors coming in with their biases and prejudices, and you hope that they're all objective, but they're not.
No.
Nobody's objective in that courtroom.
Right.
So.
Yeah, let's listen to another clip here. This is about 1 minute and 45 seconds. Another clip here from Jose Baez on closing argument, talking about the state not digging into enough evidence that would have contradicted Alexander Bradley's version of the events.
Through this area. And you remember Sean McCann, one of the very first witnesses who called 911. Do we have his photo? He testified to seeing Aaron right at the top. He testified to seeing Aaron speaking with two individuals later on that night. That he was with two guys. He couldn't describe whether the person had cornrows or not, but he said something specific. And he said, yeah, I saw him with two people. There's a lot that you don't know because the state didn't go digging for it. We can only do so much coming into the case much later. The state had this case from its inception. They investigated a certain way, and they were not going anywhere that Bradley wasn't taking them. And that's a fact. These 3 witnesses all saw him over by the W right around that time that the missing video won't show you who actually went in that garage. Shadowy figures, looks like what they're wearing, maybe. They want you to squint, like you're looking at a toast with Elvis on it. You know, don't believe the facts, the hard evidence facts. Squint a little, stretch, speculate, and then you'll see our case coming together. That's the Commonwealth's case in this case. That's what they presented to you.
That's the famous toast with Elvis on it quote from Jose Baez. I think that's the first time I've heard that in a courtroom, but he's telling people, hey, the state didn't go digging for enough evidence, and by the time the defense team was assembled, which was quite some time after the crime, at least a year, everything that could have been found was gone.
Right, but that's a common trick that defense counsels, you know, the prosecution has never done enough, the police have never done enough, that this person was railroaded, look at over here, don't look at over here, look at all these people that could have done it. So anything he can do to get reasonable doubt, and I think he did a good job with that. What do you think?
Baez, you know, mentioned the street sweeper, that they never found the street sweeper initially. His testimony was very colorful first time around. He mentioned that the police, that picture that I mentioned before of Aaron Hernandez taking in the club with a fan, he said the police did not produce that. They didn't dig enough. They didn't dig deep enough for that. And basically in his closing, he said that, you know, we're very lucky to be able to prove a negative. And he said we normally can't prove the negative, but now we have a picture of him standing with a fan. What does that prove? He's trying to make a point. He doesn't say what that point is, but basically he just leaves you with the police didn't do their digging. Baez is very good to lead you to a certain point and then leave the question unanswered and say, you know, for the jury, that's for you to decide. That will be for you to decide. But again, he's just trying to, you know, engage and continue the inconsistencies and point to the police not doing their work and not doing a proper investigation here.
And put the question in their mind.
He's very good at that, and he has a way about him, a style in court that comes across as reassuring in ways, but also, you know, David, you've called him say this is a prize fight. He's a prize fighter.
He is, and I told you last time he's the champion. He won the championship with Casey Anthony, and anytime he goes up against a star witness, you know, he's going to have the upper hand. And I think I said the last time I made the analogy, how do you beat the champion? You knock him out. Bradley didn't come close to knocking him out. Bradley barely at some point stayed on his own feet, and he got knocked back, in my opinion, pretty often.
And he talks in a way that's very easy to understand to the jury. He doesn't like talk above them, or he talks right to them in a way that they can understand. I think he's likable, and I think they're really listening to him.
Baez is a street guy who came from the street,
right,
who dropped out of high school, had a child early in life, went into the Navy, came out of the Navy, got his GED, got into college, must have done well in college, went to law school. This guy is a survivor. He came out of the streets. He knows how to relate to the streets. My only issue with him in this case is, could he relate to a Boston jury, not being a local guy? And I think he's done a fair job.
I think so too. At first I was a little bit hesitant. I wasn't quite sure if he would be able to pull it together, but I've been surprised. And I give him respect because of that. The way that he has lined up the evidence and the way that he handled Bradley. I remember him questioning Bradley about not wanting to be a snitch, and then he just goes, well, what are you doing now? And he said it with that tone that just was... It was friendly from the perspective of the jury, but it was combative from the perspective of the witness.
But he has to be able to relate to criminals because they're his clients.
He can do it without being one. So, kudos to him. He's doing his job well. So let's listen to another clip here. This is where Jose Baez really starts talking about the prosecution strategy. He said that they tried to throw everything at the wall and just see what sticks.
That takes us to West Palm Beach. Now, I submit to you, ladies and gentlemen, there's a whole lot in Florida that you don't know about. And I think based on the way this case was presented, they tried their best to throw more. The whole strategy is let's throw everything against the wall and see what sticks. What do they get you? What do they bring you first? They bring you a druggie. Someone who admittedly tells you, I was completely partying that entire week, and those days were mushed together. He didn't want to come forward. There's a lot going on in Florida, ladies and gentlemen, where Alexander Bradley specifically told you that he can't recall 2 of the 5 days he was down there. He can't account for it. What does that mean? I can't account for 2 of the 5 days I was down there? He's doing what he does. This individual, I really don't know what he contributed. He had an interesting fashion. Drives a Jaguar, doesn't have a job. I think these 2 birds of a feather. And then he shot a month later. He shot a month later. And you'll recall, these guys, they're Deontay Thompson's friends. Sometimes people rise above and become successful. They don't forget where they came from. Many times, when you're successful, you realize and you recognize that your past struggles and where you come from define who you are and are really the core reason why you're so successful. We take adversity and turn it into sometimes something positive. But we don't forget where we came from. And we don't forget people where we came from. And Mr. Thompson is just one of those individuals, just like that. There were 15, 20 guys at night, each of the nights at Tootsie's Lounge. Contrary to what Mr. Bradley told you. Mr. Gargars, the VIP guy, knows who Aaron is and remembered pretty vividly of both nights that they were there. Mr. Hagan tried to trip him up. Was it a Monday, Tuesday morning, Thursday? No, he remembered each night and remembered that Aaron doesn't have, VIPs and celebrities, they don't have to pay to go up in the next level. And you saw that in Cure. That's because these bars, these clubs, they want celebrities in their bars because it's advertising. It's a celebrity endorsement of their product. And they want them there. And these 5 guys, not 4, for which Bradley testified to, you know, at what point, when the facts start contradicting Mr. Bradley, at what point do you send that meal back? How many cockroaches do you need in your food before you send it all back? I submit to you, all you need is 1. All you need is 1 reasonable doubt. Especially when Judge Locke is telling you, listen with caution and great care. This guy has an incentive. And all of this is lies. He's lying to you about how many guys are there, who's there. Deontay told you they had like 4 or 5 guys, 4 or 5 cars going there. You have no idea how long Bradley was at Tootsie's. You know his phone was returned, despite the fact that he lied about that. And there are phone records of him calling. There are phone records. Now you can't, you're right, you can't place, I take that back. You can't place a person behind a phone. But his excuses to you is, I didn't have my 2 phones. But there are phone calls. And one person is telling you, one person without a dog in this fight, who hasn't seen Aaron Hernandez in 3-4 years, had limited interaction with him, is telling you, we gave that phone back. But this man is telling you otherwise. Who are you going to believe? The drug dealer or the manager at Tootsie's? This is another person coming forward and giving you a conflict in the evidence, a conflict in what Mr. Bradley is telling you. Lies from beginning to end, ladies and gentlemen. Lies from Boston to Florida. But they're going to ride him. They're going to ride him all the way home. Come on, Rocky. He can't even give you his nickname right. This guy's calling him Rock, but oh, he's Rocky. Little Rocky. He just can't tell you the truth because he's a parasite. He's here, he's got an incentive, and he's lying all over the place. They can dress him up, put his $500 designer shirt on that he didn't work for. We all have to get up sometimes and go to work. People have to get up and go to work even when they don't want to, even when they're not feeling good, even when they just don't feel like it. But this man can prance around with designer shirts and not earn a penny. He's a career criminal. The last 14 years, but now he's got a legitimate trucking business that he's running from jail. We've cleaned him up. He's got a nice Burberry shirt on. The glasses are a really nice touch. Really nice touch.
So that was Jose Baez earlier today on closing arguments in the Aaron Hernandez double murder case from Boston, and he's really bashing the witnesses, saying, hey, how does a guy wind up getting a Jaguar without having a job? How does a guy sit here and wear designer shirts without having a job? And he just said that Alexander Bradley was a parasite and a career criminal.
You know, that's his job, to bash the witnesses against him. But I really think what he did really well here was the imagery, that he talked about the cockroaches in the food and the parasite, and he was riding the horse. I mean, these are the things that the jury's going to go back and they're going to remember. You remember with O.J. Simpson with the if the glove doesn't fit, you must acquit. And those are the things that resonate. You know, sometimes the details are lost, but they'll think back and they'll remember those big things and say, yeah, that was a cockroach, that was a cockroach. Yeah, you only get one cockroach in your meal, you send it back. So I think that he did a very good job in getting points across to the jury in a way that they're going to remember. And he also did the repeat, reiterate, and restate. Liar, liar, liar. That's another way to put it in the jury's mind. So, you know, he's getting his message across.
This is an important part of the trial, which relates back to the shooting of Hernandez shooting Bradley at this point. So he needs to discredit all of the witnesses who are testifying about that shooting, because if the jury believes that Hernandez shot Bradley, then they're more likely to convict. So Baez needs to distance that testimony of Bradley being shot, not being Hernandez. And he's doing that through all these witnesses who are not credible, who are career criminals, who are cockroaches, like Al Pacino said.
So let me ask this. Let's say the jury discounts most of what Bradley says. Could there still be a conviction here?
Of course. You never know what a jury's going to do. That's the bottom line. I mean, you should always try, if it's possible, to work it out. I mean, I would never want anyone that I know to be in that position. So if, even as an innocent person, you'd want to try to work it out, because you never know what's going to happen.
And to Marie's point before, when she talked about whether the jurors know about Hernandez's prior conviction, you don't know what's going on in the jury room, the deliberations. They probably started this trial, some of them thinking, why is he even on trial if he's already convicted the first time? And I would think that at least some of the jurors know he's been convicted. And the answer to that question is that his first trial, his first conviction, is up on appeal, so the prosecutors want to make sure they have a backup plan. But getting back to the present deliberation, some people may be thinking, well, you know, it's going both ways. He's already in jail. We convict him. What does it really mean at the end of the day? He's in jail for life anyway.
Right. But the truth is, you're really going to be winning the case in jury selection, because these jurors do bring in their biases. So you put on the best evidence, and they find some kind of minute thing that no one ever thought of, that they focused into to prove the way that they're going to vote. But it's really because of their preconceived ideas So it's scary if you have someone like that on your jury. So you never know.
And some of them may be focusing in on that tattoo on the side of his neck that says Lifetime, which is one of his newer tattoos, you know.
Yeah, I mean, and we've got the issue about the tattoos. We've litigated it about 20 times around this table on top of the multiple times it's been litigated in the courtroom. So, you know, maybe somebody on the jury says, okay, look, you know, I'll discount half of what Bradley says, but I'll believe him on the other, you know, 2 or 3 grains in there, and then tie it together with the tattoo artist, and then you know, the fiance found a gun, and then the ballistics match. But I've been really worried about the ballistics because they keep saying that the marks on the bullets that were recovered from the murder scene match the bullets that were fired by this gun that was found a year after the murder in the trunk of a car a couple hours away from Boston. And yet my own research, what limits, however limited it's been, into the accuracy of that ballistics testimony has indicated to me that it's not horribly accurate.
Right.
The prosecution wasn't even going to enter it as the gun, you know, that was used in the murder. You know, it came in basically through a back door and an inadvertent stop of this woman that made some reference to, you know, being with some football players, and then they pieced it together, then all of a sudden that's the murder weapon. And I don't even think that's the murder weapon the prosecution was going to be using during the trial. So, Aaron, I think you're right, exactly right.
Yeah, and I'm sorry, I was distracted a little bit because I was looking at the feed from the courtroom, and I'm wondering if we might want to go back to that for a second because I think they're pulling the you know, the numbers out to see who's actually going to deliberate. You know, deliberate here. So let's listen to this for just a second.
Juror number 264, sitting in seat number 12. Juror number 80, sitting in seat number 5. And juror number 69, sitting in seat number 4. Each of you have been designated alternate jurors. You will be kept separate and apart from the deliberating jury and in the custody of the court officers until further order of court.
All right, ladies and gentlemen, I'm going to suspend my instructions now. Tomorrow morning, I will explain to you the verdict slips to be used, and we will have the exhibits ready to be sent up to you, and the 12 deliberating jurors may then commence their deliberations. Please understand that jurors can deliberate only when all are assembled and sent up as a group to deliberate. You cannot have private conversations among select jurors. You can only discuss this case during your deliberations as a group. That's a way of saying between now and tomorrow morning, I again impose the cone of silence on all of you, both deliberating and alternate jurors. Please don't discuss this case. Don't read, hear, or see anything about this case, and don't attempt to learn anything about this case on your own or outside of court. We will adjourn now until tomorrow morning at 9 a.m. for the final portion of these instructions.
Okay, folks, so that was the remainder of the selection process in the Aaron Hernandez trial in Boston. That was the fanciest barrel that I think I've ever seen used in a courtroom to select the numbers of the jurors who will not deliberate.
It looks like one of the original ones.
Right? it must go back to when the British Crown was still in power in Boston or something.
What it looked like.
Something like that. So well, there was a historical note. So I'm glad we were able to watch that. But 12 jurors were deliberate. They pulled the 3 alternates out. And interestingly enough, the judge, who usually breaks at around 4 p.m., kept going today. It's about 4:20 on the East Coast here. And he's suspending the jury instructions until tomorrow. So there's going to be more of this. He's got to explain the verdict slips tomorrow morning, and then finally the jury will get the case. I've just not ever seen jury instructions go on that long.
I think it's a good idea, actually, in this circumstances, because they've been sitting all day with closing arguments and then the jury instructions. This at least allows them go home, get a good night's sleep, wake up, come back, get very brief instructions, and then start deliberating the beginning of the day for a full day.
And also the notoriety of this case and being on TV, and this judge doesn't want to make any mistakes. He's going to put everything in the kitchen sink that could be applicable to this case. So that's why it's going so long.
You don't want reversible error on something like jury instructions.
Right.
Some of the evidentiary calls have been interesting in this case. The tattoo came into evidence after a lot of argument. I could see potentially that being an issue for appeal, and there were a few other issues about the street sweeper that were argued pretty heavily as to whether or not he should have been questioned more thoroughly by police and then disclosed in a different manner to the defense. The defense tried to turn that into a potential appealable issue. In my opinion, it was a weak one because they learned of the street sweeper not independently, but rather through police documents. He just wasn't a major piece of the police documents.
Right, right.
So let's listen to another clip here of the closing arguments from today. This is Jose Baez using his famous Oprah Winfrey analogy.
And then this guy testified about a gun that he loaned to Deontay, but took it back before the shooting ever happened. They flew this guy from Florida to come here and tell you that. And they're giving all of them immunity. They're handing out immunity in this case like it's candy on Halloween. Mr. Hagan's the next Oprah Winfrey. You've got immunity. You've got immunity. We all got immunity. Everybody's got immunity. That's not how you build a case. That's not how you present a case. You're not the Oprah Winfrey of immunity. It's absurd. It flies in the face of reality. It doesn't even pass the laugh test. But they will come here and put a man's life in the balance because he's an NFL football player. That's a nice conviction. That's a nice thing to have.
Well, Jose Baez said that didn't pass the laugh test, but we all giggled. So, he's animated, but he makes a point.
He makes a good point. He's very animated, and I think the jury's eating it up. I mean, we were eating it up. And he does make a point about the immunity. Why should all these people be getting immunity except to give favorable testimony? It really does fly in the face of a fair trial. What do you think?
That's a pretty strong statement. David, do you agree? Flies in the face of a fair trial?
Going to come down to whether the jury believes Bradley. That's it. At the end of the day, I don't think they care if he has immunity or not. They just believe him, they're going to convict. They don't believe him, they're going to acquit.
But it gives him reason to lie. It gives him reason to lie, you know? If he has the immunity, then he's... Listen, they don't give immunity to people willy-nilly. They want to know that they're getting the story, and this is not supposed to happen, but they want to know that they're getting the story they want from that person. And they only give them immunity if they're going to say what they want to hear.
Well, correct. However, in Baez's cross, he spent a lot of time with Bradley explaining to him in question form that you understand that if you lie, your immunity agreement is out the window.
Correct. But the truth of the matter is, when you give immunity, you're buying the person's testimony.
You know what the proffer is. You know what you're going to hear. Absolutely. Then it's a question for the jury whether they believe him or not.
Right. I agree.
Yeah, so we have no clue how long the jury will deliberate in this case, but I would assume that it's not going to be a simple in the door, he's guilty, back out, because these jurors have been sitting with one another for a month, more than a month, I think. And I would walk in the room and just say, okay, folks, it's nice to finally meet you, or something like that. It's just been lengthy. And
the same token, I would not be surprised if there's a verdict tomorrow.
They may have
I
already,
could see that. I could
they
see
may
that.
have
I'm
already
sorry.
made up their minds. You know, very often a jury will come back very quickly if they've and if it's been a long trial because they've already made up their minds. The problem is that won't happen if they've made up their minds differently. Then it'll be a long, drawn out.
Do we know what's needed to convict here of the 12 jurors? I don't know if that's been discussed.
In what sense?
How many jurors do they need?
I thought the judge said it had to be unanimous.
Is it unanimous in Massachusetts on the 12?
Yeah.
Okay.
So we'll see.
Could see tomorrow.
I mean, it'll be really interesting to see if in that room they get in and 6 are saying acquit and then 6 are saying convict, and then it could be a lengthy battle behind their doors.
They bring out James Stewart for the 12 Angry Men and they see if they could be converted.
I'm dying to see what the jury looks like. That's all. I'm dying to see.
You know, I will let slip a piece of information from the past that when the Stephen Avery jury was deliberating in Wisconsin, which became Making a Murderer, there were a group of people, I was not part of it, but who actually watched 12 Angry Men in the media room while waiting for the jury to come back. But so don't make me relive it. But
however, to the viewers and in the chat room, I'm sure that none of them know what we're talking about with 12 Angry Men.
You know, somewhere on DVD I have the old black and white version of that, and I watched it once and I thought it interesting, but haven't watched it again. So maybe I should put it on eBay. But you know, let's talk about the Stephen Jones case because we're waiting for them to come back into court here. So well, let me back up for a bit. Let's talk about what else is going on here. So Hernandez is wrapped for the day. The judge is going to come back tomorrow and finish with the instructions for the jury. He has to explain the verdict slips. They did narrow the 12 jurors who will deliberate by pulling the numbers out of a barrel of those who will be selected as alternates. They're separating them out at this point and coming back tomorrow to talk about the verdict slips and then go on and allow the jury to start deliberating. So Hernandez is all done for the day if you're just joining us, but we're waiting for the Stephen Edward Jones trial to resume in Arizona. He's the one that's accused of 7 counts, one of which is first-degree murder, the rest of which are aggravated assault charges for shooting 4 people, killing one of them right on the boundary of the Northern Arizona University campus. And we heard on the stand this morning one of the people who was shot and survived. He testified into the afternoon and talked about exactly what he witnessed from his perspective. But I want to go back to yesterday, because yesterday is when we saw the opening statements in this case. And if we thought Jose Baez was a soundbite machine, today we had attorney Amon Barker trying this case in Arizona. He was his own soundbite machine. Let's listen to some of his opening statement.
The defendant, Stephen Jones, murdered a young man and seriously injured 3 others because his pride was hurt. In the early morning hours of October 9th, 2015, the defendant was confronted by a group of college students, and he was punched 1 time in the face. Instead of punching back or walking away altogether, the defendant went to his car to get his gun, a fully loaded .40 caliber handgun, and then he went another 90 feet back toward that group to shoot 4 unarmed college students. Now, these college students were Nick Peering, Nick Prado, Kyle Zentek, and Colin Brew. The defendant shot Nick Peering twice, once in his arm and once in his hip. He shot Nick Prado once through his neck. He shot Kyle Zentek twice in his back as Kyle was running away. Now, miraculously, these 3 victims survived. Sadly, Colin Brew did not survive the defendant's rampage. The defendant shot Colin twice in his torso, lacerating vessels to his heart, causing massive internal bleeding. Colin died within minutes after the defendant shot him. Now, before this night, none of these victims knew the defendant, never associated with him, didn't know him to like him or dislike him. But that night, to the victims, the defendant was an assassin emerging from the darkness, and they had no chance to protect themselves before the defendant unloaded 10 rounds from his gun and changed their lives forever. All this because the defendant wanted payback. Now, ladies and gentlemen, during this trial, you will learn that what the defendant did was not an accident. It was not self-defense. This was aggravated assault, and it was premeditated murder. Now, earlier that night, the defendant and 3 of his friends decided to go to a party off campus, off NAU campus, Northern Arizona University. And the defendant's 3 friends that night were Shay McConnell, Jacob Mike, and Hunter Todd. All of them were freshmen at NAU, all of them newly pledged members of the Sigma Chi fraternity. Now, the defendant was driving that night, and he and his friends to this location. This is a 2-scale diagram, you'll see this during trial, of the parking lot where the defendant parked his car, and ultimately the area where the defendant shot the 4 victims in this case. The defendant parked his car here, and then he and his friends walked across the parking lot and up Franklin Avenue toward an area called the Grove, where the party was at. Now, at the Grove, like many college parties across America, there was alcohol, and some of them had some drinks, but nothing excessive. And at around 1 a.m., the defendant's 3 friends walked back down Franklin Avenue the same way they had come, across this area near the courtyard. Now, the courtyard was a location that right across the street from Mountain View Dorm, just off NAU campus. And at around that time, there was another party, a separate party occurring at the courtyard. Now, the courtyard housed a number of members of the Delta Chi fraternity as well as the Sigma Chi fraternity, the same fraternity the defendant and his friends had recently pledged to. Now, the courtyard also housed 2 of the victims in this case, Colin Brew and Nick Peering. Well, at this party at the courtyard, just like the party the defendant attended, there was alcohol. And you'll hear that the victims in this case all had quite a few drinks that night. You'll also hear that none of them were in a particularly bad mood that night. In fact, the party was pretty uneventful. At around 1 a.m. that morning on October 9th, this party was winding down. People were leaving the party or were just about to leave. It was at that point that the defendant and his 3 friends were nearing the courtyard area, coming down Franklin Avenue. And one of the defendant's friends, Hunter Todd, decided to leave the group and go into the courtyard to visit some friends. Now, he didn't tell the others exactly where he was going, and so the defendant, Shay McConnell, Jacob Mike, his 2 other friends, stayed outside of the courtyard area on Franklin Avenue, tried to get a hold of Hunter, didn't know exactly where he'd gone. And as they waited outside that area, Jacob Mike, one of the defendant's friends, had an idea that he thought would be funny, which was to go knock on the door to one of the houses in this courtyard complex.
All right, folks, testimony has resumed in the Stephen Edward Jones trial in Arizona, so let's go straight back to the courtroom live.
Yeah, so I'm from the Phoenix area, and I'm a senior here at NAU, studying exercise science, wanting to be a physical therapist.
Okay, what year are you in school right now?
This is my 4th year. I'm a senior.
What year were you in October of 2015?
I was a junior.
All right. Where did you live at that time?
Mountain View.
Is that a dormitory?
Yes.
Is that a dormitory that's exclusively Greek, or can you explain that a little bit?
Yes, so in the past it's been exclusively Greek, and I think this is the first year they're opening up to other students.
Okay, so how is the building divided up by floors and wings and sororities and fraternities?
Yeah, so each sorority gets a different wing, and yeah.
Okay. Which floor were you living on in October of 2015?
The 3rd floor.
All right. Do you remember the room number?
Yes, it's A300A, I believe.
So A refers to the wing?
Yeah.
And did you have your own room, or did you have roommates?
I had a roommate at the time.
What was her name?
Victoria Campbell.
All right, Jalen, I'm going to ask you about the events of the early morning hours of October 9th of 2015. Do you recall that date?
Yes.
At approximately 1:20, 1:30, what were you doing?
I was asleep.
That's AM. So you were sleeping at the time?
Mm-hmm.
All right. Was there something that happened?
Mr. Champ, sorry. Ms. Kunkel, I'm going to have to ask you to answer all the questions either with yes or no, so that we can clearly get your answer down.
Okay.
Thank you, Your Honor. I apologize. So you were sleeping. Was there something that happened that woke you up?
Yes, I heard arguments and shouting from outside in the parking lot.
Okay. Did you have your window open or closed? Do you know?
No, it was closed.
All right. Was that something strange to you?
There's always arguments or loud noises coming from the parking lot. It's very loud, especially on the weekends, but this was a little louder than usual. Not normal.
This was like a Thursday night, though, right?
Yeah.
So that's a weekend?
Yeah, well, Thursday night until Sunday, I guess, or Saturday.
Why is that?
That's mostly when people go out to party and stuff.
Okay. So on this night, it woke you up, and do you remember anything specific that was being said, or was it just noise?
I don't remember anything being said.
Okay. Did you have to get out of bed in order to look out the window, or?
No, my window was directly my bed was directly facing the window, so I just had to roll over in bed and look out the window.
Okay. So when you looked out the window, what did you see?
As I was turning around in my bed and looked out the window, that's when I saw the first gunshots and two guys fall to the ground.
Okay. All right, so you heard noise, it woke you up, you rolled over, looked out, and you saw gunshots immediately?
Yes.
So you didn't see anything that was happening prior to that?
No.
Did you know immediately that they were gunshots, or what was your response, or what did you think at that moment?
No, I thought they were fireworks at first. I didn't realize they were gunshots, and as I looked out the window, I thought it was a flashlight. I didn't realize it was a gun at first.
Okay. Did you continue watching, or what happened?
Yes, I continued watching.
In addition to seeing the shots, what else? Did you hear things?
I don't recall anything being
But you
said.
did hear shots?
Yes.
Okay. So I think you kind of trailed off when you said what happened immediately after the gunshots.
Oh, I just saw two people fall to the ground.
In succession, one after the other?
I
do you
can't
know?
recall that, yeah.
Okay. What happened next, Jalen?
And then there were more people kind of standing around, and there was, I think, more arguments being said, and then the people standing around lunged and I think threw a couple punches at the shooter, and then that's when the second round of gunshots
All right.
went.
So, just to be clear, you just saw the shooting, you saw two people either go down or on the ground.
Yes.
And then there were other people there that were arguing with the shooter?
Yes.
Are you able to estimate how many?
I'd say maybe 3.
Did you hear anything that they were saying or what the argument was about?
I wasn't listening to that.
Did you see anybody approach the scene go towards anybody that was on the ground?
Yes, so I saw a girl run out of nowhere and approach one of the guys that was on the ground and started putting pressure to his wounds.
Was anybody else trying to approach the victims or approach the shooter?
Not other than the guys that were standing around already.
Was the shooter saying anything? Did you hear him saying anything?
The only thing I can remember him saying is, "I didn't mean to." That's the only thing I can remember.
Did you make any observations of the two guys that were on the ground besides the girl who approached? Anything about how they were acting, moving, not?
One of the guys wasn't moving. The guy that was unattended wasn't moving very much.
Very much?
At all.
So did, prior to whatever interaction or physical interaction succeeded that you just told us about, did you see the shooter do anything else before that? Did he approach anybody on the ground?
Yes, he was near the one of the victims that wasn't moving, and sort of, in a way, pushing the, not physically pushing, but so the other guys wouldn't get to him.
Get to whom?
The first guy that was on the ground, the first victim. The guy that wasn't moving.
Okay, let me see if I understand. The shooter approached the guy who wasn't moving?
Yes.
And was keeping other people away?
Yes.
How so? Was he saying something, or?
Yes, he was just saying, stay away, keep back, things like that.
Okay. Did you hear anybody who was arguing with the shooter? Did you hear anything that they were saying, any questions that they posed?
I don't recall.
Okay. So now let's talk about so you talked about a physical confrontation with the shooter.
Yes.
Okay. How many people were involved in that?
I can't specifically say. I want to say 2 or 3.
Okay. And what did they look like they were trying to do?
From what I saw, it looked like they were, well, they threw a couple punches at him. I think maybe trying to get the gun away, or trying to get him away from the guy that was laying on the floor.
Okay. Did he go to the ground? Did anybody go to the ground?
Not that I can recall. He was in a squatted position, the shooter, and then regained his control.
Was there any obstruction between you and the scene that you were looking down upon from your building?
No.
Could you see, was there enough ambient light? I know it was at night, right? So it was dark outside? Was there enough light for you to be able to see what was going on?
Yes. I don't recall the shirt colors or anything like that, but.
So you talked about the shooter kind of going into a squatting position, but he didn't go to the ground?
Not that I can recall.
And what happened next?
He stepped back and regained control of the gun, and that's when he shot the second round of shots at the people.
When you say regained control of the gun, did somebody else have the gun, or did you know what was going on with the gun?
No, he had it the whole time, but when the other people that were standing around threw a couple punches at him. He obviously wasn't in full control of the gun. He was kind of taken back, I think, and then stepped back a few steps and got re-control of the gun and shot again.
Okay. Did you see him fire the gun the second time?
Yes.
And can you describe for the jury his posture when he fired the gun the second time?
I don't recall his posture.
Was he standing? Was he still squatting?
He was, I believe he was standing.
Okay. Did his arm come up? Can you tell us anything about how his body was situated?
I don't recall.
Okay. Do you know where those shots went to, or what?
So to me, it looked like he just kind of did a quick scan of the gun, and it hit two people. I didn't see them go down or anything, but they said, I got shot, and then ran off, and I couldn't see them anymore after they ran.
Okay. You actually saw two people get hit?
It was dark. I couldn't really see that. I just heard them say that and ran.
Okay, so you heard two different people say that they got shot?
Yes.
All right. So I want to go back to, you said he scanned and you used a little body motion. Are you recalling how he was holding the gun, or?
I don't recall how he held the gun.
Okay. But there was a period of time in between him regaining control of the gun and him shooting?
Yes.
Can you estimate that period of time?
A few seconds. There wasn't much time. But
what about the guys who had gone for the gun? Were they still in his immediate proximity, or had they moved away, or do you recall?
No, they were in his proximity.
Okay, how close to him were they?
A couple feet, I'm guessing. I don't know exactly.
Okay, only what you recall, Jay.
Okay.
Okay, so just to be clear, after the gun came back out, those guys stayed near him?
Yes.
Okay. What were they doing?
So after the gun came out, and they kind of, as what I can recall, they kind of stepped back a little, and that's when the second round of shots were fired.
Could you tell if it was, okay, so you didn't see him actually, you didn't see the people get hit though, you just heard them say they got hit and run away?
Yes.
All right, what's the next thing that you recall happening, Jalen?
So those guys that said they got hit ran away, and then there were sirens, and the shooter put down his gun and then lifted up his hands and ran to the police that showed up to the scene.
Okay, did he run to the police before they arrived, or did he run to them after they arrived?
I don't really recall because it was out of my vision. I couldn't see the police cars. I just saw him running.
Did you see flashing lights, or?
Yes.
You could hear the sirens?
Yeah.
And that was before he put the gun down?
That was after. He put the gun down first and then ran.
And then you heard the sirens? I guess I'm trying to, which happened first, the sirens or putting the gun down?
So I heard the sirens first. coming to the scene, and then he put the gun down in the rocks.
Did you see any change in demeanor for the shooter in that time frame?
Yes, he seemed kind of in a panic mode, kind of like not pacing back and forth, but you could kind of see.
Well, describe what you saw if you can, Joe, then.
I can't 100% recall that scene.
But it was a change in his demeanor from prior to that?
Yes.
Did you see anybody else approach him prior to putting the gun down?
Yes, I recall, believe 2 people that came out of nowhere, and I believe they were like trying to convince him that he had to turn himself in and to put down the gun, and that's when he did that.
Could you hear that conversation?
I recall him saying, "You have to turn yourself in."
Okay, when you say him, this is one of these other guys?
Yeah, one of the random guys, I don't know who it was, but someone that came to the scene.
Okay, so somebody who had not been out there before who came out?
Yes.
Can you estimate, if you can, how long that conversation between those two, the random guy who came out of nowhere and the shooter, prior to him putting the gun down?
I want to say very, very briefly. I don't remember how long exactly.
Did you think that this whole thing was a real thing, or what were?
No.
What did you think you were seeing?
As I said, I thought the gunshots were fireworks at first, and I thought the shooter was holding a flashlight. I didn't realize until I saw the guys laying on the ground and not getting up that it was a real thing.
Did you see any of the official response, the police response, or anything like that going on?
Yeah, so I saw the police come in and tell everyone to get on the ground, everyone that was there, and they handcuffed people, and I saw them take people, I saw them separate people and take them in different directions and talk to them individually, but I saw one policeman trying to do CPR on one of the victims that was on the ground, and he performed CPR for a little while, but then went to the ambulance and got a sheet and covered the body. So
all right. So you really didn't see any of the interaction prior to the shooting, is that right? And was it just in the instant before that woke you up?
Yes.
I mean, did it take you any time to wake up and look out the window?
Yes, it took a little while, but only a few seconds.
All right. The 2 sets of shots, are you able to estimate for the jury the amount of time kind of in between the 2 sets of shots?
I want to say about a minute.
Okay.
or so.
Let's see. And do you recall how many shots you heard in each of the two clusters?
I don't recall.
Okay. Was it more than one in each of the two clusters?
Yes.
Jalen, do you know any of the guys that were involved? Or let me ask you this way. At the time that you were looking out the window, did you know anybody that was involved out there? Did you recognize anybody?
No.
Okay. Have you since discovered that you know anybody?
Yes. Kyle, he's one of my best friends, family friends. But
Is he one of your best friends or?
My best friends, family friends.
Okay.
So I know of it. I don't know him personally.
You're not close to him?
No.
Okay. If I may have a moment?
Sure.
Jalen, we're going to, with the permission of the court, project the True View Leica scan. I'll ask you to just direct your attention to the screen. There's a pointer, like a laser pointer on the desk in front of you. Jalen, do you recognize what it is that we're looking at here?
Yes.
Can you just, using the pointer, point out what we're looking at?
Yes. So Mountain View, and then the parking lot, and then this is the crime scene in this area where everything happened.
Now, looking from that perspective, are you able to determine which one of those windows is yours?
Yes, so my window is this one right here.
Okay. Can we, I'd like to look up this. So we're going to change our perspective a little bit. And of course, it was nighttime when this was happening, right?
Yes.
And what we're looking at here is daytime, right?
Yeah.
But you've indicated you could still see.
Yes.
Now, there's no obstruction or anything that you can see that's in between your window and the scene that you were looking down upon, correct?
Correct.
Can we move up to this one? All right. Now, ignoring the yellow cones, all right, Jalen?
Okay.
All right, there you go. What are we looking at here?
Just the sidewalk in front of Mountain View, and then here's the parking lot.
Okay. Now, the best you can do, I'm going to ask you, and just, again, just do the best that you can.
Okay.
But I'm going to ask you if from this perspective you can point out to us essentially the locations where you were seeing things happen. So when you first looked out there, where did you see the guy with the flashlight?
I saw him about right here.
Okay.
Or even maybe, yeah.
Go ahead. What were you going to say?
I was going to say even maybe a little farther back, like right here.
Okay.
Around this area.
Did you see him move before the shots, or was he stationary?
I didn't see him move before the shots.
You did not?
I did not.
Okay. I'm just going to again ask you to, now I think because we've turned you towards the screen, you're a little further away from that microphone, so it's hard to hear you. All right. And so as far as you recall, that's where he was standing when the shots occurred?
Yes.
And where did you see the two guys? Did you see them actually go down, or did you just see them on the ground?
I saw them go down.
Okay, and where were they?
One was right here, I believe. It's kind of hard to see, but, and then the other one was, I think, for here.
Okay. So you're familiar with this area that we're looking at, right?
Yes.
In that first section where you said the one was right here, that's like a rocky divide between the sidewalk and the parking lot?
Yes.
And is it fair to say that you indicated the second one was in the parking lot in the striped area?
Yes.
Okay. Did you see them moving before the shots were fired or anything like that?
No.
Can you describe, if you can, if you took note of this or if you recall it, how many other people were on that sidewalk or what the rest of the sidewalk or parking lot looked like, if you know?
I want to say there was maybe 3. No. A couple people, 4 or 5 maybe.
Okay.
But that's about it.
So there was not a crowd?
No.
And amongst those people that you did see, however many, 3, 4, or 5 people, were they in a, when you first looked out, were they in a cluster? Were they spread out along the sidewalk? What can you tell us about that? If you can.
I don't recall that, how
Okay.
they were positioned.
All right. And after the shooting, did they move? Or did they stay in the same place? Where were they?
The first shooting?
Yes.
They moved. As I recall, they took a few steps back, like what, maybe thinking like what just happened. And then a little time passed and then they threw a couple punches at the shooter.
So those guys took a couple of steps back before that engagement?
As what I recall.
Nothing further at this time, Judge.
May I approach, Your Honor?
Yes.
Thank you.
Okay, so we'll get to that in just a moment. I just wanted you to have it before we get going.
Okay.
So you said that you heard some fighting or shouting, yelling going on out there. And
Yes.
that's what woke you up, right? Yeah. The first shots?
Yes.
So you didn't see anything that happened prior to those first shots?
Yes.
When you were just describing the position of people, that was after the shots?
Yes.
From that moment going forward, did you ever divert your attention? Did you ever get out of your bed or go anywhere?
No.
You sat in your bed the whole time and watched?
Yeah.
Okay. Now, let's go ahead and turn to that transcript. Let's go to page 4. And the very first line, the officer asked you if you had heard yelling out in that parking lot previously in other nights. And your answer was yes, but nothing that would have woken me up. This yelling was more like an emergency or like urgent. It was different than the rest.
Yes.
then a little further down, you said that it all seemed like kind of a blur, right?
I'm sorry, Judge.
Let's direct you to line 20.
I'm not sure if this is inconsistent statements or what the basis for referring to the transcript is.
Verify that this was all sort of a blur to you. Would you agree? We don't necessarily need to refer the transcript. I'll strike that.
All right. Can I see counsel up here for a second?
Yeah, okay. Not necessarily referring to the transcript, just in general. I know it's been a year and a half since this happened, and there's certain things you've said you can't recall now. But even at the time that you gave this interview to the officers, would you agree that a lot of this happened so quickly that it was kind of a blur to you?
Well, I don't want to say a blur because I saw what happened, but I did just wake up from being asleep. So at first I was trying to get all, I don't know, like unfogged, wake up.
Okay. But then that's why I'm referring to your transcript here on page 4, line 20. You did tell the officer that it was all kind of a blur and you couldn't really recall, right?
I don't see that,
You
but
specify the line, please.
It's line 20?
on page 4,
Yes.
it's not what I have on mine.
Let's make sure we're on the same page here, okay?
Ms. Kunkel, what's the exhibit number on?
You have exhibit 33, right?
Yes.
Okay.
What exhibit number is that? You see the green sticker right there?
Oh, yes, 33.
Okay. Okay, I'm going to strike that. We're going to back up. Let's go back to page 4.
Okay.
Now, you told us today that it definitely was more shouting than usual.
Yes.
But what you told the officer was, and I'm referring to line 2 there, you said that it was super violent because the parking lot is usually really noisy anyway on the weekends.
Yes.
So it wasn't just louder than usual, it was super violent in the way it appeared to you when you first heard it, right?
Yes.
And you went further. On line 6, you said it was like terrifying, like screaming, right?
Yes.
Okay. Now, you said that it was just a few shots. It wasn't continuous shooting, right?
Yes.
And specifically, there were sort of 2 separate moments of shooting.
Yes.
But you don't recall exactly how many shots.
No.
Now, you told us today that you did see some individuals throwing punches at the shooter, right?
Yes.
Okay. Now, I'm going to direct your attention to the, like, you still have the pointer there?
Yeah.
Yeah, does that view work for you? Is that, we can get rid of the cones for you. Okay, so this is the view we were just looking at, right?
Yes.
Okay. Now, you told us just a moment ago that you felt like the shooter was, you pointed your light, if I'm right, yeah, the second hash mark.
Right here.
Right.
Yeah.
That's where you saw him after you heard the first round of shots?
Yes.
And then you said that the group of individuals backed up?
Took a few steps back.
Right. And you don't recall today exactly how many?
I don't
people,
recall.
but they backed up. And then you saw these individuals punching the shooter, at least a few of them, right?
Yes.
Okay. So when you say backed up, where did you see them back up to?
Not very. They only took like 1 or 2 steps back. They didn't back up all the way over here. They were still.
So they
around
were
here.
this group of individuals that you saw after the shooting. They were all on the rocks,
I don't recall where exactly they were standing.
but you saw them take a couple steps back,
As I recall, yes.
and then you see them throwing punches at the shooter.
Yes.
Okay. So, did they run all the way to where the shooter was, or
No, as I recall, the shooter was leaning over the body of the first victim that was on the ground, and they sort of lunged at him at that point and threw the punches then.
okay? So he walked up to where the gravel is.
Yes.
Did you see him do that, or you just noticed that now he was there?
I just noticed that now he was there.
Okay. And so they're not that far apart when these guys start punching him?
Yes.
Okay, okay. And I take it you didn't count how many punches, right?
I don't recall that.
But it was more than one?
Yes.
And it was more than one person punching him?
Yes.
And you saw him at least go down into a squat?
Yeah.
Okay. And they're still punching him while he's going down?
I don't recall that part of it.
But eventually he's able to regain his composure, get away from them. They're not punching him now.
Yes.
And you see him stand up.
Yeah.
Now, at that point, you saw him shoot the next round of shots?
Yes.
Okay. But you didn't see him aim at anyone, right?
No, not directly.
Is that what you're referring to when you say quick scan?
Yes.
Okay. And it was just a quick burst of shots. He didn't just keep shooting, right?
Yes.
And from there, you saw him. What did you see from that point after those next round of shots? You saw, you didn't see anyone actually get shot, right?
No, I just heard them.
You heard some people say, I've been shot.
Yes.
Did you see those people run?
Yes.
So did you see 2 people run that were yelling they were shot?
Yes.
Where did you see them run to?
If we're looking at it this angle, they are running at us. So along the sidewalk.
So you didn't see them get shot, but you heard two individuals say they were shot, and you saw both of those individuals running along the sidewalk as if they're running towards us right now, as we're looking at this? Am I getting that right?
Yes.
Okay. So, looking at this from this view, we can see it looks like a van way out there in the back. Is that Franklin Street?
Yes.
Okay. They weren't running that direction?
Not that I can recall.
You saw two individuals yell they were shot and start running as if they're running into this courtroom from that screen.
That's what I can remember.
Okay. How far did you see them run?
Not that far. My room didn't allow it to me look out that far.
So point to where your room is there.
It's this one.
Right there. Okay, so from there, you can't see that all the way down this sidewalk?
No.
No? Okay. So they ran out of your view?
Yeah.
Both of them?
Yes.
Neither of them went to the ground on that sidewalk?
Not that I could see.
Okay. Now, did you watch where Stephen went after that second round of shots? I'm sorry, you don't know his name. Do you see where the shooter went after those second rounds of shots?
Yes.
Where did he go?
As I can recall, he just stayed in the parking lot. He didn't move much.
Okay. So, can you point to where you recall him being after the second round of shots?
I want to say like in this area.
But still in the parking lot?
Yeah.
Now, it's okay if you're not certain.
Yeah.
You're not guessing, are you?
No, I can recall him in the parking lot. I just can't point out where exactly.
But you saw him put the gun down?
Yes.
Where was he when he put the gun down?
Gun. It's in the rocks over here.
In the rocks?
Or around this area, right over here.
Okay. So he had backed out of the parking lot.
Yeah, at that time.
And then, after he put the gun down, it was moments later that he ran towards the police?
Yes.
Was that all in your view? Were you able to see him go all the way up to the officer?
Not all the way up to the officer.
You just surmised that he was running towards the officer?
Yes.
How did you come to that conclusion?
I saw the lights, and I saw the lights come closer and the sirens get louder and louder.
So you could tell that it was coming from Franklin?
Yes.
And that's the direction he ran?
Yes.
Okay. Have a moment here. So I just want to be clear again about directions you saw people going, okay? When Stephen was going towards the officer, you saw the lights flashing and you knew that was Franklin, so he went towards Franklin to go to the officer. Is that accurate?
Yes.
No further questions, thanks.
Redirect.
A few more questions, Jalen, if you'll indulge me.
Okay.
So when you use the word violent when you were interviewed by the police,
Yes.
were you referring to physical violence or why don't you describe what you were?
No, I was just violent, I don't know, language, violent, just voice, I guess.
So you didn't see any physical violence besides the shooting?
Yes.
And the subsequent punches?
Yes.
But those punches came after the first set of shooting, is that correct?
Yes.
And whatever yelling you heard was within what, can you guess how long the yelling or the what you described as violent or yelling before the shooting?
I don't know. That's just what woke me up initially.
You indicated to counsel that the shooter was leaning over one of the guys who went down.
Yes.
Leaning over, like, still on his feet, though?
Yes.
All right. He didn't kneel down?
No.
When you discussed the scan and when counsel asked you about the scan, he was on his feet. Is that fair to say?
Yes.
Okay. And you didn't say, you said that he didn't take aim, but can you describe to the jury how the gun was pointed or which direction?
It was pointed towards Mountain View, towards the victims, towards everyone.
It was level though, right?
Yes.
Wasn't pointed up?
Not that I can recall.
Good. No further questions, Judge. Thank you.
All right, I'll turn to members of our jury and see if they have any questions for Ms. Kunkel. It doesn't appear that we do. Can this witness be excused?
Yes, Your Honor. Thank you.
Ms. Kunkel, thank you for your testimony. You are
Thank you.
excused. All right, folks, let's go ahead and stand at recess for about 10 minutes. Please remember the admonition. All right, folks, see you in 10 minutes.
Welcome back to the Law News Network, everybody. I'm Aaron Keller. I'm your host this afternoon, and we're listening in for testimony to resume in about 10 minutes in the murder trial of Stephen Edward Jones. He's accused of shooting 4 people, killing one of them just on the fringe of a university campus in Arizona. I want to go back to some of the testimony we heard this morning in this case. An officer, Matthew Haiti, who was one of the first officers to respond, and I'll get this frog out of my throat while you listen to that.
Admitted to being the shooter?
Correct.
Was there any action taken by yourself or that you observed other officers with regards to the young man who was lying in the rocks?
Yes. Initially, as I said, we were trying to get control of the scene. Once we had that control, we began to render aid. At that point, another officer who was on scene made the comment that it appeared that that subject was not breathing. And so one of the Flagstaff police officers began to perform CPR on that subject. After a short time, that officer relayed that he actually had a trauma pack with him secured in his vest. We made the determination that it would probably be better for him to use the contents of that trauma pack on the second injured subject there. And so he removed that trauma pack and went to render aid to the second subject, and I took over chest compressions on the unconscious, not breathing subject in the lot.
Did you also make efforts to get EMTs or medical personnel into the scene?
We did, yes, as quickly as we could.
But that requires securing the scene first, is that correct?
Correct.
So what did you do? You're just relaying information over the radio, indicating security of the scene and what you're observing?
Correct, yeah. I was providing information to Officer Park, attempting to ascertain whether or not he had that, the scene was safe, and he did relay that he had that subject in custody. At that point, I did relay that we needed medics to our location first, as we had a subject who was not breathing, and I believe that was the highest priority in terms of medical treatment at that time.
As you were providing chest compressions or CPR to that individual, did you make any observations indicating injury?
Yes, I did observe what appeared to be a gunshot wound to his right chest area.
Shortly after that, did medical personnel take over your efforts?
They did.
And they were from where?
The Flagstaff Fire Department.
What did you do at that point?
At that point, knowing that from what we knew, we had the scene secure, and I believed it was probably good to start setting up a perimeter at that time and dealing with the crime scene. I ran back to my vehicle, which again was parked at the intersection of roughly the Mountain View Drive and the Mountain View Service Drive. I ran to my vehicle and then drove it a little bit closer to the scene and activated my emergency lights to try to start creating a little bit of a barrier to secure that crime scene.
Did you ultimately learn the name of the individual you tried to help?
I did, yes.
And what was that name?
Colin Brew.
At some point in time, you were given information about his status, is that correct?
That is correct.
Do you recall approximately what time?
I believe it was approximately 01:35 hours.
And what was that status?
The Flagstaff Fire Department informed me that he was deceased.
And what did you do?
At that point, I went and obtained a blanket from the rear of my patrol vehicle and placed it over him, just because of the large number of people that were outside and the fact that there's several windows that face that.
That was some of the initial testimony from one of the officers who secured the scene after the shots were fired. Let's listen to more of that officer's testimony and listen to him describe some of his body cam footage.
Jewish. Okay. Okay, that kid looks like he quit reading. Are you guys witnesses? No. Okay, I got you. He's still conscious. So I got one here with a gunshot wound to the chest. Have them check out the person first. But we got him coming in, we just cleared him. We're on the service drive. Oh no! Are you big? No! Are you big? For now, and then we get to call and see how we get a chance. Just stay there.
So that was some of the footage from one of the responding officers' body cameras right after the shots were fired and police showed up to the scene just on the fringe of the NAU campus. We're waiting for testimony to resume. We were told that court was on about a 10-minute break, and that should be wrapping up very shortly. While we're waiting, let's replay a clip from Nick Peering, who was one of the victims who was shot and survived in this attack. He was the first victim to testify, and he testified earlier today.
Okay. And what about Colin's voice caught your attention?
Well, he was the only voice I recognized, and since I said I lived with him for the past 3 years at the time, I heard his voice and I recognized that he was in a verbal argument with other individuals.
Okay. Now, were you part of any type of confrontation occurring in Franklin Avenue in the street?
No, I was not.
Do you recall anybody knocking on a door and you exiting that unit?
No, I do not.
So you were outside of the courtyard area in the parking lot when you heard Colin's voice?
No, in between the two buildings in the stone pathway, if you will. Not the parking lot, but adjacent to it.
All right. And did you investigate what was going on?
I did.
So where'd you go?
So at that point, like I said, I went into the parking lot of Courtyard, across the grass towards Franklin Avenue, across the street into the driveway that separates the Mountain View parking lot and the dorm.
And what did you see as you approached that direction?
At that point, I saw Colin talking to three individuals, yelling back and forth, three individuals and him, and they had proceeded to just yell at each other verbally and a lot of chest puffing, I guess, if you will.
Did you see anybody punching anybody?
No, I did not.
Anybody kicking anyone?
No.
Anything physical at all?
Nothing physical at all.
Did you see anyone with weapons at that point?
Not at that point.
Later on, did you see someone with a weapon?
I never did see the gun. I only saw the flashlight.
Okay. So did you approach that interaction?
I did.
And were you running, walking?
Jogging. Up until I reached, until I saw Colin fall, and at that point, I sprinted and jumped over the bushes that you had pointed out earlier on the scene.
Okay. And let's take this just a step at a time, Nick. I know it's, I know we want to talk about what happened, but let me just take it a step at a time with you. As you're walking up or jogging up, as you described, did you see anyone else in the area besides Colin and these three other individuals?
I did not, no.
Did you recognize these three other individuals?
I only recognized Colin.
Do you recall what Colin was wearing that night?
I don't recall.
Okay. Do you recall what anyone else was wearing of those three people you talked about?
I do not.
As you were jogging up, did you hear what was being discussed?
A lot of derogative terms. Would you like me to express them?
Sure.
It was a lot of "fuck you, you guys," me to leave, and then from their end, it was basically, you guys can't kick me out, blah, blah, blah. And just back and forth, a lot of cussing, calling each other more derogative terms.
At any point, did you hear someone say, "I'm going to kill you"?
I did not.
Or "I'm going to hurt you"?
I did not.
It was words to the effect of "get out of here"?
Yeah, and
then the profanity?
Profanity, yes.
Okay. As you got closer to what was going on, what did you see happen?
At that point, Colin was still talking to those three, or yelling with those three individuals. And I noticed, and I guess he noticed at the time, a flashlight coming from the Mountain View parking lot, which would be the west side. And at that point, he turned from...
Okay, folks, we need to cut away from the replay clip that we had there of the earlier testimony of one of the victims who was shot in this case, because court is resuming.
All right.
So let's listen back in
The
live
prosecution
to
would call the next witness,
proceedings
please.
from Arizona.
Thank you, Judge. The state calls Valerie Pabon.
You solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God, or do you so affirm? Thank you.
Go ahead, sir.
Thank you, Your Honor. Good afternoon.
Good afternoon.
So I'm going to just go ahead and ask you to make sure you're speaking into the microphone and make sure that everybody who's sitting here can hear you, okay?
Okay.
Can you state and spell your name for the record, please?
Valerie Pabon, V-A-L-E-R-I-E, P-A-B as in boy, O, N as in Nancy.
And I said Valerie Pabon, and it's Pabon, so
Pabon,
I apologize
It's
for
okay.
that.
Everyone messes it up.
Can you tell us a little bit about yourself, Valerie?
I am a junior at NAU. I was born and raised in California.
Where in California?
Glendora, California, by like Pasadena, kind of.
Okay. Are you an NAU student, or were you?
Oh, yes, I am a NAU student. I'm a junior, full-time student.
What are you studying?
I'm studying communications with an emphasis in PR and advertising.
What year were you in October of 2015?
I was a sophomore.
And where did you live?
I lived in Mountain View Hall.
Mountain View Hall?
Mountain View, let's just say Mountain View. I don't know if it's called Hall, I don't know.
All right, is it a residence hall?
Yeah.
Okay. And that's, you were living on the sorority, your sorority's wing of that hall, is that correct?
Yes.
All right. Do you recall the room number? It's okay if you don't.
I don't.
I'm
sorry.
Do you recall which floor you were on?
The third floor.
Third floor? Okay.
Yes.
Valerie, I'm going to direct your attention to the very early morning hours of October 9th of 2015. Do you recall that time frame?
Yes.
Shortly after 1 o'clock, or in that approximate time frame, can you tell the jury where you were?
I was in my room with my roommate and then my suite mate, one of my suite mates.
Who were they?
With their names?
Yes.
Paloma and Kayla.
Okay. And what were you guys doing?
We were crafting for our littles in our sorority.
What are littles?
They're like girls in younger like grades than us that we kind of like mentor, I would say, kind of.
All right, so younger girls in your sorority?
In our sorority, yeah, that we like take under our wing, and they were all in the same sorority, but like it's like big sister, little sister kind of deal.
Oh, I get it. Okay. And so you were crafting, like making?
Yeah, I was making her crafts.
Okay. Was there something that occurred in roughly that time frame that caught your attention?
Yeah, when we were making our crafts, I heard yelling outside, and so I went and looked out the window, and there was just a bunch of boys outside arguing with each other, and which is not really uncommon for Mountain View. There's always like yelling outside
Okay.
at nighttime, so I didn't think anything of it.
You didn't think of anything of it, but you looked out the window anyways?
Yeah, just because nosy, I guess.
Okay. Can you, and roughly, I said roughly that time frame. Do you have a better time frame for me? Did you look at the clock or have an idea what time it was?
No, I didn't.
All right. So you heard the yelling, and when you looked out the window, what were you looking down on?
The boys.
Okay. What area?
Oh, on like the big sidewalk thing, not the parking lot, but the sidewalk closer to the building.
Okay. You said the boys. How many, was it, well, why don't you describe what you saw?
Okay. So I saw two groups of boys, roughly around 6 or 8, somewhere around those numbers. I'm not exactly sure.
Total?
Yeah, total.
Okay.
And there's two groups arguing with each other. And then two of the boys kind of got it more heated with each other, but then the friends separated everything. So one of the groups started walking back, walking away. I think they both kind of started just like the friend just separated it, and it kind of was, I thought it was going to end, like, okay, everyone was going to go home. But then, so one of the groups was walking back towards the courtyard.
Okay.
I don't know what street that is.
If I said Franklin Street, would you
Yeah,
agree?
Franklin Street. Yes, Franklin Street. And one of the boys, what I recall, is one of the boys in, not the group walking to Franklin, the other group, yelled something. I don't know what they yelled, I didn't hear, but obviously it didn't make one of the other boys happy. So one of the boys in the group walking to Franklin Street ran back to him and shoved him. And then all the other friends came running to like either stop it or get involved. I'm not sure.
Okay. Just to be clear, so we're talking about two groups, and you said that they were separating?
Yes.
So one headed maybe towards the track side of Mountain View?
Yeah.
One group?
Yeah.
Can you estimate the number of people in that group? To the best of your recollection.
I don't want to say a wrong number.
That's all right. If you don't recall, that's
Yeah,
okay.
I don't recall.
All right, but it was more than one person?
Yes, more than one person.
And the other group was headed back towards the Franklin Street direction?
Yes.
How far away would the two groups get before one said something that caused a response from the other? To the best of your ability. I know you weren't measuring, but.
Maybe like 4 or 5 yards, I think.
5 yards, so.
Maybe more than that.
Okay.
I don't want to say something wrong.
Well, in a minute, we'll bring up a kind of a view of the area, and maybe I'll re-ask that question.
Okay.
Did you hear what was said?
I did not.
Okay. But it was definitely something that was said from one group towards the other.
Yes.
And that prompted a response from how many of the members of the other group?
What I recall is one individual.
All right. What do you recall about that individual, if you recall anything? Any description you can give the jury?
I want to say he was wearing a red shirt.
Okay.
That's about it. That's all I recall.
All right. And you said he went back and pushed somebody from the other group?
Yes.
Okay. I just want to be clear about what you're talking about. So, something was said from over here. One person came back from over here. Did these guys stay where they were? Did they come back in the direction of the first group, or what can you tell us about that?
I don't really remember.
Okay. So, but in any event, somebody from this group, the Franklin Street side group, closed that distance and pushed somebody from the other group.
Yes.
Do you remember anything about the person that was pushed?
I think he was wearing a white shirt.
Okay.
I didn't see faces very well, but
Just whatever you recall.
okay.
Just the shirts? Or you recall anything else?
I think the guy in the white shirt was Colin.
Okay. Ultimately, you determined that, or you knew that at the time?
At the time, that's what I thought at the time.
Did you know Colin?
I did not.
Okay, so I guess what I'm trying to ask you is, did you identify this person in the white shirt as Colin Brew at the time?
No, I saw him in the white shirt, and then later I saw that same boy on the floor.
Okay, all right. So you think that one of the guys that ended up on the ground was involved in that, for that interaction?
I do. Yeah, yes.
So you described a push. Was there any other physical confrontation between those two people or the other?
I didn't see any fists being thrown or anything like that. It was it was more them running up, all the boys running up, and then it kind of just, I didn't see any fists thrown.
Okay.
It didn't seem like it was going to get that big of a deal.
I'm sorry, what
Didn't seem like it was going to be that big of a incident.
Okay, it didn't seem like a big deal to you?
Yeah.
Okay. And so after the push, did they just argue with each other, or what happened?
I don't remember.
Okay. Now that interaction right there, was that any different? I mean, did it sound any different to you than any other given Thursday night in front of Mountain View?
I mean, yeah, I haven't really seen a whole outside of Mountain View, it's usually just yelling, people being intoxicated or something like that, just yelling, but I haven't seen an actual people going at each other, I guess you would say.
Well, again, just to clarify what you mean by going at each other.
What's the word? Pushing each other, I guess. I really haven't seen that year. I mean, I only lived there that 1 year, so I haven't seen that at all.
Okay.
There.
All right. So you've described what you saw up until that point. Valerie, can you tell us what happened next?
So after that, it was honestly it seemed like I just blinked my eyes, and I guess it was kind of, yeah, it just seemed like I blinked my eyes, and then someone had a gun. And when I saw that and I heard the gun go off, it didn't really put it together. I didn't really think it could be real. I thought maybe it was a BB gun or something. And then when I saw someone hit the floor, sorry. After that, I was just okay, this happened, so I ran to my RA's room just to see, like, just to tell her what's happening, you know, and she could get, like, the call officers or whatever. So I ran to her room.
I'm gonna
Okay.
just step back.
Yeah, okay.
Because I need you to describe what you saw, Valerie. I know it's difficult, okay? And take your time. But, well, let me step back just a little bit further. So after the push, how long until you saw a person with a gun?
Probably like, I don't know. I don't know.
Okay. Longer than a minute? Less than a minute?
Yeah, longer than a minute.
Okay.
I would say longer than a minute.
And what were these guys doing in that minute? Just jawing back and forth? If you recall.
I don't recall.
All right. Do you remember hearing anything said in that time frame?
I don't think so.
Okay. But were things being said that you just didn't hear what was being said?
Yeah, there was like yelling,
Okay.
but I couldn't make out any of it.
All right. All right, so push and then yelling and then maybe a minute or more than a minute passed. And then tell the jury what you saw, Valerie.
I saw a boy holding a gun with a flashlight of some sort. I don't know if it was on the gun or like an actual flashlight being held in the other hand. So I saw that, and then I remember the boys that were there after it was like he was there with the gun, and then all of a sudden, like, I blinked and shots were fired. And then what I recall is the boys that were there it seemed to me that they backed up and they were just like, what are you doing? Like, this isn't, like, what's going on? Like, this is not real life. Like, kind of like that. And that's when I ran to the RA.
Okay. So you heard shots.
Yes.
Can you estimate the number of shots that you heard?
No, I don't remember.
It was more than one?
More than one.
Did you see the shots?
I was looking while that happened, but I didn't see, like, I couldn't tell you where the gun was being pointed or not. It kind of all just happened.
Okay. And then you said the boys. So what was it that you saw?
The boys that were there, that were a part of the earlier altercation, were all there, and they all were backing up, what it looked like to me, backing up, and I heard one of them saying, what are you doing? What's going on?
How many were on the ground, if any?
At that point, I believe there were 2 on the ground.
You described could you actually see the gun? You could see the gun?
Yeah.
Okay.
Well, I saw the flashlight, because there's obviously like a big light coming out. I don't know if I saw the like actual, like the look of it or anything like that.
Did you see the shooter?
Yeah, I saw the person holding the gun, but I couldn't make out a face.
Okay. Did you see his posture?
I don't recall what it was.
Did you hear him say anything?
No, I didn't. I kind of, I don't know, it just all just happened, and it just, yeah, I mean, if he did say something, I didn't hear it.
Besides that person with the gun, did you see anybody else with any weapons?
I did not.
Did you hear anything about the cops or somebody saying, out there, somebody talking about calling the cops? What did you hear?
Yeah, I heard the boys that were backing up saying, "What are you doing?" I heard them saying, "We're gonna call the cops." And so I heard some more talk about that after I went to my RA.
Okay.
When I came back, should I go on with my story?
Well, okay, so you heard somebody say, "We're going to call the cops"?
Yes.
Did you hear any response to that?
I heard him, I remember him saying, "Okay, call the cops. Call the cops." But I don't recall if that was before I went to the RA or after I came back.
So, with regards to the people that were on the ground, did you notice anything about them before you went to talk to your RA?
Yeah, I noticed the one boy, one of them was not moving, and the other one was struggling to move.
So then you ran to your RA?
Yes.
And what's an RA?
An RA is like someone who, I don't know I forget, like resident assistant, something like that, who lives in the hall and kind of works in the front desks at some shifts and like keeps the hall kind of under control.
So just kind of an older student who keeps an eye on everybody?
Not necessarily older, but just someone who the school has like.
They're in residence.
Yeah, they're responsible people who.
All right.
Yeah.
So that you went looking for that person.
Yeah, I went to her room, which was like a hall away, because there's 3 halls.
I'm sorry.
Sorry, there's like 3 different halls in the one wing that we lived in, and she lived in the second one, right around like a couple of rooms down from me. So I ran to her room and knocked on her door.
Okay, what happened next?
She didn't answer, so I assumed she wasn't there. So I called the police, and they didn't answer. It was beeping, so the line was busy. And then I went back to my room, and then like a bunch of girls were in my room just crying.
Okay. So other girls had come into your room? Because there was just the 3 of you in there before, right?
Yes.
So other girls had come into the room?
Yeah, there was a few other girls that came into our room just to be like, "Did you hear?" like kind of stuff. But yeah.
And everybody was upset?
Yes.
What happened next?
I looked out the window, and at this point, I heard people like below me, like maybe that lived below me, like their windows open, yelling like to the people who were out there, saying like, "Hold down the wounds, we're calling the cops," just kind of yelling things to help them in any way.
Did you hear, was the shooter still out there when you looked out there?
Yes.
Where was he?
I think he was, if I recall right, he was standing in the parking lot, like but close to the sidewalk. He was just kind of standing there.
Did you hear him say anything?
I don't remember.
Okay, that's fine. And again, in a minute, we'll bring up the scan and you can describe the areas that we're talking about, but how far, just for now, how far away from the 2 men that were on the ground was the shooter, if you recall?
I don't recall.
Okay. What do you remember happening next, Valerie?
I remember
May I approach your arm? Sorry. Just tissues. Do you have tissues up there?
yeah, there are,
Oh.
sorry. Yeah. So after I got there, I looked, he was standing there and it just kind of looked like he didn't know what to do, and no one really knew what to do, and the cops arrived shortly after I looked out the window after I got back from my RA. And right when the cops got there, he went on the floor like everyone else did and listened to what they said.
Okay. So when you looked back, did you hear any additional shots after that first?
I didn't, because
Okay.
I was with my RA, or trying to get my RA in the hallway.
And when you looked back out the window and you could see the shooter standing there, did he still have the gun? Do you know?
I don't know.
Did you see the flashlight again? Does that
No, I
ring in?
did. I
Okay.
didn't see the flashlight again.
And it wasn't until the police got there that he reacted in some way?
Like reacted by like going onto the floor, like.
Whatever his reaction was. If you
no.
recall, Valerie.
I remember looking and him kind of just like not really like just being like kind of just like I just did this, like what did I just do, kind of. It looked like that's how it looked to me.
Okay.
And then the police got there.
All right, Valerie, I'm going to back up just a little bit. So we talked about the guy in the white shirt.
Okay.
And you
Yeah.
think that was the young man who ultimately passed away?
Yes.
All right. Now, he was involved in that pushing?
He was, I don't know if he pushed back, but he was involved. Yeah, I don't know if he pushed back, but I mean, I don't want to say something I don't know.
Okay. What about the other boy? Was he involved in any of that interaction at all? The other boy who you saw on the ground?
No, I don't believe he was, but I wasn't there, like down there, so I don't know what was going on.
From your point of view?
From my point of view, I don't think he was.
Your voice trails away a little bit.
Sorry. From my point of view, I don't think he was. The other boy who was struggling to move, I don't think he was involved in the pushing.
Before the gun came out, Valerie, did you think that this was a really serious or life and death situation?
I did not.
You've seen guys get into shoving matches with each other before, right?
Yes.
Did you think that the use of a weapon was likely or necessary?
Objection, Your Honor. Salazar.
Sustained.
May we approach, Judge?
No. It's irrelevant, too.
Well, I guess that's what I wanted to discuss.
I understand.
All right. The All right, in a moment, we'll go to the Leica scan, Valerie, but fair to say you didn't hear anybody talking about killing anybody or threatening to kill anybody, is that fair?
I did not hear that.
Okay. With the court's permission, may I publish the Leica scan, Your Honor? All right. There might be a laser pointer up there, Valerie?
Yeah. Yes.
Can you indicate to the jury what we're looking at here?
The scene of the crime? Or
Is
Mountain
that
View
Mount-
Hall? Yeah,
is that
okay,
Mountain View
yeah.
Hall?
Yes, that's Mountain View Hall.
All right. From this point of view, are you able to identify which window was yours?
Yeah, that one.
All right, so that's the fourth one in from the left
Yes,
on the third floor?
yes.
And when you were observing all of this happen, was your window open or closed, or do you recall?
I think it was at least cracked, but I'm not sure if it was all the way open or not.
Okay. You think it was open a little bit?
Yes,
All right.
because I heard yelling,
All right.
but I couldn't tell you if it was all the way open or not.
All right. All right. Valerie, can you describe to the jury what we're looking at here?
That's the sidewalk thing I was talking about, where all the boys were when I first looked out the window when I heard yelling.
All right. And from this point of view, and let me know if from this point of view you can't answer the question, and we'll try another point of view, okay?
Okay.
But from this point of view, can you tell me how far the group that was heading back towards Franklin, how far in front of Mountain View they got, or how far down this sidewalk they got?
Maybe like right there. Like the end. Can we look at a different point of view?
Sure.
I don't know if it's going to help.
All right, so now would you agree we're looking the opposite direction down the sidewalk?
Yes.
All right, maybe, is that any better? Are you able to answer the question from that point of view? And if not, let me know. We can try another one. Okay.
Okay.
All right. I think we're back to where we started. Are you able to
Yeah, I think that's probably.
answer the question from that point of view?
So I would say probably like right there.
Okay. And where would you be able to tell us where the other group was before the yell that led to the...
Like right there,
Okay.
possibly. I'm not exactly sure,
Okay.
but those are my best guesses.
All right, Valerie. And again, let me know if you can't answer these questions from this point of view, but can you tell us from where you were looking where the shooter was when you first saw him?
Oh, I can't answer that. I don't remember.
You don't remember?
I don't remember.
Okay. Are you able to tell us where the young men who got shot were immediately prior to the shots?
I believe one of them was right there. I can't remember where the other one was.
All right. And did you see anybody moving immediately prior to the shooting?
Just people backing away.
Immediately prior to the shooting?
Yeah.
Okay. If I may have a moment?
Sure.
Nothing further at this time, Judge.
Mr. McKellen?
Good afternoon.
Good afternoon.
You might have already said it, but just to clarify, what room were you in?
I don't know the exact number. I was on the 3rd floor, fourth room in.
Okay. And we'll go back to that in a moment to clarify that. Okay. So, when you first look out the window, you already see these two groups walking away from each other?
No.
Okay, what did you first see when you looked out the window?
When I first looked out the window, I saw them right next to each other, and they were all yelling at each other. I don't know what they were yelling, but they were all yelling at each other pretty close to each other.
And you think there was about 6 to 8 guys total?
Yeah, roughly.
But you don't know how many on each side?
No.
Now, you had heard a lot of yelling, right?
Yes.
You couldn't make out everything that was said, right?
Right.
So it's possible there could have been people yelling curse words at each other, and you just didn't make out exactly what was said, right?
Right.
Before those first shots, you didn't hear the shooter say anything?
I didn't know.
But he could have said something, you just didn't hear it?
Yeah, I couldn't really make out what anyone was saying.
Let's go ahead and pull up the likeness. We'll stick with the view that you're most comfortable with.
Okay.
Okay. So if you can use your pointer and just clarify, which window are you looking out of?
That room.
That one.
Yeah.
And that window's closed as we see it in that picture, right?
Yes.
Okay. But you think that at the time you were looking out, it was open?
I think it could have been.
But you're not sure?
I think it was at least cracked. I don't 100%, I can't 100% tell you which it was.
Okay, now we see that tree in front of that window. Is that obscuring your view at all?
No, because the walkway is a little farther away, so I could see right over it.
Okay. So you're seeing the two group. When you first look out the window, where do you see that group of guys?
They're almost directly under my window, so one was about right there, and the other one was like right there. It was all they were all like right in that proximity.
And that's that group of 6 to 8 guys that you're referring to?
Yes.
So that's on the sidewalk? Those guys were all standing on the sidewalk?
Yes.
They exchanged some words, but you don't make out what anyone says, right?
Right.
And then they start to separate?
Yes.
You see a group of guys start walking towards Franklin, right?
Right.
And if you can use your pointer to just sort of show the direction they were moving.
That way.
Okay. The other group, were they starting to walk away too, or were they still standing there?
I don't really recall that.
But you recall somebody from that group there on the sidewalk yell something to the group that was walking away towards Franklin.
Yes.
And after that, somebody from that group ran back and shoved the person who yelled something?
Someone from the group walking away.
Turned around and ran back and shoved somebody?
Yes.
Okay, but you don't recall what anyone said at that point?
No.
but somebody was saying something. You clearly heard yelling, right?
Yeah, I heard yelling.
And then all of the other guys that had been walking towards Franklin came running back,
Yes.
and did they surround the guy who had yelled something initially?
No, it looked to me as they were running back to stop whatever was going on, or just like, yeah, to stop whatever was going on.
To stop the guy who was pushing?
Just to stop the fight from happening again.
Okay.
Or the arguing.
Okay, do you remember giving an interview to the officers shortly after this all happened?
Yes.
Did you have a chance to review that in preparation for your testimony today?
Yeah,
You did?
I did.
Okay. All right. I'm going to give you a copy. It's Exhibit 62.
You with the lights back on?
Yeah. Yeah.
Yes.
Take a look at that, confirm that's a transcript of the interview you gave the officer?
Yes, it is.
And that's something you also had reviewed in preparation for today?
Yes.
Okay. So I want to direct you to page 2 of that transcript.
Okay.
And we'll actually look at line 2. Now that's the end of your paragraph where you refer to the pushing, right?
Yes.
Okay. And then right after that, starting on line 3, you say, and then all of his friends kind of surrounded them, sort of running over. And you're referring to this group that had been walking towards Franklin, right?
Yes.
And so after somebody yelled at that group, one of those guys didn't like what he heard and he came running back and shoved somebody, right?
Yes.
And as you told the officer that day, then all of his friends came running back over and surrounded them, right?
Yeah, that's what I said.
Okay. And you would agree that what you told the officer that day would have been much fresher in your mind than a year and a half later as you sit here today, right?
Yes.
No further question.
Redirect.
Just a couple more questions, Valerie, thanks. Just to be clear, there were six or eight guys total, so both groups combined added up to 6 or 8 guys, is that right?
Yes.
And when the comment was made and the person came running back from the other group, it was an interaction between one person and one person, is that correct?
Yes.
And there was one push, is that correct?
Yes.
And there was no other physical altercation?
Not that I saw.
Okay. Anything else? That's all, Judge, thank you.
All right, I'll turn to members of our jury and see if they have any questions for Ms. Pabon. Looks like we do, so I'll see counsel at the sidebar.
Welcome back to the Law News Network, everybody. I'm Aaron Keller, and we're listening to testimony from people who witnessed the shooting on the Northern Arizona University campus, which led to this trial against Stephen Edward Jones. He faces 2 basic counts overall, a first-degree murder, and he also faces a total of 6 counts of aggravated assault in this case. We are going to go back and listen to some of the earlier testimony from today. Victim Nick Peering, who was one of those shot, testified earlier today about his perspective in these events. So let's listen to some of his testimony now.
Okay. And what about Colin's voice caught your attention?
Well, he was the only voice I recognized, and since I said I lived with him for the past 3 years at the time, I heard his voice and I recognized that he was in a verbal argument with other individuals.
Okay. Now, were you part of any type of confrontation occurring in Franklin Avenue in the street?
No, I was not.
Do you recall anybody knocking on a door and you exiting that unit?
No, I do not.
So you were outside of the courtyard area in the parking lot when you heard Colin's voice?
No, in between the 2 buildings in the stone pathway, if you will. Not the parking lot, but adjacent to it.
All right. And did you investigate what was going on?
I did.
So where'd you go?
So at that point, like I said, I went into the parking lot of Courtyard, across the grass towards Franklin Avenue, across the street into the driveway that separates the Mountain View parking lot and the dorm.
And what did you see as you approached that direction?
At that point, I saw Colin talking to 3 individuals, yelling back and forth, 3 individuals and him, and they had proceeded to just yell at each other verbally and a lot of chest puffing, I guess, if you will.
Did you see anybody punching anybody?
No, I did not.
Anybody kicking anyone?
No.
Anything physical at all?
Nothing physical at all.
Did you see anyone with weapons at that point?
Not at that point.
Later on, did you see someone with a weapon?
I never did see the gun. I only saw the flashlight.
Okay. So did you approach that interaction?
I did.
Okay, folks, we have to cut out of that clip from the earlier testimony from victim Nick Peering because the jury has asked 2 questions of this witness who's on the stand. So let's
Are
go
in the
back to
parking lot 7A. Is this a well-lit parking area and sidewalk?
I couldn't tell you how many lights there were. I've never took the time and counted. The lights aren't very bright, but it was bright enough to where I could see what was going on.
Follow up.
Thank you, Judge. All right, just talking about lighting. You've walked down that sidewalk at night before, is that correct?
Yes.
And you can see?
Yes.
So there is ambient lighting, street lights or lights on the building?
Yeah.
Judge, again, I bring up the Leica scan?
Sure.
All right, that's Exhibit 316 for the record. Looking at that view right there, can you indicate to the jury any lighting that you're aware of?
Pretty sure that's a light and that's a light.
One of you are excused. All right, folks, let's take our last mid-afternoon recess, 10 minutes. Please remember the admonition.
Okay, folks, the court is back on another break, and so here's the moral of the story. If you're going to serve on a jury, move to this particular county in Arizona because they receive more breaks than any jury I have ever seen in my career covering trials. Bottom line, we're going to wait this out and we're going to hope to hear more testimony this afternoon. But in the meantime, I want to go back to some of the testimony earlier today that we've tried to bring you a couple of times from witness Nick Peering. He was one of those who was shot in this confrontation. We've tried to play one of his clips a couple of times, and I won't force you to hear the beginning of it for the third time. So we're going to play some of his later testimony now. Let's listen in.
Nick, before the interruption, I think we were talking about Mikey and Nick Plecky being there with you during that time. You said this time between shots seemed like forever, and you gave an estimate. What did you hear before those shots, if anything?
I was yelling, call an ambulance. So I mainly heard myself yell, call an ambulance, call the police, call 911. Mikey laid on top of me at that point and said to be quiet, that he was still shooting. And I think I yelled at her to get off of me because it hurt. And that's what I recall.
Okay. And how many shots did you hear this second time?
Perhaps another 4, 5 shots.
Did you see where the shots were going, or did you see anybody falling at that point?
I did not, but I think they were going in the direction they were going originally.
Okay. That is toward Mountain View dorm area?
That would be east, yes.
West to east, okay.
Yeah.
From the parking lot?
Correct.
And after you heard these shots, what do you recall happening?
After the shots, I remember the police and the paramedics showed up maybe 2 minutes after. There was just a bunch of chaotic yelling. I was yelling. Mikey had still putting pressure on my wounds, and then I think it was either the police or the fireman got there first and put like a bandage or something on my wounds to try to stop the bleeding.
Okay. Do you recall seeing Colin at all after that?
I do. When I was put in the stretcher, I recall seeing him. I was yelling because no one had helped him. He was still laying in the rocks. And I remember as they put me in the stretcher, they turned me so I was going head first into the ambulance, which was away from Colin, so I could see him at that point in the rocks still.
So let me just back up a little bit, Nick, and ask you directly. At any point were you part of any kind of physical altercation?
No, I was not.
At any point were you running or attacking the defendant?
No, I was not.
Were you attacking anybody?
No.
When you were taken from that scene by the medics on scene, do you recall that transport to the hospital?
Yes.
Recall kind of what you were feeling at the time?
What I was feeling?
Yes.
Yes.
Did you know that you were shot in those 2 locations at that point?
At that point, yes. I told the paramedics that my wallet was in my back left pocket. I didn't know my blood type. My insurance card was in there. Where I was shot, they cut my pants off to get to my hip wound. And I remember yelling at them to go help Colin. And then I asked if he was deceased, and they confirmed that.
Okay. When you got to the hospital, what do you recall from that experience?
I recall laying in a hospital bed next to Nicholas Prado, and I think Zintek was on the far side of him. And there were curtains in between us, but I could hear his voice.
Okay, and was this type of kind of a trauma bay that you were in?
I believe so, yeah. I've never been in one before.
Okay, these weren't individual rooms then?
No, it was one long room just separated with curtains.
All right, and were you being treated by medical staff at that point?
I was.
And what were they doing to try to help you?
They had put bandages on my wounds, and I believe they had put me on an IV and some sort of pain medication, perhaps.
Okay. How long were you in the hospital?
2 days. I believe I got out on Sunday, the following Sunday, so Friday and Saturday.
What was the result of those shots to your body?
Well, muscle damage. I had a cracked pelvic bone on my left side, and then muscle spasms.
Okay.
Still.
Are you experiencing anything today from that experience?
Occasional muscle spasms.
That was testimony from Nick Peering, who was shot as part of this altercation, which ultimately led to a grand jury indictment on murder charges for the man who pulled the trigger, Stephen Jones. His attorney argued earlier in this case yesterday that there's no conflict about who pulled the trigger, it's just a question of why. Let's listen to some of the defense attorney's opening statement.
Stephen is aware that his friends Shay and Jacob are still somewhere in this group with these people who are less than friendly. And he walks over and approaches this group. Yes, it was 90 feet. But what the prosecutor didn't tell you is that this cold-hearted assassin who was on a rampage this night did not approach his friends who were being surrounded and fire shots. He did not approach his friends who were being surrounded and even have the gun leveled off at them. He held the gun pointed at the ground in what's sometimes referred to as a low-ready position. He approaches his friends, and there's Mr. Brew. Mr. Jones is holding the gun, not pointed at anybody, he's pointed at the ground. Announces he has the gun. He's just trying to protect himself. He's not shooting anybody at this point. He says, get out of here, leave, stop, get the fuck out of here, words to that effect. And in response to that, what does Mr. Brew do? He turns and he lunges at Mr. Jones. And it was in that very moment that Mr. Jones leveled up his pistol and fired those shots at Mr. Brew. And we know that Mr. Brew was no more than 2 feet away from Mr. Jones at the time that happened, and that's based on the prosecution's own medical examiner, because one of the 2 wounds that struck Mr. Brew had what's called stippling around it, indicating that it was anywhere from inches to a couple feet from the end of the muzzle of the gun. At that very moment, as Mr. Brew lunges towards Mr. Jones, Mr. Brew's roommate, Nick Peering, is running from up behind Mr. Brew. Mr. Peering later told the police that he was running towards Mr. Brew primarily because he wanted to calm him down, not calm Mr. Jones down, but calm his roommate, Mr. Brew, down. And in essentially that same moment, when Mr. Brew lunges at Stephen and Stephen lifts up his pistol, Mr. Peering comes up behind Mr. Brew in the same direction towards Stephen and jumps up from this elevated position. Mr. Brew and Mr. Peering are up here. Mr. Jones is down here. From this elevated position, Mr. Peering jumps up over this bush that's separating him and Mr. Brew. And then in that moment, after firing those shots at Mr. Brew, Stephen sees that there's the second subject who's also jumping at him from an elevated position and fires shots at him as well. Now, there's other people around. There's no question that there's people from the party across the street who are still there and who are associated with this group who started this confrontation. And what does this homicidal assassin on a rampage do? He tucks his gun.
So that's attorney Joshua Davidson, who's one of the defense counsel in this case. He's joined by co-counsel, and there are also 2 prosecutors handling this case. Let's listen to a little bit more of the defense's opening statement, because I thought this case was really interesting from the perspective that both the prosecution and the defense had very clean, easy to follow opening statements, which both painted drastically different versions of the same scene. So let's listen to more of the defense's opening statement.
He kneels down and he attempts to offer aid to Mr. Brew. As he's down there trying to render assistance to Mr. Brew, a group of people essentially pummel him and doggy pile him. And they're punching him and they're kicking him and they're trying to grab his gun, and again they're threatening him, we're going to kill you, we're going to kill you. And it was in that moment when Stephen's underneath this doggy pile, again being threatened, this time people trying to wrestle his gun away from him. He's screaming, help, 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 repeatedly. In fear of his life, he fires multiple shots up in the air with the intent only of dispersing this group of people who were trying to take his gun and cause him harm. In the course of doing that, the evidence will show that Mr. Prado and Mr. Zintek were shot at that point as well. Now, after a resident of the nearby dormitory who had heard a commotion, didn't see anything, but he came down at this point, a gentleman by the name of Chase Jones, he walks up and he approaches Mr. Jones and basically tells him, hey, it's safe, you're okay. What does our rogue assassin do? He puts the gun down. Puts the gun down, I would note, having not fired all of those 17 rounds that Mr. Barker made a point to tell you that his pistol was capable of holding at one time. He put it down and he waited and he cooperated and he voluntarily turned himself into the police in a very peaceful and cooperative.
Okay, welcome back, everybody. That was more of the defense's opening statement in the murder trial of Stephen Jones. He's accused of shooting one person and killing that person, and then shooting 3 other people, not killing them, on the fringe border of a campus in northern Arizona. So let's go back now, if we can, and listen to a little bit more of the opening statements. I think we're going to go to clip 10, Cedric, because we thought court was going to come back into session. We started hearing some audio rumbling, but they're not. So we'll listen to a little bit more of that opening statement, and as soon as the testimony resumes, we'll take you live back to the courthouse.
There are things you'll find that are going to be undeniable and are not going to be the subject of dispute. In addition to Mr. Jones having no alcohol and no drugs in his system, you're going to hear that Mr. Brew had a blood alcohol concentration of 0.285%, approximately 3.5 times over the legal limit. The medical examiner also found THC, tablet of marijuana, and Xanax in his system. You're going to hear from a defense expert named Dr. French, who's a professor of pharmacology down at U of A, and he's going to talk to you about the potential interplay between alcohol and sedatives, such as the Xanax that Mr. Brew had apparently taken prior to that incident. Mr. Peering also had quite a bit to drink that evening. His BAC was 0.208, just over 2.5 times the legal limit. Mr. Prado, Mr. Zintek were also over the legal limit. Mr. Zintek, I believe, was a 0.092. Mr. Zintek was a 0.181, over twice the legal limit, and Mr. Prado was a 0.092. 4 individuals who had quite a bit to drink. There's not going to be a whole lot of dispute that this was a very dark area where this took place. There's not going to be any dispute that Stephen had his glasses knocked off his face when he was sucker punched, because his glasses were recovered by Franklin Street, north of the parking lot. There's not going to be any dispute that Mr. Brew was indeed lunging at Mr. Jones at that critical moment when Stephen had to make that split-second decision on what he was going to do to protect himself. And the reason that we don't have to wonder about that is from the prosecution's own expert witness, the medical examiner. The examination that was done by the medical examiner showed that Mr. Brew had an entrance wound by the 4th rib, which is essentially by the nipple area of his chest, and that bullet came to rest in the 11th thoracic vertebra, which is essentially his lower back. So you have a situation where the bullet goes in by his chest, it gets lodged in his back. It's pretty hard to explain that away without having Mr. Brew leaning at a very aggressive, particularly given the fact that he's in an elevated position towards towards Stephen at that very moment when shots are fired. There's not going to be any dispute that the presence of stippling on by Mr. Brew's wounds means that he was no more than 2 feet away from the end of Mr. Jones' gun, if not closer. There's not going to be any dispute that Stephen suffered injuries as a result of this incident, whether it was from being sucker punched up by the courtyard or being pummeled down by the parking lot. The officers who had contact with him right after he He was taken into custody. Notice that he had injuries to his neck, to his head, to his back, to his chest, to his arms, and to his knees. The officer also noted that Stephen had a swollen wrist. Again, all corroborating that Stephen was attacked and he was pummeled, and that it was under those circumstances that he, in that split second, made the decision to do what he had to do to protect himself. You're going to receive additional instructions from the jury, from the court, before you go back and you deliberate, and there's going to be several days of testimony between now and then. And one of the instructions, or several of the instructions that we anticipate you're going to receive, is an instruction called justification, self-defense, and other justifications that provide circumstances under which a person can use lethal physical force. And the burden of proof at no point in this trial will shift from that table to this table. It will be the burden of proof on the prosecution to not only establish that Stephen committed a crime, but also to exclude that his crime, alleged crime, was not justified as a matter of self-defense or through some other recognized legal justification. So you won't get the exact instructions on what constitutes self-defense and justification until later on, but I'd ask you to keep that in the back of your mind, at least as it relates to where the burden of proof for that is as this trial progresses. There's things that will be unclear. There's things that we'll have to see how the evidence plays out as to those finer points. There's things that we know for certain. I talked about them: the wound path, the toxicology results. There's things that we're equally confident that you'll know for sure when this trial is over, and that is that this was not a case of murder. It certainly was not a case of premeditation. This was a case of a young man doing what he had to do to defend himself. And for that reason, we will ask you to return verdicts of not guilty on all 7 counts. Thank you.
We're going to continue to listen in to some of the earlier testimony here because it looks like although court should be starting back up soon and we're seeing a little bit of movement in the courtroom, we're not sure quite how long it's going to take everyone to get situated. So I want to go and play a brief clip from earlier today. This is Jalen Kunkel, who was one of the eyewitnesses who was in her dorm room above the shooting scene when the shots rang out.
Not normal.
This was like a Thursday night, though, right?
Yeah.
So that's a weekend?
Yeah, well, Thursday night until Sunday, I guess, or Saturday.
Why is that?
That's mostly when people go out to party and stuff.
Okay. So on this night, it woke you up, and do you remember anything specific that was being said, or was it just noise?
I don't remember anything being said.
Okay. Did you have to get out of bed in order to look out the window, or?
No, my window was directly my bed was directly facing the window, so I just had to roll over in bed and look out the window.
Okay. So when you looked out the window, what did you see?
Okay, folks, this is usually the case as soon as I play another clip, even if I think court's going to start back up again. Of course, it starts back up. So this is a witness named Katerina Tacton. She's just about to take the stand.
You solemnly swear or affirm under the penalty of perjury that the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God, or so you do affirm. Thank you.
You have a basic plan right there.
Okay. Thank you. Okay.
Go ahead, Mr. Shea.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Could you please state and spell your name for the record?
Yes, Katerina Tatkin, Katarina Tatkin.
So it sounds like you're a little soft-spoken, so we'll ask you to just either speak directly into the microphone or try to raise your voice a little, okay?
Okay.
Everybody here needs to hear what you're saying. Can you tell us a little bit about yourself, Katerina?
I'm a senior at NAU.
What are you studying?
I'm studying strategic communication.
All right, you grow up here in Arizona?
Yes, I'm from Scottsdale.
So you're a senior now. Does that make you a junior in the fall of 2015?
Right.
Yes?
Yes.
Take your time.
Yes.
Okay. And where were you living at the time?
I was living in Mountain View Hall.
All right. Do you remember what room or what floor you were living on?
Yes, I was living on the 3rd floor. I don't remember the room number.
Okay. Katerina, I'm going to ask you about the events of the early morning hours of October 9th of 2015. Do you recall that time frame?
Yes.
Okay. Somewhere around 1 o'clock in the morning, do you recall what you were doing? Were you at home?
I don't remember the exact time, but I remember before this incident I had just returned home.
Okay, returned from being out with your friends, or?
Yeah.
Had you been drinking at all?
No.
All right. So shortly before that time frame, you returned back to Mountain View. Was anybody in the room that you returned to, or were you alone?
All 3 of my roommates were home.
Okay. Do you remember if the window to your room was open or shut at the time?
It might have been cracked. I think our blinds were open.
All right. So was there something that happened that captured your attention in that time frame?
Yes. I had just returned home and was getting ready for bed and heard some arguing outside my window, so I looked out my window.
Okay. Was there anything unusual about hearing that?
Yes. I mean, it was pretty common living in Mountain View to hear people outside at late hours of the night, rowdy people, but I think it was unusual in the way that it was yelling.
Okay. And when you looked out the window, what did you see?
I saw 2 groups of boys walking along the sidewalk driveway area in front of my window.
All right. Are you able to, all right. So 2 groups, how many people were out there, do you know?
I want to say total, maybe I saw around 5 or more.
Okay.
I couldn't give you a definite number.
More than 10, less than 10?
Less than 10, I believe.
All right. And what indicated to you that it was 2 different groups?
I think at the point that I looked out my window, both groups were walking in the same direction, but there was clearly distance between the 2. So that's why I perceived it as 2 groups.
All right. Can you tell the jury how many were in each group, if you recall?
Possibly 3 to 4 people.
In each group?
I believe so.
They look like they were similar sizes to you?
Yes.
Can you describe, or do you recall the lighting conditions?
I believe there's street lamps along that driveway, so while it was dark and I couldn't really see faces, I was still able to see the bodies.
Okay. All right. You said they were moving in the same direction. Which direction was that?
Away from Franklin Street.
Okay. So from your point of view, looking out Mountain View Hall, they would have been moving from your right to your left?
Right, yes.
Was it like running or walking, or how would you describe the pace?
I would say walking briskly.
Okay. Did it look like a chase or anything like that?
No, it did not appear to be a chase. However, the groups were yelling at each other.
Okay. Both groups exchanging words?
I believe so.
Now, what happened next? Was there a change in that dynamic?
As I recall, members from each group sort of approached each other in a confrontational way. So the groups kind of came together at a point. And then verbally arguing, but I couldn't make out exactly what was being said. And then all of a sudden, there was a bright light.
So I'm going to stop you, and I'm going to still talk about the 2 groups. So was it all the members of both groups came towards each other? What do you recall?
If I recall, it was one member from the group in front, kind of approaching the second group behind them, and then it all happened very quickly where the 2 groups convened.
Okay. So the 2 groups got together, and you said verbally. Was there any kind of physical confrontation that you observed?
No.
Okay. And were you looking? Would you have seen it had there been one?
That's hard to say because since the boys were so close to each other, I didn't see a physical contact personally.
Okay. But they were still arguing with each other?
Yes.
How long between when that happened before you saw the flashlight?
It happened pretty quickly, I would say in the course of seconds.
Okay. In addition to or can you describe the flashlight, where you saw it, where, was it moving, stationary?
Yeah, so I didn't know that it was a flashlight right away. It sort of came out of nowhere, and in my mind I was like, what is that? And it kind of flashed up at the building almost for a second, and was kind of moving around a bit for a second. Yeah.
Okay. And did you see anything else?
Not at that point.
Okay. What happened next?
Then right after the flashlight, right after I saw the flashlight, that's when I heard a gunshot.
All right. Did you hear any, prior to the gunshot, did you hear any loud yell? Did you see or hear that person saying anything?
As I recall, I heard sort of a sense of, I don't know who said what. I just heard dialogue, but something along the lines of, what are you doing? Oh my gosh, what are you doing? What is that?
Okay. And then after that, you heard the shots?
Right.
Do you recall how many shots?
I don't recall an exact number.
Do you have an estimate?
Maybe 2. I couldn't say for sure from my memory.
Okay. Were you looking at the person with the flashlight when you heard the shots?
Yes.
Did you see a gun? Did you see shots?
I was sort of focused on the bright light, and didn't fully process that it was a gun until after the gunshots. So I couldn't make out like the actual, like I couldn't tell you what the gun looked like.
Okay.
Yeah.
How would you describe the flashlight? Do you have anything besides it just being a flashlight?
Just a bright light. That's all I saw.
Okay.
At the time, I didn't know what I was looking at.
Did it seem brighter than a regular flashlight?
I think so, yeah.
Did you realize, I think you said that you didn't process until after, when you first heard the shots, what did you think was happening?
I think I thought maybe it was a BB gun or something, and it wasn't until I saw someone on the ground that it hit me that it was real.
All right, so let's talk about that then. You heard the shots, you were focused on the flashlight. What was the next thing you saw?
I saw someone on the
Can you describe to the jury where you saw them on the ground?
Yes. One was in the rocks, kind of between that driveway and the parking lot, sort of to my right, and then the other one was also in the rocks, but to the left.
Okay. Did you notice anything about either one of them? Or did you look long enough to see, besides just that they were on the ground?
I didn't recognize them. I I was on the phone with 911.
Okay, so you called 911 during that period of time?
Right.
When, do you know when in that sequence of events you called 911?
After the first couple shots, or the first round of shots, I had my phone in my hand already, so I called 911 right then and was just yelling at them to send help because there were 2 people on the ground.
Having heard that and having seen that, did you respond in any way yourself besides calling 911? Did you continuously look out the window, or?
Right when the shots were fired, I was right at my window, but I ducked as an instant reaction for a split second, and then I looked back out, and then that's when I called 911.
Okay. While you were on 911, could you continue to hear what was going on outside, or were you paying attention?
Yes, I was focused on the people who had been shot. Because I was just telling the operator to come and that they needed help. And they were asking me what they were wearing, but I couldn't see what they were wearing.
Okay. What was the next thing that you observed going on outside?
And then there was more shots after that short pause. And yeah, that's...
All right, so let's talk about, there were 2 things there. You saw a group of people huddled. Were they near or away from the people who were on the ground?
They were near.
Were they moving? Were they getting closer, further away?
I think initially they backed off in a reaction of shock. And then it looked like they had convened again.
Together with each other or near the people on the ground?
Together with each other.
Okay. And roughly where was that along the sidewalk, if you recall?
Just in the middle of the sidewalk.
All right, and we'll bring up some...
Middle of the sidewalk.
All right, and we'll bring up some photo type thing in a minute, and we'll talk about that.
Okay.
You said that there was a second cluster of shots?
Yes.
How many, do you recall?
I don't recall.
More than one?
I can't say for sure.
But you definitely heard shots?
Right.
Did you see anybody helping anybody on the ground?
Yes, I saw a girl holding down one of their legs or one of their wounds.
Okay, and which was one of, when you say one of their, you mean one of the 2 people on the ground?
Right.
And which one of those, do you recall?
I think I have it in a drawing that I made. I don't remember if it was the one on the right or the left.
All right, so you're referring to a map you referred to during your police interview?
Right.
Okay, but you don't recall now whether it was the person on the right or the left?
I couldn't say for sure. I think it was the one on the right.
Okay, to your right.
To my right.
You indicated that you called 911. Were you inclined to call 911 before the shooting?
No.
Okay. And besides the gun, did you see anybody with any weapons?
No.
Did you see any kind of physical violence other than the shooting?
No, just purely verbal from what I saw.
After the shooting, did you hear any specific things that anybody said?
Yes, I heard, well, after the initial shots, I heard just general panic, like, what did you do? Call 911. Yeah, that's about it.
Did you hear anything that you thought was said by somebody who was shot?
Yeah, I heard one of the victims on the ground screaming, saying that he was dying.
Are you able to determine who said that, or?
It was Colin.
Did you know Colin at the time?
No.
So you're referring to learning who that person was later?
Yes.
When you looked out the window, did you recognize anybody?
No.
And when you were originally interviewed about this, did you know who any of these people were?
No.
Prior to the gun coming out, did you think that this was a life and death situation you were looking at?
No. Your Honor, referring again to Exhibit 316, if I may. Katerina, there's a couple of different views we can give you if you can't answer my questions, okay? So just indicate if you needed to see it from a different direction, okay? Okay.
Do you know what building we're looking at?
Yes.
What building is that?
That's Mountain View Hall.
Are you able to determine from this view which one of those windows was your window?
Yes. Did you want me to
Yes,
point
if
it?
there's a laser pointer up there, please use
Yeah.
that.
My window was this one right here.
Okay. And of course, this is daytime, but it was at night, right?
Right.
But you've looked upon that sidewalk and you've walked on that sidewalk at night, is that correct?
Yes.
And is it fairly well lit?
I would say so.
And in any event, you could see from your perspective, is that correct?
Right.
Now, you can see in this photograph that it appears there might be trees there. Were those trees obstructing your view at all?
No, they weren't. I could sort of see over them, I would say.
Okay.
They were not obstructing.
Now, I understand that there's that black curtain thing there that was not there when you were observing what you've described to the jury. Is that correct?
Yes.
All right. Again, if you need me to use a different perspective, let me know. Are you able to, from this perspective, describe where the two groups were when you first looked out the window?
Yeah. When I looked out, they were walking from over here, this way. And then they convened about right here, I would say.
All right. How long a period of time was that you watched them walking and convene? Was that seconds? Was that a longer?
I would say seconds, yeah.
All right. And then where was the flashlight when you first saw it?
Right in this area, I believe.
Okay. And did it remain there?
Yes.
It didn't move that you saw?
No.
So you can see that there's the bush there and the rocky division between the sidewalk and the parking lot, right?
Mm-hmm.
Is that a yes?
Yes.
Thank you.
Right before the shooting, did you see any movement? Anybody moving in one direction or another?
As I recall,
Groups exchanging words?
it looked confrontational, as in people were moving towards each other.
The two groups on the sidewalk?
Yes.
Relative to the flashlight, did you see anybody move towards the flashlight move, anything, only if you recall?
I recall people moving slightly away, like in a reaction relative to the flashlight.
And then the shots?
Right.
Did you estimate I know that you were on 911, so if you can't, that's okay, but can you estimate the amount of time between the first cluster of shots and the second cluster?
I couldn't tell you a number of seconds. I just recall that there was a pause.
All right. Did you see any action, any movement in between the two sets of shots?
I don't recall what I saw.
Was the flashlight, when you saw the flashlight at any point, did you see it illuminating a person?
Not particularly from my perspective.
All right. And can you, was the flashlight or the gun in the same place after the, right before the second shots, or had it moved?
I don't recall the exact placement.
So I know you called 911, Katerina. Did you see all of the police response?
Yes, I did.
You can turn that off. All right, and that was, how long after the shooting would you say that the police arrived?
Well, after I got off the phone with 911, I went to check on the other girls in my hall. So by the time I got back to my room, the police were there.
Okay. Nothing further at this time, Judge?
House Exec.
Hi.
We'll look at the diagram a little bit more later. Do you recall, was your window open or closed?
The blinds were open, and I'm not sure if our window was actually open.
Do you know what your usual habit was at 1 o'clock in the morning with your window?
Yeah, I think it was definitely at least cracked.
Okay. And you said that you'd seen these two groups walking along the sidewalk, less than 10, but more than 5 or 5 or more?
Yeah.
Okay. You're not sure exactly how many?
No.
Now, you said you could see, because there was some lighting in the parking lot. Could you make out faces?
No.
Now, when you first saw the light, was your focus mostly, once you saw the light, was your focus mostly on that light?
Yes.
You indicated that you thought you saw some people back away from the light,
Yeah.
but you can't recall the movement of every single person that was on that sidewalk, right?
Right.
Now, you didn't, all you recall is you saw some people step back, right?
Yes.
But you can't be certain if anyone else moved forward, right?
I did not see that.
You didn't see it, you also can't rule it out, right?
I mean, I saw people step back, so
Right.
that's what I saw.
But you don't know how many people exactly were out there, right?
No.
And your focus was on the light once you saw it, right?
Right.
So you can't be certain that there weren't other people that you didn't see that moved forward, right?
Yeah.
You didn't see it, but you can't rule it out, right?
That's just from my recollection. Yeah.
In preparing for today, did you have an opportunity to look back at transcripts from what you told the officers the night of?
Yes.
Okay. Will that help refresh your recollection of things?
Yeah.
I'm going to go ahead and give you your transcript, so we might need to refer to it going forward, okay?
Okay.
Yes. Katerina, take a look at that and just confirm that's a transcript from your interview with the officer on October 9th, right?
Yes.
And that's what you reviewed in preparing for today?
Yes.
Okay. So earlier you told us that you saw these two groups. It was definitely confrontational. There was yelling back and forth, right?
Yeah.
And they were moving briskly along the sidewalk, right?
Right.
And that was coming from Franklin?
Yes.
Okay. Did you see, did it appear to you that it was about to be a fight?
I thought it was possible.
Did you see anyone charge anyone?
I saw, like I referenced before, at least one member sort of approach the other group.
Do you recall, I'll direct you to line 19 on the first page there. This is what you told the officer. There was a, well,
What's your objection?
my question was whether she saw someone charge, and she doesn't seem.
That question.
Right, so now I'm confronting her with her prior inconsistent statement.
The objection's overruled. Go ahead. Mr.
Okay,
Keller.
so back to line 19 here. This is what you told the officer, right? There was about to be a fight, and I watched one of them like charge another like that. Is that accurate? That's what you told the officer?
Mm-hmm.
Okay.
Yes.
Yes.
So you did see somebody charge somebody, right?
I think that's to what I'm referring, the person sort of confronting that other group. Yeah.
Right. Now, I think you already clarified this before. That you told the officer that it was a brawl. Did you clarify what you meant by that?
Where did I say
I'll
that?
direct you to page 9. I can't recall if you brought this up just now during direct or not.
Objection, same, it's hearsay, Judge.
What line are you referring to?
It's page 9, line 2.
And what's your question?
The question is, if she told the officer that she saw a brawl, where the brawl happened.
And your objection is hearsay?
That's correct.
Overruled.
So you can go ahead and answer. Did you tell the officer that you referred to what you saw out there as a brawl?
I'm not sure where I said that.
Okay, so look at page 9 and line 2. You said, but yeah, that's where like the brawl happened.
Yeah, I think, are you asking what I meant by that?
Yeah, go ahead and because you do explain it here, so go ahead and tell
Yeah.
us what you meant.
I think by brawl, I meant the confrontation of the two groups.
So to you, when you say confrontation and you use the word brawl, are you not referring to physical confrontation?
No, I did not see any physical contact.
But you did use the word brawl.
Yeah.
Okay. Now, you told us earlier you weren't sure how many guys were in each group, right?
Right.
Okay. But when you spoke to the officer that day on October 9th, didn't you tell him that there were 5 guys in the one group? I'll direct you to page 10, line 3.
Yeah, I see it.
Okay. So you don't know the total of everyone that was out there, but one group had 5 guys.
I remember seeing about 5 guys in total in that group. I don't know if there was anyone else around.
Okay, so let's make sure we get this clear. When you say that group, you were referring earlier to 2 groups.
Right.
So when you refer to the 5 guys, are you referring to 5 guys in one group?
I'm referring to 5 guys in total.
Okay. Now, you heard, you've told us about some of the statements that you heard individuals say out there. You couldn't make out everything that was said, right?
Right.
And you have told us about some of the statements that were made. I want to direct your line, page 10. Did you hear anyone use a derogatory slur towards anyone else?
I did hear it thrown out.
Okay. What did you hear?
The derogatory slur.
Yeah, I know. It's indelicate, but go ahead and say it.
I heard the words fucking faggot.
And at any point, did you see anyone crowding around someone else?
As I perceived it, I didn't see crowding around a single person. I just saw a confrontation as a group.
Okay. So I'm going to direct you, again, stay on page 10, down to line 18, your answer there. You see where you're referring to them crowding around?
Yeah.
So, having looked at that, does that refresh your recollection? Do you recall that they crowded around somebody?
I think I said crowded around them.
Right.
So,
So you did see some group of guys crowd around other guys?
yeah, but I wouldn't say like, I don't think I meant around like in a circle. I just meant crowded together. That's what I recall.
So it didn't make a perfect circle, but you did say crowded around them.
Yeah.
Right. Around means around, right?
Right.
So it wasn't one line and one line, right?
It was, from my point of view, it was like a group huddled together.
We can pull up for Okay, so I just want to clarify, the group that you saw walking, was two separate groups, right, at first?
Yes.
And then they sort of convened where, on the sidewalk where the bush and sort of in the middle of that screen there, right?
Yeah.
And when you were referring to walking briskly, you were referring to them walking from Franklin, which, in the way I'm facing the screen, is the left end of that screen, right?
Yes.
And they walked briskly. Now, when you first saw them, they were two separate groups?
Yes. I wasn't sure if they were together or not.
Okay. But you could make out that they weren't being friendly with each other, right?
Right.
And by the time we get to the end of the bush there in the middle of this screen, they're not two separate groups anymore. They now have merged together.
As I recall, they walked past and then were kind of more towards the right of the screen.
Okay, go ahead and use your pointer and
Okay.
point where you saw them converge.
So both groups of people were walking this way and kind of got to over here, but then convened back over around here.
When you heard that derogatory slur, where were the groups then?
I don't remember the exact point that I heard that.
Wait a moment, Your Honor.
All right, thank you. Mr. Shea?
Thank you, Judge. Just a couple of questions. Katerina, do you still have that transcript in front of you?
Yes.
And that was Exhibit 88?
Yes.
Okay. I'm going to refer you back to that same page, that page 10, line, the question begins on line 1. So you were asked how many were in there, and then the trailing group, is that correct?
Yes.
And you indicated that it was like 5 guys or so, right?
Right.
And the next question is total? And you said, yeah.
Yes.
So not inconsistent with what you said here today.
Right.
You told the jury during your direct examination that you saw one from each group, right? Going towards each other?
Right.
All right, so again, not inconsistent with when counsel questioned you about that. You had described that, is that correct?
Yeah.
And that's when counsel asked you about one person charging another. That was what you were describing there?
Yes.
So did you see anybody charge the person who had the flashlight?
At that point, the flashlight, I hadn't seen it yet, so I'm unsure where that person was at that point.
Okay. But it would be fair to say that you did not see a person charging the person with the flashlight.
Right.
And the derogatory slur that was discussed, do you know which group that came from?
No, I sort of heard, I remember hearing yelling and name calling, I think, from lots of voices, so I couldn't tell you who said that.
Nothing further, Your Honor, thank you.
All right, I'll turn to members of our jury and see if they have any questions for Ms. Tatkin. Does not appear that we do. Can this witness be excused?
Yes, Judge, thank you.
Thank you.
Ms. Tatkin, thank you so much for your testimony. You are excused.
Thank you.
All right, folks, let's go ahead and recess for the day. Thank you all for your hard work. Please remember the admonition. We'll get started tomorrow morning at 8:30 a.m.
Welcome back to the Law News Network, everybody. I'm Aaron Keller. I've been your host today, and we've been listening to testimony from the college students who witnessed the shooting on the Northern Arizona University campus. Stephen Edward Jones is the young man accused of shooting 4 people, killing one of them early in the morning hours of October 9th, 2015. We heard from 3 young women who were in their dorm rooms just above the shooting scene. They testified with various degrees of specificity depending on exactly what they were able to see from their perspective and when they started looking out the window. Some of those of you who are chatting along with us on our live stream feed were talking about how difficult it must have been for these young women to witness and then process what they had seen, and that certainly is something that I agree with. The last witness doing, from my perspective, so well on the stand, trying to articulate exactly what she saw, trying to be accurate about what she saw, trying to be fair about what she saw, and then still also trying to grapple with the gravity of having witnessed a shooting that left someone dead. The most chilling line that I recall her saying was, quote, "I heard one of the victims on the ground screaming, saying that he was dying. It was Colin." And Colin Brew was one of those who, or was the only one rather, who did indeed die in the shooting. So chilling words from these witnesses that we've heard from today. We're going to continue our coverage here on the Law News Network starting tomorrow at 9 a.m. Eastern, and we will be able to bring you the last few words of the Aaron Hernandez double murder trial from Boston. The judge there whittled the jury down today to 12 people, taking the 3 alternates out of the pool and setting them aside. So if there's a problem with deliberations, they can come back in, but he did select the final 12 who will decide the case, and he also has to finish up in the morning giving the jury instructions on the verdict sheets. But most of the jury instructions were read this afternoon, and we heard the closing arguments in that case. So deliberations will start tomorrow in the Hernandez case, and of course we will bring you the verdict as soon as we have it. We're also going to continue to monitor the case you've just been watching from Arizona, from Flagstaff, and we will continue the testimony in that case. They start at 8:30 Pacific time or 11:30 here on the East Coast. So we will have live testimony at 11:30 Eastern, 8:30 Pacific in the case you've just been watching. So we will wrap things up for tonight. I'm Aaron Keller, and for all of us here at the Law News Network, have a good evening.